All right, everyone. Good morning. Welcome to Uncivil Law. The jury is deliberating for about 45 seconds or something. The judge brought them in with her scowly face, looking kind of scowly. She asked the jury the standard questions. Have you and sent them back to deliberate, and then told counsel to be back at 4 o'clock and not be further than 10 minutes away, and that was it. So there is nothing more. Let's see if we can watch some of what's going on here outside the courthouse as they walk outside. Let's take a look at what's happening outside the courthouse. Standing for our pictures, Miss Reed looking nice in this, I guess we'll call it light blue suit. Very light blue. Light blue to off-white. I like it. I'm not sure what color exact, some sort of pastel light blue. It's nice. I like that color. I'm not sure what color it is, but I like it.
Give her some room, guys. Give her some room. Give her some room.
Any thoughts on the question? No comments today, guys. Excuse us.
No comments while the jury's up. Thank y'all so much. Stand on the sidewalk. Stand on the sidewalk.
You look well. Yeah. See you later on, okay?
Good luck. No problem.
Back up. Back up. Come on. Back up.
It was funny. Everybody was saying you guys did something. I didn't know. I looked at it.
Got to get her a Cadillac, huh? Big ballin' Cadillac. Big ballin'. Big ballin'.
I don't like
All right. Spinny Fan is spinning for justice. Spinny Fan is curious what the jury is thinking about. Spinny Fan, like you and me, is wondering what's going on. I'm a little reluctant to tea leaf read jury notes. I find that they are find that sometimes they're misleading. Not intentionally, of course. Well, sometimes, somewhat, but sometimes the jury is holding things close to their vest deliberately. But even where they're not like trying to hold things back, I find that jury notes are not necessarily particularly reliable in what the jury is thinking. I mean, you and I have no choice but to try to tea leaf read what we can, because it's all we have to work with. So I'm not saying don't do it. I'm just saying that like I don't have a lot of confidence in it. So like a lot of people have said, well, it must be like, you know, that they're stuck on part 5 of count 2. That is certainly a logical conclusion. I do not deny, right? That is a logical conclusion, because why would they ask the questions they are unless they were stuck on part 5 of count 2? Like why would they be doing that? And therefore, and they also asked like what happens if we have verdicts but and some and not all, which sort of implies that they're not guilty on 1 and 3 and they're stuck on count 2, right? Like the last jury. I understand all this. I get it, and that is certainly a logical conclusion. I'm slightly reluctant to draw that conclusion just because I think jury notes can be misleading. So I don't know what exactly it means. I don't know what it means, and I think that drawing conclusions is a little, well, I don't know if foolish is exactly the right word for it, but a little suspect maybe. So I don't know what it means until they say we have a verdict and they've checked one of the boxes. I'll know what that means. That's the jury note I'll understand. When it's like we have a verdict and they've checked a box, that note I'll understand. Well, I'll understand what it is. Maybe not why they checked that box, depending on which box they check. I might not understand that, but at least I'll understand what they've done. Maybe not why, but I'll understand what, if not why. At the moment, I'm not sure I even understand what, because again, jury notes is a little sketchy in trying to draw any sort of conclusions there. Yeah. So someone asked about law school for their 8-year-old, or apologies, not 8-year-old, 8th grader. So I'll tell you what I told the person in chat. Well, I'll tell you like kind of regardless of grade, because it's good advice in any event. If you want to go to law school because you want to be a lawyer. That might sound obvious, but at least historically, and I don't know the degree to which it's still true, and I would imagine it's not any less true than it has been. A lot of people use law school as sort of just a delay tactic, or other schools, to be honest, but law school seems to be the most popular for this reason. Like they're not really quite sure what they want to do. And so they use law school as sort of a delay tactic. This is a bad strategy because law school is very expensive. So at the risk of stating something that should be obvious, but apparently is not to some people, don't go to law school unless you want to be a lawyer. You know, that's just good tips. And then if you do want to go to law school, try to figure out exactly what kind of law you want to do. And to do that, try to figure out ways that you can shadow or intern with lawyers in the field that you're interested in, even if you have to do it for free, right? Because, you know, working for free isn't exactly fun, but in this scenario, you're working to gain information. So you are benefiting in this scenario, if not monetarily. You're benefiting by trying to figure out exactly what does it really look like to be whatever kind of lawyer you are. So even if it's like for a day, it will give you some insight, although perhaps not as much as you would like. But if you can work for a lawyer in the field or fields that you're potentially interested in, even for a day and potentially a longer period of time, and shadow them a little, it will give you a better idea of what that really looks like. That would be good. And the other thing is, of course, just to look at the economics of it. Law school graduates are on a binomial distribution. So there's a nice little curve. There's two humps in the bell curve, right? So you got a little like low hump, and then you kind of got a big hump, right? So there are a lot of law students who graduate, you know, sort of on the lower end of that curve. And then there are lower end of the distribution. And then there are ones that graduate on the higher end of distribution. And some fields of law pay more than others. This isn't, of course, to say that you shouldn't do a field of law that doesn't pay as well. It's to say that you should understand exactly what you're doing, right? Be a informed consumer, like, rational. So if you want to do public service, if you want to be like a prosecutor or a defense lawyer for the government, you're not going to get paid particularly well. I mean, you're not going to get paid dog scrap, although you might, depending on what jurisdiction you are, and the amount you're getting paid per hour when you do the per hour calculation can look pretty depressing, right? So if you work for the government as like a prosecutor or a defense lawyer, when you do the pay per hour calculation, you're getting paid close to minimum wage in some situations. So there's that. I'm not saying don't do it. I'm just saying understand what you are doing. That's what I'm saying. Also, incidentally, by the way, if you do public service, there might be loan forgiveness things, but those can be tricky too. But in any event, look at what you're doing, understand the economics of what you're doing, look at how much it gets paid, look at, how easy it is to get promoted, be realistic about it, be realistic about it. Assume that you are not going to be exceptional because, of course, the exception is by definition exception. So assume that you're going to be the average lawyer because that is the safest assumption. You might be better than the average lawyer. If that's true, then great. Then you'll just wind up better than you predicted. So, play it a little conservatively in your predictions. Assume that you're just going to wind up kind of average, and, base your economics on it accordingly. Look at how much law school debt you're going to take on. Look at how much you're going to get paid. Look at what that looks like economically, so forth and so on. In terms of what you should be studying, you should be looking for any sort of clubs and activities that give you public speaking experience. So speech and debate, I recommend very much. Obviously, speech and debate is great for law interested people. So look for mock trial, moot court, speech and debate. It doesn't necessarily have to be law related speech and debate. Any speech and debate is fine because it just gives you practice speaking and like organizing your thoughts and performing before an audience of some kind. I also recommend theater. So if there's a theater club or something, I recommend theater because part of being a lawyer, at least if you're going to be a trial lawyer, and it doesn't hurt in any event, right? Not all lawyers are trial lawyers, incidentally. So if you don't want to be a trial lawyer, this is less important, but probably still a good idea in any event. I still recommend the public speaking thing, even if you're not going to be a trial lawyer, because it will help you organize your thoughts. Theater is also just good, just good because it will help you with theatrical aspects of law, especially if you're a trial lawyer, because there is a bit of theater to it, as we saw from AJ, for example. AJ is a good example of what the theatrical aspects of law can look like. And you don't necessarily have to play it that way. There are a lot of different kinds of actors. If you think about the actors that you like in cinema, they probably are different in how they do things. There's a lot of different ways to be an exceptional actor, right? There's a lot of different ways to perform that are exceptional or great. So, but do theater because it helps you. In terms of what you should study, I recommend philosophy as a minor, not necessarily as a major, but I recommend it as a minor because philosophy, again, teaches you different ways of thinking. It teaches you how to think about various things, teaches you how the great thinkers have thought about things. If you do it right, it teaches you to really think critically about various things. That's really good. In terms of a major, it doesn't really matter as much. Law schools, I don't recommend pre-law. That's basically my one recommendation when it comes to a major. I do not recommend that you major in pre-law. I think that's a very bad idea, ironically enough. I think pre-law is a really bad idea. Do literally anything else for your major. English, degree could be fine. Obviously, if you want to be a patent lawyer, well, maybe not obviously, but if you want to be a patent lawyer, you have to have an engineering degree of some kind. If you want to be a patent lawyer, but that's fairly specific, so you have to have an engineering degree. So, engineering. Otherwise, it doesn't really matter very much what your major is. Law schools don't really look to that. They kind of look to, and they kind of like, to the extent that they care, they kind of like things that are different. So you'll have philosophy degrees. Political science degrees are very popular for law school candidates. Political science, English, things like that. If you have a different major, that might help you a little bit. It probably isn't worth a huge amount, but if you have an engineering degree, that's going to help you a little bit, just because law schools like to have, a different pool set. So all those things are my recommendation. And then when you are getting into law school, studying for the bar, getting yourself like a, that would be good, because your first year of law school is basically your bar classes. So you can get like a PMBR book that's like the multi-state portion of the bar exam, and get yourself a PMBR book and start like looking through it and trying to understand what it is. That will give you a bit of a leg up in law school. That's not a bad idea. So all those things is a good idea. So hopefully that helps provide some guidance for you if you want to be a lawyer. So all that good stuff. All right. So we're going to try to pop on with Defense Diaries. So let's see if they are awake and what they want to do. The Turtle Boy says the 4-person has a t-shirt and a big gold chain. That's okay. No, noted. All right. All right. So I've tweeted at Defense Diaries to let them know I'm available. We had already talked yesterday about me popping on this morning, so hopefully they remember to check their DMs, and we'll see where we go from there. Great. Is the judge not supposed to interpret and explain the law for the jury? Well, they did in the jury instructions. That's what the jury instructions are. And those instructions come by, the long slog of lawyers with lots of cases. So, anything that's outside of the standard instructions is a concern for a judge, because, if anything you tell them that deviates from the standard instruction is a potential ground for an appeal, because it's not that you're necessarily wrong. It's just that, the standard instructions are standard for a reason. They're a model for a reason. So if you give the model instruction, right, your odds of being reversed are basically zero, right? It's possible, but like if you give the model instructions, like how wrong can I possibly be, right? Because it's the model instruction. If you give anything other than a model instruction, then you potentially raise the issues. You potentially raise issues in appeal because, well, depending on what you did, you might have done something novel. Novel doesn't necessarily mean wrong, but it does mean, someone's going to have to figure out whether it was wrong. So, and lawyers by temperament tend to be small c conservative. Although I don't know the degree to which that is true these days, but the legal profession as a profession historically has been very small c conservative. We tend to move slow because of common law and a whole lot of reasons. We tend to be very cautious, and we tend to be worried about doing things too bad, because, well, we know what happens. We know what happens when people can get creative. That people getting creative can go bad real fast. Right. And there's any number of examples throughout history. I don't really have to explain that to you. Right. So the legal profession tends to be somewhat conservative, because it's like, well, we know that it can go really, really wrong. So maybe if we play it really slow, then things won't be total disaster fuel. So that's all those things. Cool. I only have 55 viewers waiting. Oh, wait a second. I'm not streaming. What the hell? I'm not streaming. Oh, fuck. Oh, dear. This whole thing is not, oh, fuck me. What's happening? Oh, fuck me. Oh, fuck me. I thought I changed the links. God damn it. All right, guys. For those of you who are watching the stream and have been yelling at me the whole time, which is probably some of you, this stream was not supposed to be on this feed. This stream was supposed to be on Verdict Watch Day 3 stream, but apparently I fucked it up somehow. I streamed to the wrong place. Somehow I fucked it up. God damn it. Kill me. Just fucking kill me. You know what? There's an easier way to do this. I'm just gonna fuck it. Hold on. There's an easier way to solve this problem than just abandoning the stream. Fuck it. 1 second, please. There we go. Now the title is correct. Fuck me. Fuck me. Shut up. Shut up, everyone. God damn it. Hold on. I need to update the stream titles in the other places. Give me 1 moment, please. Fuck me. Great. All right. Everything is better now. Everything is better. All right. There was no problem with the stream and everything has been fine the whole time. Will I read your super chat? Now that I see it, I will. God damn it. Lone Star Medic for $10 says, hey, Uncivil, just dropping in to ask, what do you think about the recusal of 5 justices in a copyright case? I think it's mildly hilarious. And funny. Yeah. I thought day 2 was odd. Yeah. Apparently I had the wrong stream. Apparently I had the wrong stream key, and so it streamed to a different place, and I got confused. I was wondering, like, hey, when I finally went up and looked, like, why does it say only 55? Why does it say 55 people are waiting for the stream? What the fuck? Adam Trapp says, fuck you. Well, buy me dinner first. You got it. I will buy you dinner. Oh, Lord. You know what, though? That means that the stream is set to normal latency as opposed to ultra low latency. So that kind of sucks. That's unfortunate because it created a stream using the default settings. That means that you guys are like 8 seconds behind me, which kind of sucks for real-time interaction. So now when I say things, I have to wait like 10 seconds for you guys to respond. That kind of sucks, but we'll press on. That also means I have to change the monetization settings so that there won't be ads. And that means I need to do this. Okay, great. Yeah. Yeah, you've been asking questions to a ghost for a little while. That's okay. Lone Star Medic says, thanks, Kurt. Just thought it was funny and that the con law wise was significant for future cases with their ethics statement. Also, thank you for reading. You got it. I'm in the future? Well, no, technically I'm in the past. Our times are not synced. We have a time sync problem. Our clocks are not synced, chat.
Aperture science.
Let's see what you guys have been saying in chat this entire time since I didn't know you existed until 5 seconds ago. Yeah, you've been yelling at me. You've been yelling at me, but you've been yelling in a place I couldn't see. So your yelling was completely ineffective because you yelled at me in a place that I wasn't watching. You were yelling into the void. Lol. Lol. What was that, aperture science?
Aperture science.
Yeah, someone mentioned aperture science in chat, so we pressed the aperture science button. We have many buttons. We have many buttons that are fun for chat.
You ask for miracles, do you? I give you the FBI.
Yeah. Alex Wiltrid for $5 says, just call yourself Shan the text stream clock. It's a feature, not a bug, to be 8 seconds off. Yeah. You sent me the jury instruction language that applies to question 4 via text? Oh, okay. Hold on 1 second, please. Hold on. Okay. Let's see. There is language in the jury instructions. The court can refer to them relating to question 4. This transcript of the jury instructions is read by the channel, Criminally channel. Okay, blue is the new language for this trial. Making decisions as a group. What she added to the group is for blue. Okay, cool. So we're going to try to do this. So give me a second to like figure a way to pull this up on screen and we can read these instructions or the modifications to the instructions. All right, I'll do it this way. No. Guys, I'm a competent streamer, I swear. I'm a competent and good streamer. All right, let's see. Yeah, has a new verdict slipped out? I don't think it was. And we didn't actually, I don't think we ever got the new verdict slip in the last trial either. I don't think they ever actually released the new verdict slip. They released the original verdict slip, but not the new one for some reason in the last trial either, which led to a lot of confusion because people kept saying, oh, they didn't change the verdict slip. And I'm like, they really did? But they never released it. So like, I had to keep correcting people about what the verdict, we had a lot of arguments about what the verdict slip and was and wasn't because of, yeah. It's lack of tech. You're fine, Travis. It's fine. Everything's fine. I will figure it out. Everything is fine. Ah, man, some mornings, at least I got some decent sleep last night. So I don't have like the curmudgeonly problems I did yesterday, or at least not as bad. At least I got some solid sleep. So I'm not like beating myself up from just being tired in addition. So I wouldn't go so far as to say I'm well rested, but at least I'm better rested. And thank God for that. Oh, geez, this is jank. Oh, this is the most jank. Oh, this is pretty jank. All right, that's fine. We'll make it work. This is pretty jank. This is pretty jank. All right. Hold on, please. Talk amongst yourselves for a second. Okay. Court TV feed. Okay, great. So I need to remove that feed for a second, and I need to add in a new thing. Okay. Hold on. And then I need to do this. Yeah, that'll work. And then I need to like make it look kind of like this. All right, this is a little jank and might be a little blurry, but we're gonna press on. If this is a little blurry, we're gonna press on. All right. So apparently this is a transcript of the instructions the judge gave yesterday. This is a transcript of the instructions the judge gave yesterday, and the portion in blue is the new portion that has been added. So we will see what it says and see if it provides any additional insight in exactly what's going on. And thank you, Travis, for sending this over. I do appreciate it, Travis. You're the best. So apparently here are the new exciting instructions, or the revised exciting instructions. So in we'll just read the amended portions, I guess. Reaching a verdict. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then. For each indictment, that's count 1, count 2, and count 3. Those are the indictments. I would have preferred to say for each charge, or each, like how they're labeled on the top, because I think how's it labeled? Count 1, count 2, count 3. So I would have preferred to say for each of count 1, count 2, count 3, depending on exactly how it was labeled on the top of the sheet. Because what is an indictment? What is an indictment? Even the court apparently doesn't have a copy of the indictment. Because remember that from yesterday? They're like, does anyone have a copy of the indictment? And apparently the answer to that question was no, which is super exciting. Like, apparently the question, does anyone happen to have a copy of the indictment? Does anyone have a copy of the indictment? Apparently the answer to that question is no, which is hilarious. So if the court doesn't even have a copy of the indictment, how is the jury supposed to know what an indictment is? Right? It's not labeled indictment 1, 2, and 3 on the top of the jury's sheets, I'm pretty sure. I think it's labeled count. But whatever it was, I would just mirror the language of the jury verdict. Because what the hell is an indictment? From the jury's point of view, what is an indictment? Right? So not ideal instructions right from the top, but we press on. For each indictment, you must decide where the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Again, why not just use the word charge twice, right? Why not just say for each charge, you must decide whether they're guilty of that charge? Why say for each indictment, you must decide whether they're guilty of the charge? Fuck me, right? And fuck me if I'm a juror, right? That's just fuck me if I'm a juror, I guess. Your decision as to each charge, and again, your decision as to each charge must be unanimous, meaning all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. Fuck me. Just call them a charge. Just use the same word. Just call it a charge each time. What is an indictment? It's not labeled indictment on the top of the sheet. What's an indictment? Am I supposed to have a sheet reflecting? Am I supposed to have a sheet that talks about indictments? Where's the sheet? Where's the sheet that talks about indictments? I don't have it. Also, in every case, isn't there only one indictment? Is there a case with more than one indictment? I mean, there can be amended indictments. They can amend the indictment. But is there a case in which there is actually more than one indictment, like simultaneously running? Is that a thing? I actually don't know. Is that a thing? Is that possible? Is it possible in a criminal case for a jury to have a case in which there is more than one live indictment at the time? Is that a thing? Does anyone know if that's a thing? I was under the impression that there's only one indictment. There can be as many charges as you want, of course. But I was under the impression there's only one indictment. Is there more than one indictment? Is that a thing? I don't know. Probably in some jurisdiction there is. Pressing on. When all 12 jurors agreed to the verdict for each particular indictment, and again, where is this indictment thing I'm supposed to be talking about? The foreperson should check off the verdict and then sign and date the slip and ink. For each charge, back to that word charge again, if you all agree the Commonwealth has proved every element of the charge to beyond a reasonable doubt, then you should find Miss Reed guilty of the charge. On the other hand, if you all agree the Commonwealth did not prove one or more elements of the particular charge beyond a reasonable doubt, then your verdict must be not guilty. So again, that difference between should and must. So technically, jury nullification is allowed, right? Because she said should. So I would not be breaking any rules, right, as a juror if I thought guilty in my own head but voted not guilty. Because the way it says, right, just read the words on the page, right? If they didn't prove it, you must. But if they did prove it, you should. Right? So if I, as a juror in my own head, thought that the state proved each and every count, I should vote guilty, but I don't have to. Right? So if I voted not guilty, even though I thought, you can call it jury nullification if you want, but the instructions allow for it. So I'm not doing anything wrong. Which I think is interesting, because I think in some jurisdictions they do say must. I think in some jurisdictions they say you must find guilty. But in this jurisdiction they say should. And that difference between must and should is a very powerful difference for a lawyer in particular. In on the joke for $5 with a bunch of questions. Can the jury find them guilty of DWI, OUI without finding her guilty of manslaughter? Yes, they absolutely can. Yes, the fifth item on box 2, the fifth item in charge 2 is just straight, no nonsense, uncomplicated DUI, OWI, or whatever the fuck we're calling it. Yeah, it's just driving under the influence. That's it. So yeah, it is a bit confusing because at the top it says count 2, manslaughter with OUI. So you would think that if you're finding her guilty, right? You would think if you're checking one of the guilty boxes, you would think pretty reasonably you must be finding her guilty of manslaughter, because at the top it says count 2, manslaughter with OUI. So the guilty options must be manslaughter, right? But it's not. It's not. Because of this weird thing, this weird one trick, because of this lesser included stuff. So I really wish the judge had clarified that. That would have been really nice, because while the jury doesn't need to understand the consequences of its guilty verdict, they should and do need to understand what they are returning a guilty verdict of. Right? They don't need to be concerned with what does that mean in terms of sentencing, right? Because that's not important as to guilt, right? Liability and penalty are different things. They are different phases for a reason, right? You don't need to be concerned with penalty. You need to be concerned with liability. So the jury not understanding what does it mean in terms of the consequences is perfectly fine, but they need to understand what it is they're doing. Right? What crime am I convicting her of if I check this box, can you please clarify that? And for some reason, the judge won't do it. I don't know why, because it would, yes, if you check box 5, all you're finding her guilty of is driving under the influence, bog standard DUI, OWI, OUI, or whatever the fuck we're calling it in the state. Arose by any other name, driving drunk. That's the only thing you're finding her guilty of. But the judge won't clarify that, and so the jury might be confused. Yes, so all those things. Great. Travis says it's possible. Where is he where he said this? Travis said, where's the tweet? Travis said something. He said it's possible with the indictment thing. Yeah, it's possible, but they typically do have multiple counts in one indictment. Right. Because it's read to the jury at the start. Right. So it is possible to have more than one indictment in the same criminal case that's live. Cool. I've learned something today. I've learned that it's possible to have more than one indictment that's live at the same time. This is a weird thing, but I guess it's possible. Great. All right, moving on. Red guy 123444321 for $5 says if she's just guilty on OUI, it would be not guilty of manslaughter. Correct. If it's number 5, it is just DUI. It is not manslaughter. Right. So sentencing for the random dead body in the snow should be irrelevant. Under Massachusetts law, that's correct. Under federal law, it's not. But under Massachusetts law, it appears to be correct. So federally, the federal law would allow her to factor in the dead body. The federal law would allow her to factor that in. But the state law does not appear to allow it. So that's really good for Karen Reed. So if she's found guilty of the DWI, it appears under the state law that the judge cannot, as part of sentencing, factor in any fact for which she was acquitted. Like, for example, the dead body would be such a fact. The federal law would allow for it. The state law does not appear to allow for it. And the state can provide more rights. That's fine. So there's no conflict. This is fine. So the judge would not be able to factor that in. So she would only be able, she can't factor in any fact, it appears. She can't factor in any fact for which she was acquitted. She could factor in other facts that have not been, she could factor in other facts that have not been proven thus far, because you can have new evidence during a sentencing phase, and that's not uncommon, right? For example, just to make it really clear, the most common thing that you will bring into sentencing that you would never bring into liability is your prior criminal history, right? The jury will not know and should not know during liability, that is, did you do the bad thing? Liability is, did you do the bad thing, right? As opposed to what should we do about it, right? So the jury will not know whether or not you did a bad thing in the past, right? They're just trying to figure out whether or not you did this bad thing. So any criminal history you have is irrelevant and will not be presented during the guilt phase. However, it can be presented during the sentencing phase. So that would be new information, right? And the state has to prove that. They have to prove that you've been convicted in the past, but it's only preponderance of the evidence. And of course, proving it is pretty trivial because all they really have to do is show the certified court record that, from the various jurisdiction, they just have to present the certified record that shows the guilt. And that's pretty much the end of that game. So they do present new evidence. They do have to establish it, but they only have to prove it to preponderance. Okay. So the only things that show new information could be brought in to sentencing, but it can't be information, at least in Massachusetts, for which she was acquitted. So I don't know what that would be in this case. There has been no suggestion at this point as to what that could be. So I don't know if there is any, I don't know if the Commonwealth would want to bring in information, relating to whatever. Like, for example, at least the federal law, and we haven't seen a state law to the contrary. But let's suppose, even though she's never been convicted of it in the past, let's assume that Miss Reed is a habitual drunk driver. She's never been convicted of it. She's never even been charged about it, but she's a habitual drunk driver. The state would be allowed, at least as a matter of federal law and state law, maybe too, but they would be allowed to bring in witnesses who could say that she's a habitual drunk driver and she's drunk drive in the past. And that then they would be, the court would be allowed to use that information in the sentencing of the DUI. So if they could present that to a preponderance evidence standard, that would be allowed. There's been no suggestion of that. There's no information relating to that. We don't have that. But that would be the kind of thing that appears to be permissible. So anyways, that was a very long-winded answer to your question. Anyways, there is another page of this thing. So also the other page says, the state didn't ask for the DWI sentence. Well, no, not yet, but they will. If she's convicted, they don't have to ask because we haven't gone that far. So if she's convicted of the OUI, I mean, there may be a sentencing hearing. I don't know how they typically do it in the state. I don't know. Maybe there's a sentencing hearing. Maybe there's not. Maybe the state doesn't want to have a sentencing hearing, or maybe the defense doesn't want to have a sentencing hearing. You know, you don't necessarily need to have one. So maybe the state doesn't present anything more, and maybe they ask for sentencing, you know, immediately. Some jurisdictions do that too. Sometimes they do it sometimes they do it in serious cases. We've seen it. It was Florida, I think, where they basically did sentencing like immediately in a murder case. I'm pretty sure I saw it. Like it was a murder case, and the jury convicted, and the judge then like literally sentenced them like immediately. So they didn't do like the pre-sentence investigation. They didn't do any testimony. The judge was like, okay, the jury just found you guilty. I now sentence you to whatever. And that was the end of that discussion. So that sometimes happens too. Sometimes in serious cases, apparently. But in any event, you know, so maybe she sentences immediately. If she's going to sentence immediately, one would presume it's going to be to whatever the bog standard it would be the bog standards penalty for a first degree or for a first time DUI, which seems to be like classes of some kind. Seems to be like the bog standard penalty. It seems to be some sort of, you know, alcohol and you bullshit, you know, class thing. So seems to be like what it is. So if there's going to be an immediate sentence, that's probably what it is. But in any event, whatever. When you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in the case, as well as the verdict slips you'll be using in returning the verdict. The foreperson will be given the verdict slip setting forth the charge against the defendant. 12 jurors must agree before you have a decision to any specific charge. This means that to find the defendant guilty, all 12 must agree. I'm not sure how that's any clearer than what she said in the previous sentence, but whatever. You should consider each indictment individually. Again, I would probably go with must here rather than should, because each charge is separate legally. So instead of should, I'd go with must, but whatever. You should consider each indictment, and also charge instead of indictment. You should consider each indictment individually and continue deliberating until you reach a final verdict, and then they struck out on each charge for some reason, which, whatever. All that stuff. Oh, he sent me a text. Oh, hold on. Sorry. I've been busy and ranting, and I'm confused, and things are mysteries to me. Yeah, let's punch on with defense diaries. Hold on. Talk amongst yourselves. Thank you for letting me know. Uncivil is not being observant. All right, by the way, just, you know, FYI, you may not see them on screen initially because I'm doing this the jank way. So I have to set it up so that you can see it. So if you just hear the voices for a second, it might take 20 seconds or something because I'm doing this jank. I can do it. It's just a little jank. So, please be patient accordingly. All right, great. Let's pump on with defense diaries.
Completely wrong. And like with them like fucking coming back with a hung on that stupid fucking OUI, which the problem with it is
Mandy, you got to figure out how to get us so we can.
Yeah, we got like Kurt's back there too.
Andrew Meyer in the chat. That dude's awesome, man. I want to give a shout out to that guy. Andrew Meyer. He's an attorney as well. He has a channel, Law Offices of Andrew Meyer.
Oh, he does.
Yeah, I was on his show one time. He's really, really cool. He's a good dude. He's an attorney as well.
Andrew, if you're on the Twitter machine, hit me up, dude. DM me. I'll throw you a fucking invite. All right, I'm bringing Kurt on too. We're gonna have a partay.
All right.
Civil law.
How you guys doing?
We're checking OnlyFans back here, everybody, so no one get nervous.
I've got OnlyFans spinning in the corner. OnlyFans makes me happy. OnlyFans spins for justice. She's the best. She's the best OnlyFans performer I've ever seen in my life.
She is. I mean,
and she doesn't even charge me a premium to see her private content. How nice!
I know, it's amazing.
Wow.
She's very giving. She's very giving.
I love it.
So I'd like to know from you guys, as like your night progressed, and like, I imagine it's hard to like start to drift off to sleep and not have like things that happened yesterday, like just kind of like creeping in. What angered you? What did you get more angry about as the night went on?
I drank myself to sleep last night, so I don't have. I don't remember what I was the most mad about, but if I had to pick what made me the most mad, it was the way that Bev just completely disregarded AJ in his argument. Just simply asking her to be clear to the jury, simply asking her to acknowledge the rights of his client.
It's fucking insane. And Kirk, what do you think? Like, the writing's on the wall, right? The judge knows the jurors have, just dismissed the collision aspect. Why still be so, I can't, whatever the word is that she's being, like, why?
I know the word. I'm just not going to say it.
Well, there's the charitable answer and there's the non-charitable answer. The charitable answer is that she wants to play it like ultra safe. And so she only wants things that have been vetted and approved by the Supreme Court of the state, and the Judicial Commission and so forth. So if it's not a model instruction, if it's not a model form, if it's not a model whatever, if it is not, the tried, trusted, approved thing, she doesn't want to use it because she wants to play it ultra safe. That is the charitable interpretation. The non-charitable interpretation is because, can I curse?
Yeah.
Fuck yeah.
Okay, so the charitable interpretation is that she's a bitch, and she would rather have a mistrial than a not guilty, and so she's not going to do anything.
That's still pretty charitable.
That's not uncharitable enough. Oh, okay. What is the uncharitable version? I thought that was the uncharitable version.
I'm still not going to say it because Allie's here.
Oh, okay.
Yeah.
Well,
yeah.
But and I also feel like she has got to like prove that she's the boss when she's already wearing the black robe. Like, you can only have a minute. What is wrong with her? It's
not going to say
it.
Say it diplomatic. Say it diplomatically. Say it with diplomatic flair. You can do it.
I mean, can I say it in a British accent since it's
sure.
there?
Yeah.
Okay. And
I think we'll get a strike.
We all know.
We know what you're saying. We know where you're going.
Is C for Cookie? Because Cookie's good enough for me. Cookie starts with C. Is that the problem? Okay.
Yeah.
All right.
See you next Tuesday. That's
okay.
We know.
She is such a cookie. Oh my god. Ugh.
But she's, the law, from a legal perspective, when the jurors ask a question of law, the law says the judge should answer.
Yeah. And it would be probably helpful if the jury understands what charge they're convicting her of. That might be nice.
Right.
Like they don't need to understand what that means practically. They don't need to understand what that means in terms of a sentence. But like, what crime are we convicting of her? If we check this box, are we finding her guilty of manslaughter? That seems like a pretty reasonable question to me.
Pretty straightforward too, you know. It's like, the thing with her talking about that question being a theoretical. It was not a theoretical. I mean, the jurors.
I mean, it said if, man. It said if.
What do you mean?
Who knows what that means? Could mean anything.
It's like, because they put if on there, she turned it into a theoretical when it was clearly, all right, we've reached a verdict on 2 of the counts, but we're having an issue with this third one. And how does the fact that we've come up with a verdict on the, because Allie was reading that in a different way than I was. She was thinking, all right, well, are they concerned that, are they flat out asking what the problem was in trial 1, wherein it's an all or nothing proposition? And I was hearing it as a different take in terms of what these jurors were thinking. Like, because I'm of the mindset that all these folks are from that county. All of these folks have some knowledge about this case. Like there's no way they don't. Like, these people are all aware of what this case is about, what's been going on with it to some degree. Like, I don't think there's one person on that juror who's like, I never heard of this shit. There's definitely some kind of knowledge base there. Now, what that is, and we don't know if there were jurors that wanted to get onto that jury. You know how it is with high profile cases. There's always going to be people who are like, I want on that jury. You know what I mean? That are like, going to angle if they get the jury notification, they're going to like, I'm going to do and say everything. They're Googling, how do I get on this jury? What do I need to say to make sure?
House to get on jury. House to get on jury.
Right, exactly. So, like, Allie had a really good point. I can't remember if she brought it up, and she brought it up earlier in the live, but she said it either last night or this morning. She's like they're family members because they aren't sequestered. They're going home. They're obviously somehow able to avoid social media and just the media in general, which I find to be impossible as well. But
you're not human if you're on this jury and you're going home and not talking about this.
It's insane. But like Allie was trying to keep it above board, and she's like, that person's like significant other is going to be saying, I'm not going to talk about the case, but you cannot hang. You cannot hang. And
just convict on OUI.
She's way better off if they just convict on the OUI because of the ramifications. If they hang on the OUI, that they can come back on the manslaughter, which is just like
annoying,
insane.
You just run past the bathroom and they're in there and go, don't hang.
I'm probably alone here, but I'm okay with that. But I am strongly of the opinion that any juror that pushes to convict her of an OUI is an asshole, because it's so petty. It's 3 years that have been by. Why are we here? We're here for a murder. You're proving that the murder didn't even have, the impact didn't even happen. Right. So what does it matter what she had to drink that night? It doesn't matter. Not 3 years later, it certainly doesn't. So
Will, if you're a juror and you're back there right now and you're taking this, no. Even if it creeps into your mind that if I don't give, she can be charged again for manslaughter, you're going to say no?
Why would she be charged again for manslaughter? Explain that.
Because if they hang on count 2, it's the manslaughter charge. It's a lesser.
No. Okay. All right. Yeah. Let me be more clear. My prediction, and this was my prediction before the jury questions even came in, was they're going to acquit on two of the charges and hang on the OUI charge. The manslaughter charge is acquitted. That's the assumption I'm making.
See, so that's the problem, because that's what I think every layman, and still think, thank you, Judge Cannoni, that the jury is still confused about, because you've got count 1, 2, and 3. And it's clear from the last question, because they use the words, if we have not guilty on 2, and we're left with, but we're not agreed on 1, is she not guilty or is it a mistrial on all three or all of them or just one? That they are talking about the counts, the murder count, the manslaughter count, and the leaving the scene of the accident count. But on count 2, if they have one option, right? Not guilty on all, or including the lessers, and then they have to choose. If they don't choose that, they have to choose a guilty. If they don't, count 2, manslaughter on down, is in play for trial number 3, because there's no way, and the law in Massachusetts seems to want it this way. And Kurt, tell me if you're wrong, but we've looked at this every which way, that they want it to be like that. Like, that's it. You can't have you can't say not guilty on the higher offense unless you come to a verdict. So if they don't come to a verdict on the OUI and they're hung on that, the Commonwealth, can retry Karen Reed for manslaughter for everything listed on count 2.
Yeah, the way it is right now, they've got to check one of those 5 boxes on that second page.
Yeah. Or the whole count is
or the whole count is back. There's no way for them to express the view on that form that we have not guilty on like something, but not that. They can't do that on that form.
And it's not a strict form issue. It seems to be the Massachusetts wants it that way issue. It's like it's
the Bev wants it that way issue. Because even Yannetti, when she tried to get validation from him last trial about this, because this is history repeating itself. So she looked for David Yannetti for validation and was like, this is how it's done in Massachusetts, isn't it, Mr. Yannetti? And he was like, no, bro, like, what are you talking about? So,
yeah. All right. So Will, now taking into account that fact, because I agree with you, like this is a murder case, and them capitulating and giving a compromised verdict of fucking OUI is total bullshit.
It is.
But now understanding that if they hang on this thing, if there's someone in that jury room that is of the mindset of you, like, dude, we're not here on some bullshit OUI case. There was no collision. John was not hit. I don't give a fuck. I am not finding her guilty on jack shit. You're never going to change my mind. But they may not understand that if they hang on it, if they refuse to do the compromise verdict, that means that these sons of bitches can bring it back a third time on a manslaughter charge. Like, so.
Would that change your mind?
Would that change your mind?
Probably.
Well, no. I still want to.
No. No.
I still want to fist fight the persons that are insisting on convicting her on anything.
And that's
therein lies the rub.
Horrifying.
Therein lies the rub. That's why I'm on one.
Horrifying. Like, dude, like the whole point. I mean, no, I understand what you're saying, but that infuriates me that much more that I'm being cornered as a juror to convict in a way that I'm being led.
Right.
Like I'm being pushed to that.
Right.
So
yes.
This is why. Now, to ultimately answer your question, for this reason, I would have never been picked as a juror in the first place, because I would have been like, this is a fucking sham and everyone knows it. So I would have never gotten picked. But had I gotten picked and this situation was presented to me, I don't know. I feel like my emotions would get in the way and I would insist to the foreman, like, this is not right. This is not done correctly. We're being pushed to convict her of something.
And Will, you're the juror. That's what we as defense lawyers want our jurors to be doing in every other situation in the world.
Right.
Except this one. I'm like, remember when I told you, hold your own, don't give, don't cave, don't compromise. Erase all of that. Right now.
Now, Kurt, I've been arguing for the past, 36 hours that the mistake that was made by the defense team in this was that they asked for that lesser included to be attached to the manslaughter as opposed to count 3, which was the OUI leaving the scene, which carries a much less stiff penalty. Like, I think, and it's a better fit. You know, I mean, that's an OUI, flat out OUI charge. And I think that the Commonwealth would think long and hard before coming again on that charge if the murder and the manslaughter were off the table. I mean, because I think they could have asked to have it on count 3 as opposed to on count 2, and she would have been agreeable, maybe. You know, what's your position on that?
Well, I'd have to take a look again at the statutory language on count 3 because I haven't looked at it in a while. So can you pull up the verdict form or something so I can intelligently comment on this issue?
While he's pulling it up, do we think, because I've never thought about it before, that it's even something a defense attorney could ask for at this point? Say, Your Honor, we've decided, we asked for this lesser included, and we've decided we want it to be shifted over to count 3. Is it even a question that could be asked? I mean, other than that, I was like, can they say, you know what? We changed our mind. We take it off.
I think technically yes, but even I as a judge would be very reluctant to do that because when you change things that dramatically, I think that just can lead to more confusion. So I would be disinclined even if I could do it to do it.
Yeah. Yeah.
See, at the Glare Institute of Law and stuff, we haven't taken it that far. The way we see it is if they're going to corner us as a jury to do this, then not guilty on everything. Screw Bev. You know what I mean? Like, not guilty on everything. Like,
no, I mean,
what you know what I'm saying?
Yeah, I hear you. And I feel you. And like I said, in every other situation, I'd be begging for a juror unwilling to compromise, you know, except here. And it's scary because you know a lot about this case. You've got lawyers explaining it to you. You understand the ramifications, and yet because of your convictions and how strongly you feel, you're saying I would still dig in and stay firm, and that could be a whole trial number.
I mean, I would have to be in that position, truly.
Right. You know? I know, but even to have the feeling right now and to be struggling with it.
I get what you're saying. Like, you know, if it comes down to it, like if it's either, hey, we're hung, or we have to convict of an OUI so that there's no manslaughter.
They may never understand that. She will never explain that aspect of it, right?
Right.
Kurt, so, there's no way she'll give them that piece of information, right?
Probably not. Maybe if they asked just the right question with just the right magic words, maybe she will. But, you know, she's not going to go out of their way unless the jury is like, you know, very clear and asks for something very specific. And even then, who knows?
Say the words, if we remain hung.
Not that word if. That word if is going to be a problem. If they said something like, we have a verdict as to count 1, count 2, and we have a verdict as to parts of count 2, what should we do? If they ask something that specific, maybe.
And if they said, and we have a verdict on parts of count 2, but want to know whether, I'm trying not to say if or whether, that if it's not guilty only on some and undecided on one, is the entire thing, is the entire count a mistrial? Will she say that's worrying about the ramifications, the consequences?
Yeah, I mean, the way, again, I think my wording is clear. It's just like, we have a verdict as to count 1, we have a verdict as to count 3, we have a verdict as to part of count 2. What do you want us to do?
Right.
In terms of, yeah, that would
what
be.
What do you think the answer would be?
Deliberate harder. I don't know. I can't answer that question.
So
she'd say you have to be unanimous, and if you're not, you're hung. Go ahead.
Yeah, Ali, you were asking earlier, like, my whole thing is the verdict slip being set up the way that it is. Sorry, I got distracted by chat and I lost my train of thought. I'll come back to it. You guys see.
Right. We do have the new verdict slip. If anyone wants, Bandy did send it to me. If anybody wants me to.
Yeah, I'm emailing it now. I'm waiting for.
Yeah, so I think Bob, I don't agree with the idea of count 3 because I pulled the verdict slip while I've been talking. Offense 3 is simply leaving the scene of an accident resulting in death.
It's not OUI leaving the scene of an accident.
That's not what it says at the top of the sheet. It just says simply leaving the scene of an accident resulting in death. So DUI is not a lesser included of count 3.
No.
Oh shit, that changes everything. I always thought it was OUI.
Yeah, we didn't look at it, and we were just. I had it in my mind too that it was an OUI resulting in leaving an accident resulting in death.
No.
So yeah, that definitely doesn't. Well,
if there was no accident,
well, but
how is
he's
he leaving from it.
Exactly. That's why we think it's not guilty on that. But Bob's was thinking of it wrong yesterday, thinking that count was driving while intoxicated
and leaving the scene
of an accident and causing an accident, leaving the scene of an accident, causing death.
She simply has to know that she would have to know that the collision occurred. She would have to know that she hit him, and she would have to leave the scene of the accident with that knowledge. Is all that's required.
Yeah, that changes everything.
So then that brings me back to my other question of, is it even possible to say we asked for this lesser, we have changed our mind, tell the jury it's gone?
I don't know the answer. If they wanted to strike it completely, if they wanted to strike item 5 completely from the verdict form, I might allow them to do that. Maybe, but I'd have to really think about it. But
new text.
I'm sort of reluctant to change it in that way. Because if it were me, like with the whole like partial verdicts thing, like, do you want the jury to be able to return verdicts separately as to count 1, count 2, count 3? Like if it were me, it's like you can make that decision, but you have to make that decision when we initially charge the jury. Like you can't. I am not a happy camper. It's like, oh, we want to change things because tea leaf reading. It's like you have to make that decision blind. You can't make the decision because of new information. That's cheating.
Right. I've had the situation where the judge sends the jury back and for whatever reason, then hears my directed verdict argument and directed on one of the counts and brought the jury out and told them it might not have been that. It might have been after the whole trial and he had to tell them ignore all of this stuff. That actually might have been what happened. I can't remember. But now I'm thinking that might have been what happened, that it was at the end. So he said, just ignore all the evidence you heard on this because that count is gone.
Yeah, but that's fine.
Yeah.
Another reason, incidentally, that judges will hold that back for a lot of reasons. Like it's like if they were going to give the directed verdict, they'll typically wait for the verdict from the jury anyway, because maybe the jury gets it right and I don't have to do anything. And if they do, then I can just do it at that point. So that's pretty typical.
Yeah. No. Yeah. He didn't in that one case. I just remember them telling the jury like that's not an issue anymore. Ignore it all. But yeah, I could see him doing exactly what you just said. Well, let's wait because I'm gonna direct it, but let's just see what they, what they do.
16 hours on the jury clock now. 16 hours.
I mean,
it's about 15 hours and 55 minutes too many, but okay.
So here's the thing: when we're talking about this compromise verdict, and the question number 2 of, unless that was 1, I think it was 1. What time is the DUI?
Yeah, that was interesting. I think the defense was legally wrong. I think Brennan is correct. It's a lesser included. So the time of the DUI for the purpose of 2 would be the time of the alleged manslaughter because it's lesser of the manslaughter. So the DUI would be at 12:40. Brennan was correct.
But wouldn't that dismiss if the jury has decided that no collision even took place, and also the fact that there's no blood alcohol for that time.
Yeah.
So can't they just, wouldn't that be more of an incentive to vote not guilty all the way down the board?
Well, it depends where they were, but I think that the lawyers, if I'm the defense team,
drunk at 12:45, how can they prove that?
Well,
you know what I mean?
Yeah, I think people somewhat misunderstand this issue on DUI because they confuse the way it typically happens with the way it must happen. You don't need to. DUI is fundamentally no different than any other criminal charge from first principles. So you don't need to charge them the day it happened because you don't need to charge any crime the day it happened. You don't need evidence from the day it happened because that's not true for any crime. What you need is evidence from whatever source it is or combination of sources that prove guilt beyond a reasonable doubt. That can be, but doesn't need to be a breathalyzer. That can be, but doesn't need to be a blood draw. It can be other things. It can be whatever evidence would convince a jury. In this situation, They have posited it from the video they showed at the bar. They have posited from eyewitnesses who were there seeing the drinking, and they have posited from the blood draw that was done by the hospital, which, you know, is not an accredited lab for the purposes of that thing, but it's still some evidence by definition, because evidence by definition is anything that makes a fact in dispute more or less likely. So the blood draw from the hospital is evidence that necessarily makes it more likely that she had a blood alcohol of whatever at a given time. Now, there are a lot of ways to confuse that, but yeah.
But doesn't the lack of a blood alcohol testing at that time create enough reasonable doubt? Isn't there already enough reasonable doubt whether or not she was drunk at that time?
Well, creating reasonable doubt and having evidence that also could be relied on by a jury to find guilty are two different things. I agree with you. There is enough evidence in there.
I don't know. I'm just asking.
No, but I agree. There's enough evidence in there. If a juror wanted to find reasonable doubt, they could. But as Kurt's pointing out, there's enough evidence that if the juror wants to say, I think she's guilty, that the law would say, well, there's enough there to support a juror making that decision. But I think that the lawyers, the defense team, decided to keep it like that because they thought it would help the jurors. All right, some want to say 5, some want to say 12:45. Give it to them both and let them go. Now, under the law, typically that is an unconstitutional verdict because you don't have any way to establish it was unanimous.
Yeah, you're presenting two different times. So how could I mean, it's that right there in and of itself spells reasonable doubt. It's spelling it out, right? I mean,
well, not necessarily in principle, because again, it's like as long as you could all agree that it's one of them, then you're there from like first principles.
I don't think so for unanimous verdict.
There's no way for them to express that on the verdict form, but like in principle, like if they all agreed on the same time, then that makes sense.
Well, correct. If they all agreed on the same time, that would make sense. But this allows them. In any other situation, I, as the defense attorney, would be saying you're giving the jury the option to reach a verdict that's not unanimous, because some are saying she didn't do this event at 12:45, and some are saying she didn't do this event at 5, and you're combining them to come up with a unanimous verdict.
Well, the bigger problem is, even if you assume somehow you just magic it into existence, they unanimously agreed at like 5 a.m. It's not a lesser included of count 2. So like, guilty, you don't know what time they convicted of. And so you have a problem on appeal because it's a invalid charge because it's not a lesser included. If it were a naked DUI charge, then you could dispute the time, but you can't do that in this context because it's a lesser included. So it's very odd.
But the defense
I think she made the right decision in the sense that, you know, OUIs, DUIs, whatever you want to call it, are specific in terms of the time that crime was committed. And by way of them not including anything in the indictment as to what time they're alleging that happened.
But it's a lesser included, babe. That's what Kurt's saying.
I understand that.
It has to be the time that carries forward from the charging offense.
For the manslaughter, right.
Right.
I mean, right. I agree. It would have had to have been the 12:32 or whatever.
But the defense did this on purpose because they want a compromised verdict on OUI.
Yeah, I think that's true. I think that they are trying to expand the range of the DUI because it's as long as you check box 5, we're happy. So do you think she was drinking at 12? Do you think she was drinking at 5? Do you think she was drunk yesterday? Yesterday is fine for us too. As long as you check box 5, you know, we're happy campers.
Yes. Or 1, we'll take the
1 or 5, either of those options would be great. Thank you.
Yeah.
But not Will's option, not the Glaire's option.
Yeah, it's historically accurate to never go with my option.
No, but Will, that's I believe that is exactly what the jurors are doing. You've got at least one or more of you. I'm very confident in that, saying, no way, you're not getting me to say guilty to anything, F you, and not realizing like
the ramifications of it.
they think that maybe all three will be in. So that's
Did you say you wanted to fight me for voting guilty? I was like, I'll fight you for not voting guilty. We could go outside the back. We'll see who wins.
That makes perfect sense, Ali. It makes perfect sense because I would not. I probably would be so like if there's a strong personality who tends to be emotional on that jury and feels like this was the biggest waste of time and taxpayer money in the world, you know, they're going to be adamant. You know what I mean? And even if they're smart enough to understand what you're talking about, their emotions are going to cloud that. You know what I mean? Their principle, their sense of principle is going to. Mine would.
But if there's one juror back there that understands the dilemma,
I would love to say that I'd be like, yeah, I get it, but I probably wouldn't.
See, but that juror that's back there that's fighting for that one, then they come out and if it's hung, and then they find out that she's going to be recharged on the manslaughter and retried, they're going to be fucking killing themselves about it. You know?
Yeah, there's no joke.
Like, I mean, it's.
Let me ask
a nightmare
all of
scenario.
you.
It's a nightmare. My fucking head is still spinning about count 3. I could have sworn that it was OUI. I'm still.
You have a little false memory going on there.
Yeah, clearly, I have a very, very
never for me too.
False memory.
I hopped on. Why do you guys
vivid?
I know. Why do you guys
changed my whole mind about Kelly Dever? Like now I see how it's like I've read it, I saw it. It's like it happened in my head. That's crazy. That's crazy because you're right. If that's not OUI is not a part of it, you can't stick it in there. Fuck. So we're stuck with doing this. That changes my evaluation on like how much I think they might have fucked it by adding this thing in there. You know, like with that being the only option, it's like, I mean, what would you like? I think ultimately everybody agrees this was Karen's decision. They went with her. They gave her all the insight on it.
I'm sure
they made the right decision at the time. It's a
gut call. There's no question.
The jurors, what they're hearing from juror Ronnie, they had to take like backup. But why do you guys think? I feel like we're probably all or at least felt very sure that they had come to a not guilty verdict on counts 1 and 3. Why the hell haven't they sent out those verdict sheets yet? Somebody.
Because they don't understand the verdict sheets.
Exactly.
They might be holding them hostage, Kurt, or you think it's that they don't understand, or that they're holding those hostage and trying to get a verdict on count 2.
I'm a little reluctant to tea leaf read jury forms for sort of any value because I think that they can be misleading and we read sometimes more into them than anything. So while I agree that I think the most plausible conclusion is that they are, sort of wrestling with the DUI, I don't necessarily want to take that for a given. I don't know if there's some juror out there who wants to convict on some version of manslaughter or some. Yeah. I don't know, and I'm reluctant to kind of draw those conclusions. So I don't know what the problem is. I would like them to solve the problem anytime. Be great.
So I think
we're kind of up to the conclusion that they, just assuming that they've reached a verdict on one.
Might have just been asking theoretical questions
on 1 and 2 or 1 and 3, and that it's 2 that they're hung up on. And I think that the only reason that we think that is because they were asking specifically about that form or that flip. But you're right. I mean, theoretically, they could be trying to be tricky in terms of not giving up any intel to the judge and not giving accurate information as to which thing they're on. And they just wanted to have an answer about that slip 2, because it's so fucking confusing. I mean, the other 2 are pretty clear, I mean, like that's your typical verdict slip. It's either guilty or not guilty, and you don't have the issue of the lesser includeds in there. So it's kind of like, it's right there for you. But man, yeah, it's like, I feel like, and I did read the tea leaves yesterday. I feel like that's probably what they're debating on. And that's what's got me kind of in a little bit of a panic mode about this because of that concept. Like I'm less panicked if they're hung on manslaughter. Like that changes the entire thing. If they're hung on one of the lessers of manslaughter, as opposed to just the standalone OUI, I'm still pissed, but I'm in a different way. Whereas she's not getting hauled back into court to try this case again based on them being hung on an OUI because they were really hung on the manslaughter portion of it. But like the thing is that we'll never know. It's going to be the same. It's going to be the same circumstance. If they're hung, they're hung. And if they don't reach a verdict and they don't check any of the 2, 3, 4, or 5, we are not going to know unless one of the jurors comes out and speaks.
All right. And now we can see what Mark Betterow thinks.
Yay!
Do you think it's possible the jurors were just asking, theoretical questions and that they're hung on a bigger count?
No.
He brings us back down. He brings us back.
Good. Mark's where I'm at.
He's leveling us out.
Oh, yeah. I mean, anything's possible, but just by the plain meaning of the notes they wrote, if you assume they're moderately intelligent people, they seem to indicate there was a problem with count 2, lesser included offense 5, and then asked a series of questions that would seemingly apply to fact finding on that count. And then you found out there was a 4th note, which probably crossed in the carrier pigeon mail before she charged the jury, that they wanted to know, I think, what if we hang on that? What are the consequences on the rest? So, I mean, you never know what they're really doing, but seems to me that they're all twisted into a knot on a misdemeanor DWI, which after 2 months and 3 years of all this that's great.
I know. And if you heard, I don't know if you were listening, but Will says, like, if he was a juror, he would stay dug in. Even with everything he knows right now, although he gave some wiggle room, but he's just saying, like, in his heart, he feels like he probably would be saying, I'm staying dug in. I'm not going to say guilty. Absolutely not. They're trying to force us to say guilty because she can get retried on this. Now I'm still not doing it.
Yeah, Will's he's the principal of the thing guy. It's like the principal of the thing. There's no way I'm doing it.
Look, man, like, all I'm saying is, even if this jury, I get that if this jury on a much larger moral level, it's probably better to just agree on an OUI, right? Fine. I concede to that. But any juror that does that is to some degree an asshole, and they need to repent. That's all I'm saying. That's all I'm saying.
Mark, is it legally possible for I haven't thought of it or researched it, for the defense team to go in and be like, hey, we asked for that lesser included. We want to withdraw it.
Yeah, we were just kidding.
I don't think so. No, and I think it would look terrible at this point. They asked for it. You got to deal with it. I think also that if these jurors actually believe that if they hang on the misdemeanor, that it could lead to a retrial for up the whole food chain of count 2 all the way to manslaughter, that even if there are some people who think that she's guilty of the misdemeanor, if they have awareness of that full ramification, if they can't agree, then they're duty bound and morally and obligated to acquit, because the idea that yes, I'm advocating nullification in this sense, because if you believe that she's not guilty of manslaughter, but you're willing to convict her of a misdemeanor, but the consequence is you're going to be hung, and so she's going to get retried for manslaughter when she ought to be acquitted, and you're going to have a 3rd trial after 2 acquittals, which only would happen in this case, then at that point, I think the people who are guilty on the misdemeanor are morally obligated and to just acquit and say we can't have another homicide trial. You can't have 3 homicide trials after she was acquitted of homicide charges in both prior trials. That's crazy.
That might likely, based on Will's position, and I'm accepting Will as a possible, mind of a juror in there who's dug in, that's what we're going to have to hope for, what Mark just said, that the people who actually think she's guilty just say, fine, because I sure as shit don't think she's guilty of manslaughter, and I don't want that possibility of her being.
What's wrong with just voting not guilty all the way down the line? Like, you see what I'm saying? Like,
right.
To me, it's just a simple, okay, this is confusing, and none of us can even explain why we're even here. So, not guilty. If there's a presumption of innocence, what are we thinking about here? What are we talking about?
They may be here because the defense asked them to consider the misdemeanor and the ultimate cruel irony of this whole thing. I guess the real question is, would you have asked for that count given the evidence on the higher charges?
Not in retrospect, but I think I very well might have initially. But obviously, knowing what we know now, I'm sure they're all like, "Oops, that backfired."
No, I'm or obviously retrospect. It's a disaster. Just the fact that this is even being talked about. But I always thought, it's either a car accident or not. I thought they were really strong on the no car accident, nice, clean, and this kind of muddies it up. I understand why they did it, but I think it's now, if they're debating over drunk driving to the point where it could screw up the whole thing and lead.
It's terrifying.
The jury instructions are a mess. The jury slip is a mess. Everything's a mess. The notes indicate they're exactly where they were a year ago. I mean, this is, I don't even know what to call it at this point.
It's like it's the worst case scenario. It's like I was talking about it like 2 days ago with the concept that if they hang, as soon as they ask for it, I'm like, if they hang, and I kept thinking until Kurt corrected me that count 3 was an OUI leaving the scene. Like that was in my head. And I'm like, why the fuck didn't they put it on 3 instead of on 2? Get rid of like be as far away from the manslaughter. And then Kurt's like, yeah, no, that's just like straight up leaving the scene. I'm like, oh my God. So they were always stuck. Like they went in knowing that it was going to be attached to that manslaughter. And like, we're talking about some super fucking bright attorneys who all were like absolutely aware of the concept that if they got hung on this OUI, that results in her being brought back a third time with the manslaughter. It's so easy to sit here and armchair quarterback this shit, right? Like it's like, but in that moment, they go to Karen, and I think we talked about this already, Mark. Like, Karen made the final decision on this. I'm pretty confident in saying that. I think that they went to her and said, look, this is our concept with this. This is if we give them something to hang their hat on, God forbid, and Judge may hammer you on it. I'm sure that they were very clear about that. You may pay a trial tax on it. She could hammer you on the sentence. Is your choice to add that on as opposed to having them get hung on the manslaughter again?
Yeah, I think the thing you're sort of not factoring into this equation is the alternative universe. Like suppose they hadn't asked for the OUI subcharge. Suppose we just had the exact same verdict form that we did last time. Okay, so what would this jury be doing in that situation? And they sort of know at least one hypothetical because we've been in exactly that situation. Like we know exactly what that looks like, or exactly what that can look like. We got to convict her or something. We're looking for something. So like, they're like, you'd like, well, they're hung up on the DUI because some people want to convict and some people don't. But if that in the alternative universe where that charge was never presented, we might just be in the exact same situation. It's like, oh, I want to convict her of something and some people don't. So I don't know. We're necessarily any better off either way.
I 100%.
I don't agree because that's why this is so fascinating to discuss, right?
Yeah.
It's all these reasonable. I mean, there's no right or wrong answer, obviously, and we are armchair Monday morning quarterbacking after the fact. But this is the only lesser included offense that does not require a collision between the SUV and the pedestrian. And to me, that's the litmus test on the case, right? Put aside the added charge. If there's no impact, she's not guilty across the board. And I thought they just were so persuasive on that. At the same time, I understand the nervousness, the family, you have to do something. But I also thought they gave presented a great defense, an incredible summation that really clarified there was no accident. And, the question, I guess, philosophically becomes, do you trust the jury to get past the possible sympathy and all that and say there's no car accident? See, to me, the whole defense argument is premised on there's no collision. And if you're worried about that, then you're done. I mean, if there's a car accident, you're going to get convicted of something. And when I say something, I mean something homicidal.
Significant. One of the significant charges, for sure.
Yeah, no, to Mark's point, and that's Bob Sr.'s point as well. It's like the lawyers should have had trust in their own case. They should have had faith in their own case enough. But like you said, you can
that's critical because I understand it. Right. I don't. I think I err on the other side based on the specific facts of the case. You know, but I understand what they're doing, and I think the choice they made is entirely reasonable. I mean, when it comes to lesser includeds, it comes up all the time. And really, I think most lawyers, probably you guys too, when you think about it, you know, first of all, you're wondering, God, I hope they don't ask for to take this choice out of my hands. Because, you know, where I come from, if the evidence supports it and anybody requests it, it can be included or whatever. But normally, if you think you have a defense case, you know, you don't want it. You want the all or nothing. And of course, if you're thinking, well, you know, I'm probably not looking great on this, then you want anything possible to minimize. And I would have thought this one, again, because if they're going to convict you of anything with a car accident, you're screwed.
Right.
And then the only other thing I would kind of question maybe, and this is total Monday morning quarterbacking, is if you're going to ask for it and you want that to be the off-ramp, or at least potentially, why not tell the jury that? In the summation, take 2 minutes and simply say, look, there was no collision, there was no this. She's also not guilty of driving or operating under the influence, but that's a separate analysis and you can convict that, has nothing to do with the collision, and kind of, you know, put the airline lights that they use at the airport and say, take this exit and go there. Right. I mean, because I don't think it's clear to them, because they didn't even know they were getting charged on that count until they got the jury instructions after the summation. So they had no awareness of this. They do.
I mean, they didn't do that because that's scary as shit. You know?
Yeah.
But that's Mark's point. You put it out there as a lifeboat, an off ramp, whatever you want to call it, then lean into it as one.
You're gonna do it. I think you got to notify.
Hey, I'm sending you a link in private or in Twitter or X.
Yeah,
Bob. It's a new verdict slip per Ted Daniels.
Ooh, exciting!
Another new one.
Yeah.
Another new one.
Right.
Well, the new one from yesterday, presumably, because I still haven't seen the new one from yesterday.
I haven't either.
Mandy texted to us, babe.
Oh, she did?
Yeah.
I would love to see this new exciting jury slip, which goes on for several pages, I think, at this point.
It does. It's lengthy.
Unless I'm wrong.
Okay.
Right, here, I'll pull it up.
Yeah, I have it. Yeah. She sent it. That's what I was trying to tell you. She sent it a while ago.
All right, let's do this thing.
Okay.
Sorry, Mandy.
The whole jury slip context, can somebody explain to me why she had discussion with the lawyers about the jury slip after she gave the case to the jury? Like, what are we doing?
Especially given this case. Especially given this case.
How is that not something that comes up when you're discussing, you know, the charge conference and what you're doing before summations? I mean, have you ever seen anything like that?
I have never seen that. Worst case, they have it like, all right, we've got this general feel. We'll deal with it in the morning before it goes with the jury, but never after.
She said something else yesterday too, kind of a throwaway comment when she was defending this that really scared the crap out of me, or at least should scare the crap out of everyone, when she basically said, well, this is what we do in civil cases. Did you hear that comment?
Yeah.
I missed that one.
What? I mean, that's fine when you're having like a contract dispute over, you know, a few 100,000 shekels and whatever. Not that that's anything anybody wants to lose, but you're talking about a woman on trial for murder.
Just a woman's life.
You're telling a vast experience in civil jury slips. Holy crap. What are you doing?
Yeah, it's scary.
I mean, I know that the Institute of Knowledge that I come from and founded, by the way, is not as prestigious as the ones that you all have as well. But I'm of the opinion that the jury should just draw a little square on the verdict form and write not guilty and check it. I'm totally of that opinion.
I have never seen in my life in any jury slip ever, however many I've seen over too many years to count, in any kind of case, in any case I've been involved in, or anyone I've seen, any filings or whatever, or appellate exhibits and other cases, I've never seen a criminal jury slip that does not have a not guilty and guilty option for every count, every lesser included, one at a time, not some pick not guilty or pick one of these 6 choices for guilty. And somebody showed some of Canoni's other slips in like the 1 or 2 other cases, and it's the same thing. And this is not normal. That's not how juries. They're not supposed to be designed to confuse. They're supposed to be as basic, common sense, simple. Talk to me like a for anyone. And she makes it confusing, and I don't understand it.
All right, here, I'm going to pull this thing up. I'm going to make it bigger. So
I've got it in Acrobat. It'll be better.
No, this is Acrobat, honey.
Okay.
All right, so we're all teeny, and the slip is huge. So
speak for yourself, bro.
hey. All right, so
family channel, Will.
It actually is.
Yes.
All right, so let's see. We've got, here's your language. If you find the defendant not guilty of the offense charge or any lesser included offense, stop and sign the verdict slip. So that's our new language. I like that new language. It's helpful. Guilty of offenses charged. Manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following. So you got your and/or proposition. Then they added this language again. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence, then continue below. I mean, what do you guys think of that language? I thought it was.
I mean, it's a little better. Makes it clear what they're supposed to do stepwise, but there's still no way for them to express sub verdicts.
Exactly. That's the thing.
This is kind of dumbed down, at least. But what if you, in theory, vote acquittals on the first 4 and hang on the 5th?
Right.
The same problem that the jury was indicating yesterday. Because if there was a not guilty down the line, then you could at least avoid that. And if they hung on the lesser included offense, you would all agree and understand they acquitted on manslaughter and they acquitted on these, and that's the way it goes. That's the way it should be. And to start over and get another crack at manslaughter when this jury is saying, we honest to God acquitted her, but we don't know how to check the slip because there's no place for it. This is the same freaking thing that happened the last time.
Exactly.
And retried for murder when she was acquitted.
Exactly.
Well, but it sounds like that's the way Massachusetts law wants it to be, that if you can't come to a unanimous verdict on the charged offense or the lesser in a same count, that they want them all on the table.
But the problem is there's this pesky thing called the U.S. Constitution, which is more important than the Massachusetts Declaration of Rights. So they don't even call it the Constitution because that's too complicated, too simple, whatever it is. I mean, how can anyone with a straight face say it would be just, even under Massachusetts law, from the puritanical days, whatever, that if they, honest to God, try to acquit and want to acquit and are saying we did acquit, but we can't decide a freaking misdemeanor that was added at the last second, that they should get a mulligan for the whole manslaughter charge.
Right.
It's insanity.
Well, I mean,
it's crazy.
Just look at the law that Ken Mello weaponized. I know Mark can't weigh in much on this, but look at the law that Ken Mello weaponized against not just Turtle Boy, but multiple people. That law itself is unconstitutional.
Yeah.
I mean, it's so broad. And it's basically a law that explains you can be arrested for things that you have a right to do.
For talking to a camera.
Like I'm reading, when I read it, I'm like, I can't believe this is a law.
Right. And to your point, Will, like Mark is knee deep in it with Tim. And I'm assuming that they have challenged the constitutionality of that particular statute. It's some lawyer in Massachusetts has been, this thing is fucked. This is completely unconstitutional.
We did. It was not, there were several counts dismissed, not on constitutional grounds, but the reality is, we all understand this. Usually when a statute that's been around forever and is used all the time as a weapon to silence and whatnot, and you're making First Amendment arguments, usually
not on its face.
It's not going to be a trial court normally that's going to take a hatchet to it. And, ultimately it's interesting because, it is a First Amendment thing. So who knows what a federal court would think. The other problem with that statute is, and why, it is hard to have it chucked out, is because there is a state interest in obviously, witnesses not being improperly influenced, and everybody agrees that that's a fair thing. But when it starts being used for people expressing speech through rubber duckies or opining that somebody is guilty of a crime, or even if somebody says something that's offensive that you believe is unfair and not supported by fact, there are remedies. You can sue people for defamation if you believe it doesn't translate to witness intimidation just because it hurts your feelings.
Would you mind pulling up the verdict slip again and showing option number 1? Because I have another way to solve this problem. And the technically correct is the best kind of correct. So if you go back up to item number 1, please.
Yep.
All right. I love the way this is written, because there's another way to read this that you can solve this problem. If you read number 1 literally, it says not guilty of the offense charged or any lesser included offense. It doesn't say every. It doesn't say every. So technically, technically correct is the best kind of correct, as long as you find not guilty on any of them, you can check box 1.
And that goes into what, Mark, your earlier thing, like I'm gonna, petition for nullifying here, but
no, it's not even nullifying. I'm just following the instruction literally. I'm just following it literally. As long as I find not guilty on any of them, I can check box 1. I am technically correct, and I can all move on with my life. It's great. So there's another option for you, jury. Take that one. There you go.
Yeah. How do they give that to the jury?
Well, put me in, coach. Put me in. I'm ready to help.
Shit, man. Yeah, it's like that would have been something that would have been nice to have heard one of the defense
they couldn't make that argument. Really, he's just saying the jurors can lay their hats on it because technically, literally, it's accurate. But no, that's not an actual argument.
I think it is.
No, because then the judge would have fixed it and said to each.
Yeah, I suppose. Yeah, that's interesting, man. Not guilty. Yep.
You're giving jurors so much credit for something that they're not going to pick up.
I'm just here to help to the extent I can. So that's all I had to say about that.
I mean, you're technically right. There's no question.
Right.
I mean, the jury, in essence, is asking these questions to the judge, and she's not answering it that way. I mean, she's not answering even hypotheticals, because that's the other interesting thing is they haven't said we have verdicts on the other 2 counts. They're saying, what if we do? And her attitude is, well, that's not really a statement, so I'm just going to ignore it, which is what she did. She just literally.
Right. I didn't even take it as a theoretical, because they didn't say what if, they said if, which doesn't have to be theoretical.
All right. I think it could have been theoretical in the sense that we've got a decision on 1. We've got a decision on 3. We have an if we're going to stay hung on 2 until you answer us on what happens with 1 and 3.
Well, I mean, there's a difference between what if and if. I mean, we're all lawyers and lawyer on TV, so it's like, but words matter. In terms of her deciding that it was a theoretical, really bugged the shit out of me, because I think that a layperson, that's how they'd write it. So if we've come up with verdicts on 1 and 3 or 2 of the counts, then this is our question. What happens then?
Or how about do what, in our experience, judges usually do when they get a note from a jury if the judge doesn't understand it?
Clarify it.
The way this would happen in New York is to say, I don't know what you're telling me, and it's unclear from your note whether you are saying this or that. And then what a judge here would do is not have a colloquy with them, send them back and say, either re-clarify your note or that's it. And then what they would do is they would bang on the door 10 minutes later and say, you know, we do or don't, and then the judge can answer it. But like this kind of cat and mouse game about, I don't understand what you're saying, but I'm not even going to pretend to ask you to define what you're saying. I'm just going to ignore it. What good does that do? Now, they didn't come up with another note after several hours, so maybe they're satisfied with the general answer she gave. I don't know. But
Kurt, what's the verdict watch at now?
16 hours, 37 minutes, baby.
I mean, what the fuck, dude? Like there is, we are at the point on Wednesday morning, late morning, that it is clear that there is a battle going on back there. You know, I mean, it's like
there's definitely a discussion.
There's definitely a discussion going on.
For sure.
Man, it's I just, because the way that I read it, and I kind of, like I said before you got on, Mark, but like I did read the tea leaves. I'm thinking that they were, and it was really the thing that I used as kind of my trigger in terms of feeling comfortable enough to read the tea leaves was the fact that they asked about the clips and whether or not those were evidence. When I thought about the clips that Brennan employed in his case, the only one that made any sense in terms of them, because I wasn't taking it as a theoretical, I was taking it as we have reached a verdict on 2 of the counts, which is a big assumption.
I took it that way too.
Right. But like the only one that fit in terms of what was left over of clips, because that meant to me that 1 was gone and 3 was gone, which meant that they decided that it wasn't a collision. Right. And that the only clip that fit was the clip of Karen talking about how much she had drank, like that the longest clip that he played where she's going through, it was the weakest drink I had ever had. And I put then that's what got me feeling like, all right, they're doing battle on the OUI.
You know, not to tell the judge her job, but as she will instruct the jury, they're allowed to make reasonable inferences. So perhaps you should take your own advice, Judge. Perhaps you could take that if and make the reasonable inference. Maybe this is suggesting perhaps that this is in fact the situation. Maybe I should draw that perhaps reasonable inference, and maybe I should do something with it. That might be nice.
Or you can teach the jury the law.
Oh, that would be also good.
What do you just do it?
What I can't understand is why, and again, I think every judge normally would do this, would say, I don't understand your question. I don't know if you're telling me something finally or not, and therefore I have no choice but to send you back and ask you to. I've seen that happen before. It sucks. And, you know, if she doesn't want to assume, I get it. The other side's going to complain and say, what are you doing? But why not just say, I don't understand what you're asking me, instead of saying, well, there is the word if, or it does appear this. Even though, look, I think we all interpreted the note the same way. They're telling you we're twisted into a knot with something to do with the second count somewhere down the food chain. It's obvious.
Why would they twisted into a knot? I mean, the form was so clear.
And why not resort, Mark, why not resort to just the jury instructions? Because the jury instructions answered that question and said you can look at them all individually, And I thought the same with the question about the clips, to the point of, if any, that Alan Jackson asked for. Isn't there a jury instruction that says for witness statements you can believe all or none or some?
Listen, when the jury sends a note and says, I mean, Brennan makes the clips the highlight of his case, basically, and the jury note, the first substantive note is,
are they evidence?
I mean, you know, that tells me something.
Yeah. They're like, why are they showing these movie clips?
You know what's crazy is, if this
they're
was
like Super Bowl ads. It's weird.
If this was
really are
a misdemeanor DWI case and you took away the whole collision, this is like a 20-minute acquittal. If it's literally just on proof of driving while intoxicated, either over the 0.08 limit, because that's kind of, you know, fakak the science on this one,
right,
and even what they call common law, OUI, DWI, based upon her apparent willingness or ability to handle her alcohol, apparently. I mean, she's driving like a champ, and has no indication. That could raise other questions in the mind of the jury, maybe. But the evidence that she was operating in a reasonably prudent way. So this
you got Waze, you got her friend, you've got the people driving behind her.
You're doing that on a bench trial, and you're getting an NG on it all day. I was saying the same thing. If there's no John O'Keefe dead on the lawn of 34 Fairview, and it's just a standalone OUI, yeah, you're kicking this thing in a half an hour on a bench, and that's it. You're done. There's no way a judge is gonna convict her on it because they just didn't have the evidence for it.
Yeah.
Well, and the only real indications of Karen Reed being drunk
are her statements.
Are her statements, right? Which I albeit very powerful, sure. Also, her purchasing drinks at the Waterfall and CF McCarthy's, sure, but really the angry voicemails, like at 5 a.m. You know what I mean? But because at the Waterfall, she wasn't acting drunk. Everyone testified, even the McAlberts testified that she didn't seem drunk.
Yeah.
So, I mean, what I mean? So,
if I'm arguing at the bench and and this is going into Kurt's alternative universe again, in terms of in that case, you're not hearing angry voicemails. She's not doing interviews because it's just a standalone OUI, and it's just like every other OUI that we handle in that world. But if there is a world in which they're like, wait, man, we really want to get her on this OUI, we're gonna subpoena her phone records, and we're gonna listen to her voicemails and all this other shit. And I'm using that in defense of reasonable doubt. I'm like she was on one. She went home and she drank. And
that's what I think. That's what I think.
I think that definitely happened as well. I mean,
I'm sure. She was pissed. You would be pissed at me.
You're gonna go off and party, then I'm gonna party too, asshole.
Right?
Blah, blah.
Yeah.
You know what I mean? I could see that.
If it's a misdemeanor drunk driving charge too, without all this excess stuff, you're at least giving a lot of serious thought, which something you never do in 99% of the cases, of letting her testify too. That changes the whole dynamic of there could be something very interesting to say here about when I got home or what I was doing at any given time.
Right, for sure. And does it scare any of you, or how much does it scare you, if it does, that we don't have slip 1 and 3 this morning, that the jurors haven't just sent out their unanimous verdicts on count 1 and count 3?
I don't think they understand. I think that was part of their note yesterday was I agree with all of you. We have essentially put those to the side in the not guilty column, but we don't know what we're supposed to do with this other one. So can we tell you? I think that's what they were asking for guidance yesterday, and they got no answer. So I don't think they know. So I assume at some point this will come to a head if they can't agree on whatever's going on with count 2. But I don't think it should worry people in the sense they've made it seemingly clear they're not paying much attention to the 2 counts that a year ago she was acquitted on as well, but they had the same problem with informing the court.
And Kurt and Mark, do you think in light of that, and Alan bristled up a bit in terms of some pushback as to that issue, in light of what happened the first time, in light of the fact that she didn't employ 27B to inquire as to whether or not they were hung on all counts, that's a reality. That is something that exists in the world that happened. It's why we're here. Again, it's why they were able to try her on murder 2 again. When we all know, I feel very comfortable in terms of what I've heard from various jurors that all 12 were NG on the murder 2, right? So it's like that double jeopardy thing is a kind of a fucking big deal for me. And, but do you guys feel that Alan bristled up enough on that issue in terms of really trying to, because he made a record, right? And he wanted it on the record. He's like, I'm making a record on this. I hear what you're saying, Judge, but
you have 1 minute.
I'm just sitting here, right? I'm fucking timelines. So, because I know what Allie and I would be doing, in that situation. We would be on the verge of being held in contempt type shit, because in light of what had happened, Did Alan bristle up enough? Do you guys think that he did? I don't know. Like I felt like I would have really been losing my shit in there.
I think he did what he could personally. And I'm glad you brought that up because Bev just gives me the willies. That's my only real worry in this whole thing is she is so unpredictable but consistent in doing things in a venomous nature. The way that she blew Alan Jackson off wasn't just dismissive, it was venomous. And there's something behind that. I don't care what anybody says. In my opinion, there's a motive there that we're not seeing, that we're not aware of, but it's more than I don't like this guy. It's more motive.
The motive is very simple. Okay, I'm in my own fiefdom in Norfolk County. I'm the queen of the castle. Right. And this case was just a regular, interesting murder case. And you, Karen Reed, made it Hollywood. And you literally, from her perspective, brought in Hollywood. And what happened? Here come the lights. Here come the attention. Now everyone's paying attention. And you try to kick me off the case, right? You're holding up poster boards of all these things and whatnot. And she doesn't like it. I mean, I think that's just normal human nature. I don't think it's appropriate, but it's obvious.
The jury comes back
3 years later.
Right, 3 years later, with the jury, comes back and says, I didn't buy it. You're the only one that bought it, Your Honor. I mean, essentially, you'd think she'd kind of, take it down a notch after that.
He has accused him of lying to the court. She's accused him of suppressing evidence over the ARCA stuff. Accused him of being late yesterday, accused him a few weeks ago.
Grave concerns.
How dare you and Bob consult, in the furtherance of a mistrial application. Look, it is what it is. That's just calling balls and strikes. She doesn't like him. It couldn't be any more obvious.
Yeah.
But it's because he brought this case, hooray for Hollywood. And it's now the biggest case in the country.
Yep.
I don't think it's a coincidence that her brother represented Chris Albert in that manslaughter charge. I mean, these things are, to me, I'm not jumping to conclusions because I don't know, but I just don't find these things to be coincidental because there's too many of them.
I don't think it's coincidental. It's just, but that legal community and the politics in general, it's just incestuous. It has been for 100 years.
Yeah.
I mean, around. It always has been.
I keep getting confused with this trial with European royalty, how incestuous it is.
It's really gross. It's really gross. It really makes my skin crawl. Like,
Fire Dancer says, I speak 3 languages: sarcasm. I started this, cuss words or curse, as I would call them, and dog. Love you all this morning. Judge Cannoli equals Lorraine Branco.
Well, the judges are appointed there. I mean, if you want to have them, that's part of the problem. I mean, they're political appointees.
That's scary. Because I mean, where did it work in Illinois?
Pissing off the public right now, though.
Yeah, how far does this go? Is it gubernatorial? You know what I mean? Like, how far does it go?
Like there's going to be no ramifications to Cannoni after this thing. It's like,
absolutely not.
Mark's hearing it constantly whenever he's bouncing around, because everybody, like the lay people are like, well, what can we do about this shit? What's going to happen to Hank Brennan? Nothing's going to happen to Hank Brennan. Nothing's going to happen to Cannoni. Like, just accept
I think something should happen to Hank for putting on false.
There's nothing happening to Hank Brennan. I'll make a gentle person bet.
How many prosecutors are disciplined every year by the bar? Is it like 2?
Right. It's like the only time I've ever seen like the Rust case where what the fuck got on the stand in order to make a record.
Yeah, that was good. That was good.
Yeah, it was unbelievable. My head almost exploded. I couldn't believe what I was watching. It was amazing. And it's just something that you'll never see. And she's like, I'm making a record. They're saying it was a Brady violation. I'm telling you it's bullshit, and I'm protecting myself, but I want to make a record. And it was like, it was amazing. I loved it. And it was like I think Allie and I were at CrimeCon or some shit when that thing was going down. I'm like, oh, great. This amazing thing happens with this prosecutor, actually taking the stand when the judge is like, you sure you want to do that?
Yeah, you're really sure. You don't have to, right?
Right. I mean, I'm not going to stop you, but Yeah, I don't know, man. It's like that concept in Illinois. If a judge has to leave the bench, they then will appoint somebody, but that judge still has to run for election after initially being appointed, kind of in an interim basis. So they like here, you know, but it's like I'm telling people, I'm like, you need to like just not go in and vote on party lines when it comes to prosecuting attorneys and judges. Like, do a little research. And Allie was like, give me pushback. She's like, well, like, what do they do about judges? Like, especially if it's a first-time judge, like somebody who's not been on the bench, who has no.
And I tell them, you know what? Just don't vote then. If you don't know anything about the judges or the prosecutors, you guys stay out of it and let the lawyers in that community who know and the people who actually know something, let their voices be heard. Because vote.
This judge is definitely making me feel better about myself. I mean, I would be a first-time judge because I've never been a judge before, but you know, I feel like I could give it a go. I probably can't do any worse. It should be fine. It'll be fine. It'll be all right. It'll be all right.
The only vulnerable person here is Michael Morrissey. That's it. I mean,
that's it.
And
he's the common denominator for sure.
He's fucked either way.
The only one who's accountable to anyone who can vote. And, you know, you look at someone like Brennan, he doesn't even work in the DA's office. The public literally has nothing they can do.
Right.
He's going to get $1 million of your tax dollars. And when this case is over, he's going to go back to private practice. And the only vulnerability, if that's the word that he has, is, you know, are there some people who may be less inclined to hire him? I don't know.
I'd love to know the story about how they decided to hire Brennan in particular. How did that process go? How did that decision process make? What was the flow chart on that one? Walk me through it.
Yeah, to be a fly on the wall for that conversation when they're saying, okay, well, we're not letting Lally do it again. Yeah. Who's our choice?
They should have done a little America's Got Talent show, you know, have a little panel, people come on, do a little song. It'll be good.
This goes back to what you're talking about 5 minutes ago. You have to understand the Norfolk County and Quincy and area, you know, I know this area well, obviously. The political hackorama, okay? Morrissey has never had a non-public servant job in his life, okay? He has been on the public payroll for probably 30 years.
Government's teat.
In some capacity or another. He was very close to a guy politically named Billy Bulger. You may recognize the last name. Not James Bulger, not Whitey Bulger, his brother, who used to be the head of the Massachusetts House of Representatives. Okay.
Wow.
Yeah. His brother was the, you know, organized crime king of Massachusetts and killing people and informants.
With impunity.
His brother was actually deemed to be in good standing running the state legislature. At the time, Whitey Bulger, if you're from Massachusetts, you know this, was famously on the lam for like however many years. Nobody knew where he was. And of course, brother Billy, I don't know where he was. I've had no contact with my brother in all this time. And, you know, he was, Bulger was not the gangster. The other Bulger was a political ally of Morrissey. The criminal Bulger had Brennan as his lawyer. This is,
you know what that sounds like? It sounds like the synopsis for the Showtime show Brotherhood. It was only on for like 2 or 3 seasons, but it was really good.
Great. It was a great show.
Yeah.
That complicated. And if you want to know how crazy Massachusetts is, so even after the other Bulger, Billy Bulger, was finally kind of shoved aside with all the Whitey Bulger and all the history. And naturally, Massachusetts did what you should do with those kind of allegedly corrupt politicians. They took him out of the legislature, and you know what they did? They installed him as the president of the University of Massachusetts.
Wow.
Making him one of the highest in the state. He may have been the highest paid public employee in the state of Massachusetts for years. I don't know the exact math. This is, you know, many, many years ago, obviously, but this is how incestuous and how gross the politics is. But it would stand to reason that you know, Brennan is a good lawyer. He's a tough guy. He's a pit bull. You see what he's willing to do and how he's willing to confront experts. He's perfect for Morrissey on a case like this.
Yeah. And I think there was that overarching concept of the specter of proctor being called. And you know, you want a guy like that who lives in the world of crossing cops effectively. And if the concept was, all right, we cannot call Proctor in our case in chief, we're going to leave it to the defense to call him, and what's the most effective way that we can try to stop that from happening? And to me, because like when Mark, I saw your tweet and we were in agreement. I like, he was masterful in his cross of barrows, like in terms of what he was able to do with that very damaging testimony in terms of mitigating it was a masterful cross. If you're looking at it completely objectively, which I do on all this shit, I was like, man, he crushed that cross. And in that in and of itself, I was trying to gaslighting our viewers. I'm like, I don't give a fuck what it was. Like,
I know.
But you think Hank Brennan did exactly what he was hired to do.
He was smarmy but effective.
But you don't need to
hired to be a goon.
You don't need to make him. You don't need to make him lead for that. If that's the reason you bring him on, you want him to like rehabilitate the cops because he's just a crossing dirty cops, and he knows how to. He knows how to do it in reverse. You don't need him to be the lead prosecutor for that. You get someone else to be the lead prosecutor, and you bring him on as the specialist who deals with that, who deals with those witnesses, and then also his smarmy effect will be less pronounced, right? Because it will be smaller increments. And so that would be the smarter way to play it. So why he's lead is beyond me.
I don't know if they realized he was quite as smarmy. Like, is he always like that? I've never seen the guy try a case. So it's like,
have you tried a case with him, Mark?
No, no. But the point is, he's coming from private practice. He's not coming in to hold Lally's bag or somebody else's bag. I mean, for whatever reason, he's a well-known attorney in the area.
Right, you're not taking a side chair.
It's always been curious. Why in the hell would you leave lucrative private practice to do this? To take a case like this and frankly, to do it in a way that you do come off entirely smarmy, sleazy. And, he is used to cross-examining cops, FBI agents, scoundrels, cooperating witnesses, dirtbags, rats, all that, and he's good at it. Yep. But when you take that tone with medical doctors, engineers, and you kind of lost the plot a little bit because you
see. I thought toned it down with La Posada though, so you had the Russell and like he was very different
because he knew it. Because he literally used her in the past. I mean,
exactly.
And you could tell right on, she didn't like him. I mean, right out of the gate, she was very snivelly and pissy and sassy and
correcting him on shit, pronunciation.
Somebody has to see because Brennan
in front of your mouth.
The jury has to see because Brennan is like literally like your cliche weasel, dude. Like he sounds smarmy naturally. You know what I mean? He's got that. He's got that
nice background,
nasally voice, and he's got a lisp. And it's, you know what I'm saying? It makes your skin crawl. Like it has to have the same effect on the jury. And he's doing this to family people. You know what I'm saying? Who spent their lives educating themselves to become experts at something, and he's just minimizing them at every turn with that voice, right? So. You know what I'm saying? Like the jury is just put off by this guy from the start.
Yes.
Experienced high-level attorney who, knows how to streamline the case better than the first time and obviously has done this, seen this movie before, would literally die on the hill that the ARCA guys are unworthy of belief because of deleted texts and ham sandwiches. When you saw that.
Don't forget laughing.
That
I would have left.
Who knew Signal was so nefarious? I mean, come on. You guys use Signal? Dun, dun, dun. What?
And the Mark's point.
Like, what is happening? Rentschler was shocked. I felt so bad for him.
Yeah.
It was crazy.
And Mark, to your point, we as like defense attorneys, you don't take everything to trial. You don't want to lose. Where was his, all the other things you talked about as well? Like, all right, this isn't, why am I doing this? Why would I leave a lucrative practice for $250,000, whatever, But I could lose because this case sucks. Like, how was that not part of the analysis or factored into it enough to say, you know what, I'm going to pass? What do you think was really going on then? Why do you think he took it?
I don't know, but it's getting serious because it's getting all kinds of Texas in here now down there. With
When Kurt puts his hat on, shit's getting
damn straight, baby.
The party could pick up this much, and it just did.
Assume he took the case.
Yeah, that's right. I'm the sheriff, and I'm here to bring order to this lawless land.
Yeah, he was a sexy case, right? Lawyers like big cases. On the other hand, you want to have a little judgment. I mean, look, I know, okay, I almost got into this on the good side. You know, that's exciting. That's good what you want to do.
100%.
But the idea of saying, how'd you like to get in this case, but you're going to prosecute it, I would say, are you out of your mind? I mean, this is just, for so many
unwinnable.
Right.
It's wrong. You know, if you care about any sense of your own credibility, which every lawyer should. I mean, I feel like his biggest problem is because he is a skilled lawyer and he has a reputation of whatever. Yes. I wonder how much credibility damage has he done to himself beyond this, because
for sure, because not only did he piss off the other defense attorneys, like for the way that he did it, and someone put in a comment like even asking for trying to get all the lawyers' text messages, but now you've pissed off the white hat people because you put in perjured evidence. You tried to lie to the jury. I mean, now people are like, what
a fucking Weasley little liar, dude.
For sure. Nobody likes this guy, bro. Nobody. Like, that's where we're at. Hank Brennan, nobody likes him.
There's someone out there for everybody.
The worst people.
There's someone out there for everybody. You'll find your person.
Yeah, Kurt's right. There's plenty of folks out there. There's plenty of pro Brennan memes out there. It's like,
but they're posted by the worst people, dude.
Right, and people not looking objective.
They are the worst people, because these are the same people who would say, oh my God, you know, you lawyers have no soul for representing murderous like Karen Reed, or a serial harasser like Aiden Carney, or whatever. And Alan Jackson represented, you know, Kevin Spacey and Harvey Weinstein, and you're just awful. And then you say, first of all, lawyers, we don't judge like that. We don't. But then you say, where does Whitey Bulger fit into that?
Right, exactly.
You know, I'm thinking like murderer is worse than, you know, this or that. But again, they just
and a snitch. Like,
but I don't. By the way, in all fairness, I don't think him representing Whitey Bulger should be part of the criticism. I don't.
It shouldn't. But if that's their mentality, is what you're saying. That's this side's mentality, that they'll attack a lawyer for that. But hello, it's like Hank Brennan. Why'd you use a 50-pound, you know, the 50 percentile dummy? Well, why'd your expert do it?
Yeah, he got caught on that, didn't he?
Yeah, he did. All right, yeah. Kurt, now I haven't had I've asked Mark. I know what Mark's position on this. I'm going to go back into the case itself. In terms of, I was a huge fan of the way that they decided to try this one. You know, obviously they had an opportunity to have ARCA do some more testing. They were able to buff up and bulk up their science in terms of what they were going to be able to produce to the jury. But would you have called the Higgins?
No.
Would you have called, because that's like Mark's. Correct me if I'm wrong. Mark still is of the mindset. I would have.
Here we are again
down there.
I think Proctor is interesting. The problem, as I've sort of come to appreciate, is that Bev would have allowed the most robust cross, you know, of all time. I am quite sure, and Brennan would have, you know, asked all the questions. He would have just testified. I mean, not that cross-examination isn't already that, but more so. And he would just fed him all the answers, and, you know, he would have had the most robust cross, and it would have just been really annoying. So I think they probably made the right call on balance, although it's a tricky call. I don't know. I'm still not sure on that one.
There's no wrong answer, but think of the argument they made where they tied Higgins in the summation, not accusing him of murder, but saying, man, there's a lot of suspicious stuff that this corrupt trooper didn't even look at. Okay, now you put Proctor and Higgins in there, that argument becomes 1,000 times more powerful that you're not even looking at this guy and you're playing that video. And there's nothing Higgins is going to say about that waterfall video that's ever going to sound good. There's nothing he's going to say about, destroying his phone into multiple pieces and separate garbage cans on a military base, getting a lawyer, selecting text messages through his FBI friend, driving cars drunk around the Canton police. There's nothing.
Snow when none's late, and then parking your car right at the end of the driveway.
Let Brennan testify through these guys. There's nothing those guys were ever going to say, I think, that was going to help.
And of course, they're going to object to everything. And Brennan, with respect to the direct, they're not going to be able to get what they want out of Higgins and Proctor because they're going to object to everything.
And going to sit there looking oafish too, looking guilty as hell, but oafish on top of it. So,
I did feel.
Yeah, no. I'm actually agreeing with you, Mark. I mean, in theory, I don't see how Higgins could look good.
That part of what was missing for me was Higgins, and not from a third-party culprit standpoint. You don't even need to go there. Just from a who the hell was in the Sallyport with the car, Kenny, and then he deleted his text messages. Like, just a couple of little things like that would have, I thought, just kind of brought it home. But it sounds like they didn't need it if we're reading the tea leaves right.
Yeah, I don't think they need it. I mean, again, I think they made a fair, reasonable, excellent choice. We're really just splitting hairs. Mm-hmm. But if the thrust of the defense is like, put it on the girl right away in those text messages, Higgins becomes the poster child of just ignoring things that any reasonable investigator would have at least considered. Again, it doesn't mean you have to find him having committed a murder, but just to investigatively have no interest in any of these oddities, I think would look powerful if these two people were forced to testify. But I get totally why they did it. I think it's reasonable that they didn't. I think they handled it well in how they summed up on it. And I don't think the case is going to turn on it by any stretch.
Do you think because they put this, you call it the off-ramp, whatever the hell you want to call it, the OUI standalone, that's why they decided not to put into context, use the completion doctrine to put into context some of the recordings, because they wanted that to be kind of like you're saying, like use the lights? And why do you think they didn't then?
Because I think the recordings were not good. And
but some of them, there was like the one, for example, when he used the clip of her saying, I know I said, did I hit him? And I know I said I hit him, blah, 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 blah. And then later he argued when Russell said that's trauma response. He's like, but a year later? No. Fuck you, Brennan. She was not saying that then and there. She was not still saying that a year later. She was explaining what she might have said had she said it a year.
How are you putting that in context where it outweighs more damage of playing it again?
Yeah.
I mean, to me, I think they did the right thing with the clips. They just kind of shrugged their shoulders, and it is what it is. It doesn't prove anything. It's not a good look. She does not look good. Like a water buffalo on the plane. I mean, that's unfortunate language, but it doesn't prove anything. No. And I think the best example is the note you got yesterday. Is this even evidence? Right. So I think I don't have a problem with them just ignoring it in essence and focusing on the science and no collision. That was fine, I thought.
I have a question for my legal
Nick.
colleagues. So this might be a really stupid question. Disclaimer, by the way.
I'm sure.
But
perfect.
Do you think that maybe do you think that there's a possibility that the defense putting that OUI out there as that option, do you think that could have been possibly a strategy to let the jury know, hey, she's willing to take accountability for something?
They don't know he put it. They don't know who suggested it.
Yeah, that's true.
No, fair enough. But I mean, they're assuming, well, okay, yeah, you're right. So they would know that Karen's defense team.
It just goes back to what 30 minutes ago. Then why not tell them that in summation and lead them to that possibility with the air. Yeah, come over here, and you could still argue.
Yeah, that
guilty of this, but it has nothing to do with a car accident. This has nothing to do with a car accident. And if you find that she was drinking, don't get caught up in the car accident. You can still do this. I mean, I think if they put it there, I think for that reason, but I'm not sure why you wouldn't advertise it. That's all.
And Mark, we talked about
this. No, that makes perfect sense.
Yeah, we talked about this before you got on. But so my issue, so obviously I believe that the defense team wanted it to be either 12:45 or 5 a.m. on the DUI time because they're trying to get a compromised verdict. But technically, I still see and I'll get to Kurt made a great point, but that's you've got a unanimous verdict issue here. You can't have 6 jurors say, I think she was not guilty of a DUI at midnight, but I do think she was at 5. And another 6 say, nope, she was not guilty at 5, but she was at 6. And under the Constitution, legally have a valid unanimous verdict. Obviously, this is a strange case where the defense is like, I'll take them however you can get them. I think one of Kurt made a joke like, if you think she drove drunk yesterday, check it off, you know. But that's
listen, I had a wrongful conviction on a murder case years ago where, you know, it was like, you know, order from column A, B, or C on what theory, and the DA was arguing multiple theories in summation.
Yep.
And we're sitting there saying, how the hell are we even sure that 4 of them didn't convict at the trial, which I was not a part of, on this theory, another 6 on this, and like there's no unanimity in actually what are they deciding. And yeah, I mean, you know, they don't have a clear time. Obviously, the jury doesn't know. The DA did not plead it in the indictment, you know, the time. Obviously, the defense, for whatever reason, didn't, you know, get a bill of particulars and kind of force an answer on that, which I suppose they could have done, although I don't know that that was the biggest thought on their mind back then. They presumed that it would have been related to the time of the murder, so 12:30 or whatever. But, you know, in hindsight, yeah, but I mean, I thought the judge actually gave the right answer on that one. I mean,
well, it's helpful to the defense because they can get a nod.
Totally.
Right.
Yeah.
But Kurt's point was that he thinks Brennan was right. And I think he makes a very strong point. It's a lesser included. So it should follow the time from the manslaughter, technically.
Yep.
It probably should, but I still think, I mean, look, if you want an acquittal here, when she says, I'm not telling you, and I have no freaking idea, and that's for you to decide. I mean, that feels like reasonable doubt all over the place with what they're agreeing.
That's exactly what Will said. Like that answer right there just hones in reasonable doubt because we don't know. You tell us.
Yeah. I mean, I kind of like the answer she gave on that, to tell you the truth.
I thought it was good, but constitutionally, it would have been an issue in almost every other situation.
It's legal error. It's legal error. It has to, because you're adding something. You can't do that with a lesser included. You can't add anything.
Well, if she gets convicted, I mean, she'll have a point of appeal, I suppose.
Yeah.
On that, even if it worked against her. But unclear is unclear. How do we know what the jury was thinking? You know.
All right, which dovetails perfectly into the question of whether or not. So if they do come back with the conviction on the OUI, and I want to hear from everybody, is she gonna? What's the trial tax going to be in light of everything that this case is?
I don't know.
Some jail time. I don't think 2.5, but maybe some.
I don't really. I was gonna say, what is the max if they can
2.5
OUI?
2.5 years.
Does anybody here think Bev would throw that at her?
No, but I think, put it this way: somebody gets convicted of a first offense, DWI, almost anywhere. Again, there's no accident here. Presumably, no one goes to jail. But I'm the way I see this judge handling it is almost like what you see in federal court and those nasty Fatico hearings and acquitted conduct being used as a sentence enhancing her. And I could see her saying, you set a chain of events into play, even though you're acquitted of all this.
But it might have been 5 a.m. and that had nothing to do with it.
You could have called 911. And I'm telling you, I just feel that there's going to be not only just a trial tax in general, but
words of her saying, I'm disregarding the jury's verdict. I'm saying you're guilty.
It's like Bev went full Ratchet, full Nurse Ratchet.
If she does what he just said, that's for sure.
Like, I just hear McMurphy like being like, she likes a rigged game. You know what I mean? Like that fucking nurse, man. She's giving me that full Nurse Ratchet vibe at this point. You know, like who knows why she's doing it, but she is just taking every jab she can at Karen Reed in her defense. It is so bizarre.
If she got 2 years or something like that, if you think that this case is scandalous now, if she gets acquitted of every other crime other than what amounts to a ticky-tack DWI, OUI conviction, and she throws her in the can for 2 years, if you think it's bad now, there'll be pitchforks and lanterns out in front of the courthouse.
Yeah, I mean, if all was right in the world and even the slightest sense, she'd be treated like any other person. And like in the back of my mind, I still hold out hope. The judge will do what she should do, what she'd do for any other person. But my hope is that if she gives her jail time, it's something like, 30, 60 days, day for day. But even that's more than what she deserves. And it's more than anyone else would.
You know what would be a savage move? You know how lawyers like to analogize and use case illustrations and comparatives and whatnot? Chris Albert. Drunk driving, fled, killed someone, convicted, disappeared today, got 6 months.
6 months.
Now, granted, that's a long time ago. And yes, there's a connection with the judge's family, which is all part of the problem with this whole thing Will talked about. But granted that case was from the 1990s and may not fall, So
the judge represented Chris Albert or an Albert?
The judge's brother represented Chris Albert, and he killed in a case where he killed somebody and fled the scene.
And, lawyers talk about like, is this case within the heartland without it? Maybe it's so far afield. Again, I'm going on like federal sentencing and all that stuff. But I mean, you throw that out there as like the high watermark and say, in this case, she wasn't found guilty of killing anyone. She didn't flee. She didn't do this. I mean, that is putting the judge in a tough,
dude,
as well as
the clerk has a DUI, dude. You know what I'm saying? Like, come on.
Well, I'd like to. Go ahead.
Maybe the judge should be better off praying there's no conviction because I'm aware of the clerk thing. I'm not going to talk about that. I don't know what happened with the case. Now's not the time, obviously. But what if these lawyers?
My bad.
No, you're fine.
No. What I'm saying is, if she gets convicted and Brennan's smacking the table for 2 years, a year, whatever, they start making these arguments. Say, let's talk about justice in Norfolk County and who gets what.
Right.
And that argument
prosecution, selective sentencing.
And fair. And if you have a situation where, the lawyers on behalf of Karen are arguing about why did Chris Albert get this preferential treatment? Why did other people in the court system get this preferential treatment? You want to talk about must-see TV scandal. I mean, you start comparing all that stuff. I mean, it gets ugly.
So I was doing some
time served in probation.
Yeah, I was doing some case law research relating to the sentencing issues in terms of what can be factored in and what can't. So the judge in sentencing can use factors in mitigation and factors in aggravation. And those factors can be newly presented evidence that would be presented. The most obvious example of which would be a criminal history related to a different suspect. So obviously for liability purposes, no evidence relating to prior convictions will be presented. At sentencing, they will be, which in the case of that is pretty easy. You just show a certified, certified conviction and, Bob's your uncle and you can use it. Now, what was interesting is that Massachusetts seems to provide more protection than federal law. So one of the questions I wanted to know was if they only checked box 5 on sheet 2 and they acquitted on, counts 1 and 3, could the judge use the death of John O'Keefe as a factor in sentencing? The answer appears to be no. Under federal law, the answer is yes. Under federal law, the answer is yes. So there was a U.S. Supreme Court case called U.S. versus Watts from 2000 or 1997, and this U.S. Supreme Court said that you can use a fact from an acquitted charge as long as the judge finds it by preponderance of the evidence. So as a matter of federal
team cited that case.
Yeah, as a matter of federal law, they could. But under the
federal hearings in federal court, you see this. You get killed with acquitted conduct. It's terrible.
But under state law, the answer appears to be no, because there was a Supreme Court of Massachusetts case called Commonwealth versus McGravy from 2000, in which it appears the answer is no. So
they're not lockstep with the U.S.
Well, yeah, they're providing more protection, which is always valid. States can provide more protection, no problem. So under Massachusetts, it does not appear they can use any acquitted conduct. So she would not be able to use the death of John O'Keefe. So as we're considering what she can do legally, because it's an abuse of discretion standard, it's like she would have to justify any sentence that would be more than the norm based on factors that would be presented. I'm not aware of what those factors are that would be permissible. So I don't know that she can really do much more than is standard. So if I read the guidelines correctly for a first offense, they use this term intermediate sentencing, I think, which is like this probation-like stuff. Yeah, well, I'm trying to do some legal analysis here.
I know. I mean, I get it, and you're right. You're like, and it's super. Like, I'm kind of blown away actually. But as soon as I start to adopt that, I remember Bev's Bev. You know what I mean? And
yeah, well, she
holds my faith, bro.
What the Court of Appeals is supposed to do is do an abuse of discretion analysis, so she can sentence within a swath, but not infinitely. So again, she'd have to justify any departure based on factors that would be presented. I'm not aware of any such factors that could be presented. So you would therefore say legally her sentences would be like these probation-like stuff and not much more. So I'm not sure Bev really can do the more extreme versions based on the case law.
If you weren't drunk, you would have waited and made sure that he was either inside or out. Or if you weren't drunk, you would have went back to see if he was okay. I mean, I don't know, but that's very good to know that she cannot rely on.
And that seems to be true.
The accident,
Yeah, well, first and foremost, that was an excellent fucking answer, Kurt. Thank you.
Yeah, I'm here to help.
Yeah. So, but I think based on what Kurt just educated, I don't think that she can do that. I mean, unless she doesn't give a shit about being overturned on appeal, and I think that raises the question because I'm assuming it's day for day there. I mean, she's going to get good time. If she were to sentence her to 180 days, she's going to do half of that. I mean, you're not even getting an appeal pushed through in that period of time, So it's like the concept of whether or not she's going to take into consideration, all right, I'm probably going to get dinged on this and they're going to kick it back at me. But does she give a shit if the time frame that she's willing to go in terms of a trial tax, is it a calculated risk that she's willing to take? And that's kind of where because Will's the everyman, right? Will's the fucking enraged.
Will's the one holding this verdict up right now.
Are you suggesting Judge Bev might consciously disregard the law?
I mean,
preposterous.
I mean.
Right?
Yeah,
that can't be true, surely.
No,
right.
That's.
But maybe that's why I'm saying maybe she'd find other sort of outrageous ways that take it away from the accident and still somehow say, something like what Mark was saying, well, if you hadn't been drunk, you would have watched to make sure he went in the house correctly, or you would have done something different and he could have been discovered sooner, and that would.
I mean, if she takes that step, she's violated Massachusetts law.
No, I'm saying
only a drunk listens to you too.
No. I'm saying she figures out a way not to rely on the, on the acquitted conduct, right. So not the actual accident, not
aggravating circumstances,
right? Yeah. But coming up with other ones, and
Well, how does her saying, "Well, you should have waited back to watch him go into the home," and in
knowing he's drunk, and
I don't see the aggravation in that.
I know.
Yeah, how's that make the DUI worse? Because she has no duty. She has no duty to watch him go inside. Yeah. So how's that a factor?
Yeah, I don't.
It's a grown ass man. Exactly.
You could use the storm as a.
Oh, the very light dusting of snow enough to track a cat.
Yeah, I guess so.
Which, by the way, was my favorite new statement that I was unaware of.
Yeah, apparently it's a technical determination now. It's okay, all right.
You know what? It's magical though, because it's so on point. That's exactly the amount of snow. Like when he said it, I knew exactly the amount of snow that he was talking about, because obviously if it's too much snow, you're not going to see the tracks. So it was like, yeah, like a quarter of an inch. It's like that's how much you need to track a cat.
Also, there is no cat, so how about dogs?
Bigger paws, Kurt. Bigger paws. Sometimes. So, all right. I mean, what are they doing back there? Like,
that's what I'm wondering. It's almost lunch. I thought they might say something before lunch. Since
you think they just really, really want that free lunch? That's what it is. They just really crave
I was hoping
free
they would
lunchtime.
say something before lunch, knowing, like, I guess that the judge cuts all communication off during that hour, that they'd come out before it.
Does it qualify as a bribe if I say they come to a verdict, any verdict, I will personally buy them lunch so that we can move on with our lives? Is that a bribe?
I'll allow it.
Because we're not getting the notes, you know. So I mean, if they're in an impasse, you know, we haven't gotten the first note relating to that, and I think in my mind, you know, it became clear during the first trial in respect to what was going on back there that you know they were dug into their positions pretty early on. And then they tried to fight their ways out of it, and there was no making any headway. People were just unmovable in their position, and you know, so because what day was it that we got the first note? You guys remember? No. I'm talking not a question. I'm talking about a note. Different things. So I can't remember how many days into the first deliberation.
It was like 20-something hours. It was like 20-something hours, I think. Yeah, my friend Annie texted me, and she's like, so does anybody here, like, I got to ask lawyers this, does anybody here feel like this is already has it gotten to the point where it's taking too long, in your opinion?
Yes.
It's gotten to the point where if I'm the defense, I'm nervous. Because it's like I was talking about it yesterday. You have kind of this role. It's like every trial, you know, if you've tried a case and you're waiting on a jury to come back, you know, it's a roller coaster. You know, if you get a question, you know, you're trying to read through the tea leaves. Like Allie and I, anytime we get a question, we're running back to court. We're like, what is the question? Because you know you can glean information a lot of times from these questions and kind of where they're leaning.
You're getting closer to verdict.
You typically, you know, and like here, like I felt really, really positive about the concept that they had, you know, found her not guilty on the murder too, and more likely than not guilty on the leaving a scene, and you know that left kind of the fucked up slip hanging in the balance. And, you know, but I felt because of the clips, like I said, you know, the one that seemed to work the most in conjunction with their question was that one where Karen's kind of giving a blow by blow of the amount of alcohol that she consumed or had poured into her drink during the course of the night. So I'm like, all right, it seems to me that they're bickering about the OUI. And, you know, but now, how fucking long can they bicker about an OUI? Like,
well, it depends. Is Glazer on our jury?
As long as it takes, dude.
Kurt, what did you say, Kurt?
I said it depends. Is Glazer on our jury?
Right.
Yeah.
Sure, and I would have about how long can they bicker over an OUI may not be whether there's reasonable doubt over the OUI or not. It goes back to the questions they've been asking the judge. What happens if we do this? Are we going to have her sent away on manslaughter time? Are we going to have a whole new trial for manslaughter? And, you know, I was talking about this last night with someone else.
Yeah, that's fair.
I don't even know if the deliberation at this point is involved on what a deliberation should be, fact finding and reasonable doubt, or
I'm trying to figure out the goddamn law.
Right. And we, last answer we got wasn't exactly great. Now, they could ask if they were bothered. That's true. And they haven't, at least since yesterday. But yeah, you'd have to think that there are people who could be dug in over, again, a ticky-tack OUI because they're terrified whether they're guilty or innocent, what it could mean for the bigger picture, a retrial, going to state prison on, much more than a year, something akin with intentionally killing someone. They're worried about those things potentially more than.
Doesn't that warrant another fucking note? Like if you're sitting back there just like, and it's devolved into, we're not even talking about the facts of the case anymore. What we're talking about is trying to understand how the law operates back here and how to answer this slip. Screw her. She didn't answer our question. Somebody back there has to be saying, I'm writing another note. Like I don't care what you all say. We do.
There's no note as far as we know about clarifying the law. And at this point, it's close to 20 hours. There's been no suggestion that these people are ready to pull each other's hair out either.
Yeah.
So they just keep going and we sit and wait. That's what it is.
And the other scarier concept is that they're battling over a manslaughter. It's the longer it goes, and when we kind of take into consideration everything that we just talked about, you have to say, like, if you're the defense attorneys, you're starting that thought is starting to creep in, and it's starting to worry you the longer this thing goes. You can't help but start thinking it just with every minute that passes, and without being another note coming out saying, look, we heard you on whatever you told us yesterday, but here's the deal. Like, your answer to us is what is holding this up, because it just wasn't sufficient.
I mean, you hope you're not having 12 angry men in reverse, basically. Yeah. Until a verdict is final, they're allowed to keep going, and you never know. Momentum can change. Somebody raises a point, somebody agrees with it. Then 3 people say, yeah, we didn't think about that. And the next thing you know, the needle either way could be tilting. So there's no question that after they got the note yesterday, it did sound like that they were tinkering over the OUI. And here you are 24 hours later, and they still haven't finished it. It's natural to wonder, are they now, going back up the chain? Is that a possibility?
Right. That's the thing.
You don't know. Just have no clue.
Because that's the risk in it all. Like, if the debate on the OUI is what's going on, are they going to meander back up into manslaughter just by way of the conversation?
Any juror has any right to raise the question of, let's go back to this. Any juror could say, well, wait a minute, I want to talk about murder. You never know. I don't think that's likely, obviously.
Right.
But, they can do whatever the hell they want in any way they want. And, no one's in there. So we just have no clue.
Yeah, man, it's confounding. It really is. But it's like every lawyer will always tell you, and it's the gospel, you just never know what a jury's going to do. You just don't. Like, we've read it wrong so many times, and in cases that we've tried, we're like, man, we just crushed that case. This is going to be an NG in like 3 hours, and then they come out and convict, and we're like stunned,
And a lot of it too is unfortunate, as you said, like the kind of judicial draw you get. I don't know about you guys, but I am Will knows this, a huge proponent of bench trials in the right circumstances, like a lot. And I have always said that this case, not in the current connotation of judicial assignment. It
worked out well for Aiden just last week.
I wonder if I had a lot to do with that.
Just an observation. It worked well for Aiden last week.
I'm just observing too, Will. I'm not saying anything. The point is, this case on the law is, and on reasonable doubt, it is a ground ball acquittal in front of a judge who is just like not interested in anything else. Now, I don't think anybody would do that in front of this judge for a lot of reasons, but in front of a different judge, the reasonable doubt here is off the charts, right?
I love this exercise. So Kurt, in a world in which Cannoni's not on the bench in this case, you're presented with these facts. You're deep into you've gotten all the discovery. You know what's there. Is there any point where you're thinking on trying this one bench
as the judge?
Forget
no, as a lawyer.
If you're defense, do you contemplate this? If Cannoni's not the judge, if it's say either of the judges that
somebody who's fair.
Right.
Cannoni's not the judge, and it's not in the public eye as much because I feel like that adds that pressure to the judge. But
on a case like this, for a murder case, I don't know. That feels like a lot to do that. I mean, you're trusting your fate to one person who hopefully is objective and fair. And it seems to me, as I've said before, like the biggest problem for the government, there's a lot of ways to get to reasonable doubt, but like for me, the easiest way to get to reasonable doubt is no matter what you think happened that evening, no matter what you think happened in terms of vehicle position, timing, speed, angle of collision, like no matter what you think happened in those sort of factors, for the state to be right, two things have to be true at the same time. The vehicle collision has to have occurred with enough force to create some kind of disabling injury, whether that disabled him outright, killed him outright, rendered him unconscious, otherwise disabled him, whatever. But the collision has to have occurred to create some kind of disabling injury. And simultaneously, that amount of force created no broken bones, no torn ligaments, and no bruising. That has to be true. Both those things have to be true at the same time.
Damage, and that debilitating thing caused all that damage to the car.
Right. Well,
and you have the biomechanical expert. So
yeah. So like that's the problem for me, because you have to believe that is true beyond a reasonable doubt, because it's essential, right? It's I will agree it's possible, but you have to believe it's true to beyond a reasonable doubt. And I just don't know how you can believe it's true beyond a reasonable doubt if you are an objective person. Like you can believe, you could at least, that's the biggest problem for me. And if you can't believe that, there's no point in discussing anything else, right? Because you fail.
That analysis is accurate, but we're even burying the lead. Their own medical examiner would not call it a homicide.
Right.
Okay. In front of a judge, we're at reasonable doubt if you sit and twiddle notes the rest of the trial. I mean,
dude, you can take every fact of this case, put it in a hat, and pick one blindly, and you can find reasonable doubt.
And that was another.
I could do it.
I 100% agree. And that was another gaslighting closing moment. Am I making this up, or did Brennan say that the Emmy did not have all this other information, that she literally testified? Yeah, I heard that. And then he said, and she didn't know about Karen Reed's statements. Yes, I heard that. She said she knew all those things and said she could have changed it. There might have been like one thing that she was like, I'm not sure if I knew about that. But almost all of it, she said, I knew. And then he told the jury she didn't know about any of this.
He said that the investigation continued upon the 90 days up to which the medical examiner could have changed her opinion, and therefore she wasn't informed. That's a great argument to like have in the hypothetical of what do you think happened. The problem is that in a court of law, that's not the issue. The issue is burdens of proof and reasonable doubt.
She testified otherwise, even after the 90 days. She said, I heard those things. And she did say after 90 days, she could have still amended it.
So here's the X factor though, in kind of like playing this exercise out, because I am in the same place that Kurt is in terms of this case for me begins and ends with the injuries or lack thereof that John O'Keefe suffered. Because if you're talking about like your typical judge, the judges that Ali and I argue in front of all the time, and when you're coming in, when you insert the taillight issue and the damage to the taillight and the fact that these pieces were found in the yard, that you have this issue of are you trying to convince this judge who are typically, hey, what's up, Aiden? Are we? You've got
Hey, Bob, how are you?
Good, man. What's the word on the street, dude?
We're just waiting, man. Everybody keeps asking me, is it going to be today? As if I have any insight. I'm like, do you think it's going to be today? I thought it was going to. I don't know. I'd like to hear you guys' insight. I just don't understand. It's pretty obvious to me, based on the jury note, that it appears as if they're only debating the DUI charge, and they don't want to. The third question they asked leads me to believe that they didn't want to accidentally convict Karen Reed.
We all agree.
They said the fifth provision of the second charge, if they're worried that if they put guilty on that they are not putting not guilty on the other stuff. And so they're like, which leads me to believe they're only talking about a DUI. But now it's been 24 hours, so they've had like plenty of time to figure that out. And so I'm like, what are they doing in there? Like, what?
We were literally having that exact conversation right before you jumped on. Like I'm like, because if they're fucked up with the law, if their answer, which it wasn't, was not sufficient for them to understand what to do with that second count, like we've now had hours going on. Like, wouldn't they have sent another note? They're like, look, we heard your first answer. It's insufficient. We need more help from you because we're still hung up on this thing. And like I just think that they would have sent another note out, which gets me worried that maybe the manslaughter thing has re-entered the conversation.
I have an answer for you, Aiden. The answer is Will. The Glare says if he was on that jury, he would not want to be forced to compromise on the OUI, and he would stay dug in. And I'm sure that that's what's happening. There's some people unwilling to vote guilty on the OUI, and Mark made the point earlier. Then you know what? The guilty people need to, or the guilty people, the guilty people just need to say not guilty and just compromise on their end, because
if they don't think she's guilty of manslaughter and want to acquit, and they have any understanding that if they hang on the OUI, that it could lead to the entire count too, including manslaughter, come back, then those people are morally obligated to nullify on the ticky-tack OUI and make sure she is acquitted on the homicide count and publish that, which is exactly what the last jury didn't do, and why Karen was tried twice for murder. You're going to have this happen again for the third time if they don't do that.
But I do think that's your answer, because Will was being very forthcoming, saying, even knowing everything I know, even knowing it might open up manslaughter to a third trial, I'm dug in and you're not convincing me to vote guilty. And
if that's the case, then at some point you have to have a conversation where you say that the defense putting that on the roster is one of the greatest blunders of all time. If that's what's actually happening, if that's what causes a mistrial, and they were intending to acquit on everything else, and because of the DUI they cause a mistrial, that will go down as one of the great blunders of all time.
Go ask them to see if they can withdraw it. Your Honor, we'd like to withdraw it.
What I don't understand is she was never indicted for that. I looked at the indictment yesterday. She was never indicted for that. I didn't know that you could just, it's like a buffet. You can just add charges. Like, why not add littering? Like, she left taillight there, they're saying, right? Get her on littering.
Why not?
It's a little different. A lesser included offense has to have, the elements of the crime except the larger one, and there has to be a reasonable view of the evidence that, again, a judicial determination that a jury could find the lesser offense is a reasonable view of the evidence and acquit on the higher one. And the reality is that the OUI is an element of count two. She has to be operating under the influence. So you can't just add littering. You can't add something that's not indicted. Lesser included offenses can be requested by either party. It was them who requested it.
Maybe they can try to withdraw it now. Go ask them, Aiden.
Not a chance.
I don't know.
There's not a chance. And like,
Aiden, can she plead guilty to it? Can she plead guilty to OUI? Just
if they're willing to.
The prosecution is never.
Oh yeah, Hank would have to accept the plea.
Dismissing all the murder and as a matter of politics, even though they know they may be cooked on all the homicide counts, if they were to go in and say, if you take a misdemeanor plea right now and we'll dismiss all the top counts. This happened in the, if you guys ever heard of the famous New York case, the Central Park, the Preppy murder. Do you know about that where they, during deliberations, you know, the Manhattan DA's office kind of freaked out and took a lesser plea. It was kind of scandalous. But politically, they could never do it in this case because they would be acknowledging that 2 years and millions of dollars, 3 years and millions of dollars of investigative work and lost reputations and damaged careers. We agree that the right outcome here is a misdemeanor DWI because we're too chicken shit to hear the words not guilty on murder. They can't do that politically. Morrissey can't do that.
And there is no motivation for Hank Brennan as he's currently situated to plead her out because where he's at, he understands that if there's not one person on the jury that understands the concept that if they're hung on this OUI, that allows the Commonwealth to come back with this fucking manslaughter charge. If there's not one person on that juror who's in that jury box that's saying, hey man, like this is what's going to happen. If we reach a decision on that, Hank has nothing to lose. Like Ian, his concept, I think, was right. Like at this point, Brennan was playing for a mistrial because he understands on count 2.
He came in just when you said his theory.
Yeah, I mean, it's literally, it plays into his hands because it gives them an opportunity. Oh, speaking of the devil.
Your theory.
It gives him the opportunity or the Commonwealth the potential to try the case again. And murder 2 will be gone, but manslaughter still on the table, which is a nightmare scenario.
Well, and I mean, there's a he's going to make another $1 million off of this. You know they're going to bring him back, right? They have to bring him back.
And they accuse me of grifting? Wow.
Yeah, we've been saying that all morning, Ian, because I thought all of his answers to the jury questions was him begging for a mistrial, begging for a hung jury. And I was like, Ian was right.
But if the motive, I mean, wouldn't the motive for Brennan to give the plea agreement to allow it, wouldn't it be just that he wants the conviction?
No, that's nothing. That's literally garbage. Rip it up and throw it away.
An OUI is a win. Like
goddamn
Reed wins if she gets an OUI.
Huge win. Celebrate the biggest win ever is an OUI in this case for the defense.
We're all going out drinking, baby.
Yeah, and it would be the most expensive OUI conviction in the history of the United States, I imagine.
Probably.
Sure. Yeah. Aiden
And do you think the defense can say, I want to revoke it? I asked for it, and at this point, we want to take it back. Is it even possible?
I don't think the judge would allow it. I don't know if it's like legally allowable, but it would be discretionary even if it is. And
I'd ask for
the
it.
judge would just be like, nah.
I think it would
send it to the jury.
I would say nah. I'm like, you got to eat the consequences of that decision. Yeah, I'd say no. I'd say no.
If the judge wants to have a shred of credibility, hold the jokes and all that, you can't do that. You can't submit a charge, have a screwed up jury come back and forth, give instructions, and then say, you know what, the hell with it. Let's pretend it never happened. And
I know. I just keep hoping.
Yeah, it's not happening, man.
It's scary, Aiden, and we were hoping that you might have heard some rummages or movement over there. It sounds like no. Is lunch now? Is lunch in a half hour? What do you know?
I'm keeping an eye on it. Like, yeah, I mean, I'm just keeping an eye on it. I do know that on the 4th day last year, that's when they first came back and said we're deadlocked. At some point today, they're going to have to come back and say that. Like that has to be. We're not just going to go the whole day with nothing happening. If anything happens, they're going to come back and say we're deadlocked. She's going to tell them to screw, go back, and then we'll do it again on Friday, right? But like this is different than last time because this jury up that appears to be what's happening here. Unless I'm missing.
Wait, we missed your signal sucked. We missed everything you just said.
It's because of all the news trucks too.
Yeah.
Anyway, I don't know if you can hear me now.
We can hear you, but you cut out.
Yeah, you cut out. So re-say what
I'm
you were
sorry.
saying.
I forgot what the question was.
You were
about the mood down here. Yeah. So I think that on the fourth day last year, that is when they came back and they said that they were deadlocked. And then she told them to come back. And then the next day, the fifth day, they came back and they said, we're deadlocked. And she gave them the Tui Rodriguez. So we haven't had that yet. So they don't appear to be deadlocked on the meat and bones of the issue, which is the John wasn't hit by a car. They seem to agree on that. So unless I'm missing something, I don't know what they could be talking about in there.
Well, the OUI count is the only one, and the lesser of anything that does not involve the need for a collision. So that's a logical viewpoint. They added, a different thought process to this whole thing, and the jury appears to be chewing on that repeatedly. And as Bob said earlier, hopefully not chewing on that and then revisiting other things and saying, well, maybe they're and going back up the hill because they can do whatever they want. They can go all over the place. No verdicts are published. They have the right to revisit anything they want.
Yeah, because I mean, in my world, the longer they bicker about this OUI, and the more likely it is it's going to open up the conversation.
Yeah.
In a much broader way.
Well, my signal sucks. So I'm going to see you guys.
All right, man. Keep us up to date. Yeah,
I was just taking a look at Polymarket to see what they're doing. Polymarket, for those of you who are unfamiliar, is a betting site. So people are just betting money. So that's where the numbers come from. Right now, Polymarket is predicting for guilt on some version of manslaughter or murder, 15% chance to convict on one of those counts. And they are currently predicting a 60% chance to be acquitted on all charges, which leaves an implied 25% chance basically for the DUI/hang. So that's where they're sitting.
And so I think last time you gave us the odds on Friday, I think it was around 80% acquittal, right?
Yeah, so it's at 63% now, and as of yesterday, it was at a peak at 80%. That's right. So it is dropped to 61%. It's dropped 20% since yesterday.
How much money is in play? How much money is in there?
For the guilt pool, it is $153,000. For the acquittal pool, it's $68,000.
Wow, man. So, Ian, where are you at? What are you thinking? Let's get thoughts.
I mean, I'm hoping we don't see the worst case scenario of they hang on the OUI, because that would just be like tragic. I don't know. I don't think those questions really suggested a jury that was thinking that she hit him, right? Because those questions really very much to me said they're looking at the OUI and they're fighting over that. And I mean, it could be tragic if we end up with some juror coming out going, I refuse to budge on the OUI. And it's like, well, now she's going back for a manslaughter. And this is a weird trial because normally a hung jury is a win for the defense, right? Normally, the prosecution has to go, well, are we going to run it again? But this one, the prosecution will go, yes, we'll run it again. We'll drop another, $300,000 on Brennan. We'll drop another $500,000 on, well, maybe not Aperture, but there's got to be somebody else in the market. We'll buy another Lexus. We will, all of these things. And
it's going to be the revenge of Paul. He'll be back.
Oh, God. I mean, that's the other thing that'll be really funny on this one is if they do get an acquittal, I would not be surprised if we see Trooper Paul come back and do a little press comment that says, well, you know what? They should have called me. They should have brought me in because,
that would be like Christmas to me, dude.
In retrospect.
Trooper Paul, if you want to defend your position, like, come on. We'll...
Lally, I hung a jury, and by all accounts, at least on count 2, had a majority to convict on something. You put me on the shelf, you humiliate me, make me sit next to this guy, playing with paper clips mostly for 2 months. And if he gets a full-on acquittal, who's your daddy now? That would be right.
Yeah, there was a lot of pouting going on from that middle chair at the prosecutor's table. There's no question about that, man. I would think about that intermittently. I'm like, I'd look at Lally in the back of his head there, and just kind of like he wouldn't even typically watch Hank work. You know what I mean? It's
Right.
like because if you watch defense table, like if Alessi's there, you usually have Dave kind of staring at him lovingly, like watching him operate. And you just weren't seeing that with the prosecution side of it. And that whole situation with having Lally sit at the table was such an odd choice. Like, I really don't know, because presumably McLaughlin was just as capable of handling the couple of witnesses.
Yeah, right.
I didn't
like he would step in a courtroom. Give me a break.
I didn't think it was possible for Lally to look more defeated, and he does. Like
right now, he's thinking I did better than Brennan.
Yeah, man.
He did more ethically than Brennan.
He did this time around. He had more teeth.
Even last time he was more ethical because he brought in all that stuff that was bad for his case.
Facts.
He presented a much fuller story.
Yeah, he did.
We're Lally an ethical pass now.
Comparative to Brennan, that's what I'm going with. Yeah.
Put in an inverted video.
Well, he's certainly. Wait a minute. He's part of the team. He knows more than anyone. So he's certainly imputed in terms of any
He did the right phrase.
Hold on. When we're talking about Lally, well, you think he did the right thing. He elicited testimony from Buchanan at the first trial about the inverted video. You don't think Lally knew and didn't suborn false
That's not what Kurt's saying, though. Kurt's saying that he at least projected the appearance of presenting a case. You know what I mean? Whereas Brennan's entire strategy this entire time has been to try to cut the legs out from Karen Reed's defense.
And at the first trial, does anybody wonder why at the first trial, when Officer Barrows testified as a prosecution witness and testified that there was a crack or something that's not like the condition, that Lally, who was very familiar with the witness, called the witness, prepped the witness, never asked him the money question after, or showed him the photograph and said, does it look like this? And the answer, of course, should have been yes. Why didn't he do that? I would suggest to you the reason he didn't do it is because he knew. And that's why when Barrows learned what a big issue this turned out to be in between trials, threw himself at the defense and was literally punching and thumping his chest saying, I want to be heard, I want to be heard, to clean his own soul and conscience.
Yeah.
Yeah. I mean, no doubt about it, Lally. I mean, anybody prosecuting this case is acting unethically. There is no case. There's no way to do this case, to present this case, to prosecute this case without fabricating evidence, without lying, without creating an appearance, without trying to confuse a jury. There's no way to do it because this is factually a frame job.
Well, Lally was good at confusing the jury. That I give him credit for. To what Kurt was saying, throw it all out there and just put it all out there and, act like the Dunkin' Donuts. It's time to make the donuts guy and slough in and ask a lot of this and a lot of that and put him to sleep. Yeah, I mean, it obviously did something for somebody. I mean, he didn't come off as smarmy. That's true. He presented better. I don't know. I mean, look.
He didn't do better, but he presented better.
I mean, look, Brennan is a better lawyer.
At least the illusion of a case, he at least presented the illusion of having a case. You know what I mean? Like Brennan didn't even try. I can't think of I have limited interactions with Bostonian, but I've had a lot in the last year and a half since I started following this case. And I can't imagine a Bostonian on that jury that isn't like shaking their head at this blue paint stuff. You know what I mean? That isn't going like, does this guy think we're stupid? What's going on here? You know what I mean?
Brennan looked at his reports at the start of this trial and was like, I have got this case sewn up. And then mid-trial, you can see him start to lose his temper as his case starts falling apart. You can see him start to get more and more frustrated as things start to fall apart around him. And he realizes that these witnesses he thought were going to be great are actually not so great. Like Welcher just you know.
But Runkle, he read everything. I read all the reports. I read all the transcripts. There was shit he didn't know and shit he didn't care about. But
I mean this dude testified like this the whole time. You know what I'm saying? Like, that's not a good look. You know?
And if I'm on the jury, I'm sitting there, and one of the things that would just keep, and it's been bothering me, it keeps echoing in my head, is just Welcher looks at everything and he says, I don't want to do a full speed test with a mannequin or with anything because it might destroy this Lexus that we have to resell. And I'm like, so you've got your reconstruction expert who is so sure of all of this. And he's like, there is no way we can do the Commonwealth theory without destroying this Lexus. I won't even test it because we need the Lexus there. And I'm going, their expert thinks that the Commonwealth theory is impossible. And it's so impossible that he doesn't want to test it because it would cost money and, you know, wreck the case. And I'm going,
why can't you just build why can't you just build the client for that? Because if it's a necessary expense, it's a necessary expense. Why not? Why not just build the client?
And this is the thing. If I'm spending this much money on this case and I'm doing it, I'm going, all right, it's going to suck, but wreck the Lexus if that's what it takes, right? And that's because I'm not where the Commonwealth is. Because what I'd be doing is I'd be going, okay, if you run this and the Lexus ends up trashed, I send to the defense, hey, we tried to replicate this and it smashes the Lexus. So obviously we don't have a case here, you know, because look what it did to the Lexus when we try to reconstruct this. The problem is that's not what they're doing. They're not approaching this from a perspective of curiosity that really behooves a prosecution of what actually happened. Let's figure it out and let's try to disprove our own theory. You know, how do we show that? Because that's really how you test a theory. If you're saying Karen Read is guilty, you should be going in there going, the prosecution should be thinking, how would we prove she's innocent? And let's test all of those things and close those doors. But instead, they've done the opposite. It's how would we prove that she's innocent? And then let's not do any of that testing, you know, because that would be inconvenient for us. Let's selectively test and not test based on where we think we can guarantee ourselves a result that'll be helpful. And they've blown that up in a few places. Like they've blown this up in a few places where they've said, you know, we're going to test the piece of glass found on the bumper. I'm sure they thought, well, that'll be great evidence. And it turns out that we end up with one of the singular, most unexplainable pieces of evidence if you're thinking that Karen Read is guilty, because I cannot come to an explanation. And I've challenged several of the, anti-people on Twitter to come up with an explanation. Something plausible for that piece of glass on the bumper.
Oh, I can think of something.
Come up with it either. Stumped Welcher. He was like, wait a minute.
Wait, we're talking about something plausible other than Proctor putting it there.
That's the thing is, once we've eliminated everything else on the bumper glass, we get to Proctor put it there.
Right.
And the thing is once you have a police officer who is messing with the evidence in any sense, everything fails at that point.
100%. Dead in the water. When you have an investigation, in my estimation, when you have an investigation that looks like this, that case is dead in the water. This case should never have been brought. To me, I mean, it leaks back into due process and the lack thereof when you have an investigation this bad. This investigation, and I've seen, and I say it all the time, there is no such thing as a perfect police investigation. There's always warts. We're dealing with human beings. They're always going to fuck something up. But when it's at this level of ineptitude, in terms of the things that were not done,
we don't know what happened.
I just don't know how in good faith that they moved forward on this case at any point. It's just an unbelievable set of circumstances.
Proctor was the lead investigator investigating Brian Walsh, the Anna Walsh murder. You look at his application for a warrant and read that, and you see every T is crossed, every I is dotted as far as what to do in an investigation, how to collect the evidence, what they needed to build a case. He spells it out. So Proctor knows. So the stark contrast between how he conducted the Karen Reed investigation versus the Brian Walsh investigation says nothing other than the fact that Michael Proctor is corrupt and dirty, not negligent, dirty. Period.
I think that's an excellent point. I think that is definitive proof that he knows how to fucking do it.
Right.
So we have evidence of it. And if you guys don't know what the Brian Walsh case, it's the guy who's alleged to have murdered his wife. You know, he had all the insane internet searches about how to dispose of bodies. And, you know, it was just like he's driving around, dropping shit off.
Totally did it.
Yeah, he totally
did it.
He got the right guy on that one.
So Joe Flipperhead says, look at all these YouTube grifters and Twitter lawyers. Thanks for the invite. Stuck at work. If we're still here Friday, don't put it out there in the universe. I'll hop on. Thank you for all the coverage throughout. And Joe, you've been the topic of conversation in our household and your concepts on our lives since you sent Bob that message about how if they're hung on the OUI and no way to say it, we're screwed. And that's what we are stuck with now. It's horrifying.
Yeah, worst case scenario seems to be potentially rearing its ugly head.
And again, it's because of the glare.
Joe Flipperhead. Yeah, it's totally.
Yeah, well, Ian, we had this discussion early on with Will, who's our juror, our prospective juror, our layperson. And, you know, Allie asked him point blank, like, if you're in there, you know, and I think she posed it both ways. Like, initially, you're not aware of the concept that if you're hung on this charge, that means that they can bring this manslaughter charge back and try her a third time. And Will was much of the mindset, look, on principle alone, there's no fucking way I'm finding her guilty on anything. I'm just not going to do it. Like, on principle alone, Allie challenged him and said, okay, well, what happens if you're aware of this concept of what the result
I might cave, like, because I'm not there,
but you were being full.
I'm fighting and I'm trying to get everyone else on my page. Like, it's real easy, not guilty. What's it going to hurt anybody to just let this woman go?
Right.
Like, do you really want to see this woman even? There's a chance that she goes to jail after this sham that we just got subjected to this whole time?
And especially in light of the fact if they're all convinced there was no collision, because then it becomes a much stronger argument. Like, what do you give a shit? Like, the reason we're here is whether or not she hit John. We've all reached the conclusion that she hasn't. Who gives a shit at this point? Like,
it's going to be real hard for me not to call someone an asshole if they're adamant about convicting her.
So we're back to hoping that Mark's, request for nullification comes true. And it's equally as hard to convince other people to nullify, or they read it the way Kirk said, and they find themselves a loophole.
It's nullification, but it's also proper analysis in the sense that if they've acquitted her of manslaughter and are dickering around on a misdemeanor, and there's a possibility that if we don't agree on the misdemeanor, we're going to enable them to retry an acquitted manslaughter, then I think you are morally compelled, if nullification is even the right word, to just say, let's pretend there's no misdemeanor, acquit, because it's a worse harm to have her retried for an acquitted homicide count. Again, they've already done it, and we're going down a path where they're going to retry her for another count for the second time.
Yeah, and Lily Shaw, and I think there's others still out there that are still confused and trying to struggle and understand with how, if they're only hung on the OUI but not guilty on the rest, wouldn't it just be for a new trial on the OUI? So confused. And that's what we've been discussing, is that on count 2, now just ignore count 1 and 3. Let's assume they're going to hopefully get information enough that tells them, hand me out the verdict sheets you're done with. And then
I'm sorry, go ahead, finish. I'm sorry.
Right. And then they're stuck with count 2. If they don't sign something, either not guilty on all or guilty on 5, it's hung on the entire count 2, and manslaughter can come back for 3. Go ahead, Mark.
We are heading down a path where if the jury were to come back and say we have unanimous verdicts on 2 of the counts, 1 and 3, and the judge says, okay, fine, we'll take those and assume it's not guilty. Okay, they're done. We're done with 1 and 3. And they say, but we are hung on count 2, some component. You are going to see a situation where the lawyers are going to go apeshit and say, you have got to ask them, judge, which one have you reached on any of these? And she's going to say, we're not allowed to do that. And we are going to have, and this time they're going to be much more aggressive than they were the first time, because they did get retried essentially for acquitted counts. And she's going to have to tell the jury, you need to go back in there and straighten this out. But the problem is, if you look at the slip, there's no way to do it.
There's right.
Hung jury on count 5 and acquittal on the other ones, the way she did it. This is such a self-created error by the judge who had the benefit of the fiasco from the first trial, had warnings from the defense on the jury slips for this trial, and is doing the exact same thing again. This is insanity.
This went to the Supreme Court. This went to the Supreme Court. This is not this. There's no way this is anything other than deliberate on her part.
Which cannot do anything other than lead me back to the question: is she so fucking dense that she doesn't understand it, or is she just being deliberate about it? I mean, I don't know.
She needs to have the ovaries to go outside of the standard jury instruction. It was like Kurt saying before, all right, she's just saying, I'm following the Massachusetts law by the book. I'm doing it by the book. And as long as I do that, I'm fine. She needs to have the ovaries to say, this is not a typical case. The jury is expressing some, confusion and doubt, and I'm going to do something different.
She needs to have a lobotomy is what she needs.
You just raised a really fascinating point. Everybody knows, there are, pattern jury instructions, and you can just literally, here we are, and does anybody want to add this one? And, they are formulaic. And in most cookie cutter cases, they tend to work. This is not cookie cutter. And you're right. Most intellectual or heavy thinking judges are not afraid of crafting their own instructions, being careful. Certainly on, when you start going outside the box, there can be appellate issues, at least if the defendant's convicted anyway, not the other way. But she's not doing that. I mean, you raise a really good point. She's trying to stay in the pattern instructions. The law says this, and not willing to account for how unique a situation this is, and that I need to first and foremost prevent the possibility of a third trial on acquitted counts, which is on the verge of happening. And she needs to, like you said, have the stones, the ovaries, whatever it is, to do it. And she's just not doing it. And when the defense, even after she gives the slip, says, well, this makes more sense, she still won't do it. And you can't help but go back to why, in the first instance, all of the discussion that she's having about the jury slips occurs after the charge, after the case has been submitted to the jury, instead of before summations, which is when it should have been.
There cannot be a world
down the road
in which she actually wants to sit on this thing a third time. Is it? Can that be possible?
Oh, she wants to sit on this thing as long as it takes to get to a
conviction. You think so?
I agree with Rhodes. Dude, she willfully fought for this second trial, dude. Like, she willfully fought for it. And I mean, and she was adamant about the start date, April 1st, April 1st, April 1st. Every bit of behavior coming from Bev is an indication that she wanted this second trial. For what reason, I have no idea. But everything indicates that she was
trying it out
for the second trial.
Do you think she wants to sit on a third trial?
Yes.
No.
Yeah.
No.
Yeah.
I can't imagine.
I wouldn't. I'd tap out. I'll tell you what.
I don't know why, but I think she does. I couldn't tell you why, but I think
the thing is, if she taps out, does the Commonwealth proceed with a third trial, knowing that they won't have that judge?
Okay,
we saw some of the other judges in the same area that seemed much more reasonable.
Well,
I've got a question. Okay, so God forbid, say the unthinkable happens. When is the election? For when is Morrissey up? When does that happen?
26.
Oh, fuck. It's because, I mean, is there a world that exists where he gets bumped and it's on a trial path? A new guy comes in and the new guy says, I'm dumping this thing.
Even if the election
I hope
a potential third trial, there's a campaign and he's actually being challenged. And the mere fact that you are pursuing a third case is an issue for numerous reasons that involve an elected DA as opposed to an ADA who just goes and tries cases. You manage a budget, you manage an organization, and you have to allocate resources to this. And if you do that with limited dollars, you're not doing that to do this. And there's going to be criticism about, why are you paying Brennan when you have an office that's capable of doing this? Why are you hiring all these experts? Why are we doing this a third time? My tax money. Why aren't you investing it in public safety over here instead of, going after the great white whale like Captain Ahab with, Moby Dick, and you're just trying to harpoon Karen Reed endlessly and you're never going to get her. I mean, I think, electorally, he's going to get hurt. He's just going to get hurt. So there's a lot of variables which may not allow this to happen. I don't think she wants it to happen a third time. I think it's more about, this is my court. This is how I do it. This is how I've always done it. And you know what? I'm from here. You're not. You're in my courtroom. And if you don't like it, tough shit. Right. And she may very well step away if there's a third trial. I would expect the defense to make a motion to toss her off if there's a third trial, whether she grants it or not. But I don't think she wants a third trial. I think she wants to say, I'm in charge.
When there's such an easy out.
I know, but hey, grocery cards point is right. I just checked because we stopped reading the new slip. On count 5, it does say stop. If you find her guilty of this, stop, but it does not say and sign the verdict slip on count 5 of OUI.
Nice.
Wow.
It's missing that stuff, but yeah. I don't know how they keep making little mistakes like this. On to your point, Mark, something that's
because they're doing it on the fly. They're doing it. You heard yesterday where the judge says to the clerk or secretary or somebody, okay, I need someone's computer so we can quickly change it. Do this shit before the summations.
The language she put under 5 is, if you find the defendant guilty of operating a motor vehicle under the influence of liquor, stop, period. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. That's her language.
Each other one says stop and sign the jury slip. But
like, just to be clear to the chat, the overarching theme here, the overarching problem is the fact that if they have no way to indicate to this judge, the way that this is currently situated, this slip, what they are hung on. And if she is of the mindset that she's not going to, and we have to assume that she's not going to ask again in terms of which one you're hung on out of all the different choices, because and therein lies the problem. Because and even if it is enunciated somewhere on this form, does that cure the problem necessarily? Because they're still coming back. Like, they're never going to be able to carve this OUI out independently. You know what I mean? It's like not knowing what it is, because the result is the same either way, even if they know or if they don't know. Because she's not going to do anything if she finds out, oh, well, okay, they're hung on the OUI. I'm gonna dump the rest of the manslaughter charge, and I'm not going to allow. Like, I have no faith that she's going to do the right thing if she were to find out that they were only
no
hung
reason
on alone.
There's no reason to give her any grace and benefit of the doubt that she's going to do the right thing at this point. You know what I'm saying? Like, it's fair and it's reasonable. It's actually naive. I would say that it's naive to not assume that Judge Bev got an agenda. I mean, it's just all of her behavior leading up to this I can't.
See,
I couldn't tell you what the agenda is, but there's one there. I just feels like it.
I just can't get there. I just think it's like you see these judges when you practice and you do it for a long time. You get these judges that have that fiefdom kind of fucking mentality.
That's a lot of judges. That's a lot of judges.
Rules. I don't give a shit what you say. This is the way it goes.
Coordinated effort. There is a coordinated effort to get Karen Reed convicted of something. Now, Occam's razor to the layman would dictate that if you have to go back to one of the defense's motions to dismiss way before, I think even before the first trial, where they're basically saying Michael Morrissey is under federal investigation and he needs this win. So this is the motive. He just wants the win. So a lot of us are thinking that there's this stop to this federal investigation, but if Karen Reed is exonerated, there's all this stuff now on record. There's all of these lies. There's all of this stuff that maybe the feds might have a case after she's acquitted. And maybe this is why they're pushing so hard for a conviction.
See, but here's the thing about the feds. They're in the business of winning. Like if you look at their conviction rate, they're in the 98s. They don't fuck around. It's a completely different beast than state courts and state prosecutors. They because there was that thing, like the concept that the FBI investigation was closed doesn't mean that they didn't find plenty of circumstantial evidence. What it most likely means is they just didn't find enough.
They didn't feel confident for a conviction, right?
Yep. They're not in the business of losing, and that's why I agree. Cases bleed out.
What if after this trial, because we're finding new things out in this trial too, right? We didn't know that the feds questioned Dever, and she said that Higgins was at the Sally Port for a weirdly long time. We didn't know any of that, until she testified. So, what if after this trial there is enough evidence to start handing out indictments? I mean, I'm not saying that there is. I don't know. But I'm just speculating as to what the motive here is for this what seemingly a coordinated effort to get Karen Reed convicted. It's bizarre.
The other question that just sort of runs in my head in terms of a tactical thing is, let's say they come back and they're like, we're acquitting on everything except the OUI. Do you then turn around and appeal the OUI?
Well, we had this discussion in terms of, because we were talking about, Ian, was the concept of a trial tax here and where she would land in terms of potential sentencing, and both Kurt and Kurt thankfully brought up some law and brought up the concept of, in terms of mitigation and aggravation, what she's allowed to bring in under Massachusetts law, and it appears they're not going to be able to get into acquitted charges, that she can't consider that as a factor. And, but I was of the mindset, like, look, the typical appeal is going to take anywhere from 12 to 18 months. That gives her enough room to where Karen's going to do the time anyway. Like, is she going to give a shit about having, her sentence overturned if Karen's done the time anyway? You know what I mean? It's like, I don't know how that would play in her head at all.
Don't forget, she's getting sued for alcohol-related things. And again, I don't know what they think they are going to do or whether there's any merit to it. But, in the event they think that they have a valid 1983 claim against anyone and everyone, I think the answer is they would try to clean up her as much as humanly possible. They would.
Yeah. I mean, I don't know. All right. So some people say that they're in court. I don't know if they're taking the lunch break. That's typically when they come back in. Does anybody
I don't feel like you want to do it just for the civil suits too.
Absolutely.
Because it's like, all of the immunities that kick in if she's convicted of anything.
Yeah.
You want to,
I'm not 100% sure on that. I was talking with another lawyer yesterday. Like, if she's only found guilty on that DUI charge, does that necessarily preclude her from being able to sue for like 1983 violations. I'm not sure it has a completely preclusive effect, so I'm qualifying that. There might be some stuff there. I'm not sure.
Well, it may not be preclusive or not, but I mean, she's a less impressive plaintiff if she was involved in the incident and convicted of being wasted when all this was happening. I mean, I think if she's going to bring 1983 actions, you need to be clean as a whistle.
It helps a lot, yeah.
So Daniels is saying they're taking a lot, like this concept of them like not deliberating while they're cramming a ham sandwich down their throat is bizarre to me.
How good are these lunches? That's what I want to know. How are they being catered? Is it Emerald Lagasse? What are we doing over here?
I mean, I don't know.
If they're not,
a little bit of the fentanyl is going missing from evidence every time they serve lunch.
I happen to know that the defense eats sandwiches just about every day.
Yeah, we're talking about the jurors.
So I don't know what the jurors are doing, but man, like it is absolutely absurd that they can't deliberate over lunch, that they can't eat while they deliberate. That's ridiculous.
Are they actually not allowed to? If even they're all in the room together? I don't know if they would be, but we could.
It's insane. It's insane. Like, I mean, like typically when we get a lunch or a dinner, it's brought into the deliberation room and they chow down in there. And I'm assuming they're still deliberating while they're eating. Like, I mean, people are capable of multitasking at that level.
Can you trade food stuff for verdicts? You know, you rule with me, I give you my chips. Does that work?
Multi-million-dollar deals are made over dinner.
You know? True facts. You know how many cases I've resolved by like, hey, prosecutor, like, let's go and grab a snack after we're both out of court and let's talk through some files. You know, find a place where you can talk where there's, you know, where nobody's going to hear you, or like go to somebody's office and order food in.
Yeah, they did it. They did it in Iron Eagle, dude. Like,
I mean, the thing is
the movie
tend to be more reasonable and more able to discuss things when you're having, you know, I mean,
how did Iron Eagle get into this discussion?
As soon as I said that, I was like, oh, this is going to be a curveball.
I know it's not allowed, but I mean, if it was up to me and I was able to like run things notwithstanding the law or whatever, I'd just be like, all right, every one of you is getting one beer. We're not going to give you 6 because, you know, then we might get into problems, but just one for everybody. And it's not, you know,
just to wet the whistle.
Yeah, it's never going to actually happen, but we might get more productive juror discussions that way.
Yeah, I mean, it's like I think there was a thought process because I was of the mindset. I thought that we were going to get a verdict yesterday after lunch. You know, like we all lawyers like to think that they want that last free lunch because people love free lunch for various reasons. And, you know, as we're slipping here into like mid-afternoon Wednesday or early afternoon Wednesday, man, I don't know, man. I try to keep a positive spin on shit for the chat because people get hysterical and, you know, anxiety ridden and all that shit. But man, it's like it's getting to the point where, you know, I mean, we got some pretty bright minds in here, and it's like it's kind of that thing where it boils down to you just have no idea what a juror, you know, what a jury is going to do. You just don't know.
I have a mood lightener if anybody's interested.
Oh God, yes.
Some breaking news.
Yeah, let's hear
it. John DePepe hit somebody's car at the Registry of Deeds parking lot and smashed their taillight.
Like just
one of my mods just texted. Yeah, supposedly this just happened. One of my mods just texted me and told me.
Oh, I hope they're getting on that to like put a breathalyzer in his mouth and just see where that's at.
I hope he wasn't intoxicated.
I expect tweets from Aiden any minute. I
mean, I could pull up Ian's fight with a anti Karen Reed guy yesterday. Pretty good. I was so close to throwing that, like, you know, I like to use like the llama eating popcorn, but you know, the Michael Jackson eating popcorn meme up there because I was enjoying it. I wasn't gonna pipe in because Ian had it handled pretty well.
Thing is, I like to get into discussions with people who disagree with me in the hopes that they can present me with something that challenges me, because 100%. I'm not of the view that I'm always going to be right. And the problem I run into with like the anti-freak, you know, those
Contingent, yeah.
is that I can never actually get anything out of them. Like sometimes, you know, if I want to go on and say like either, you know, I post something to Twitter that's going to be super controversial, like, you know, take a strong stand on like, you know, abortion or the existence of God or whatever else. And I'm going to get somebody who's going to come in and they're going to have like 3 theology degrees and they're going to be like, well, have you considered this? And I'm going, and then I have to sit and think about it.
Right.
But on this, all I get is people who are just like, well, she's guilty. It's like, why do you think that? Well, you're a grifter. It's like, do you have any ability to actually articulate your point? Because if all you can do is just immediately go to insults, then it kind of suggests that you deep down know your point is garbage. Because if you thought your point was good, you'd want to hit me on, here's all the evidence I've got, let's just destroy you. It's when people start losing an argument that they go to insults.
Totally.
And these people are at, I'm losing the argument from the beginning of the discussion. And I'm just going, where is the person who has a good argument? Where, like,
I mean, look, we've watched the trial 2 times. There is no evidence. That's the entire point. Like there is, like, I mean, when Hank Brennan has to resort to playing movie clips during, like, and that becomes the heart of his case, it tells you everything that you need to know. When he searched high and low for a company that would be able to produce some kind of scientific evidence, and you come up with Blue Man Group,
dude,
that's I mean, it tells you everything you need to know about.
That's all you need to know.
Here's the other thing, though. Let's say they have a new trial and Brennan is the is on for the Commonwealth. Let's say I'm not Aperture or ARCA, but I'm some other organization like that.
You're not taking
I'm going to be extremely reluctant to take it because I will see that Welcher got slaughtered saying there weren't any x-rays, and it makes him look like an idiot in a hugely public
devastating
trial.
way. Yeah, devastating.
Yeah. And so if I'm there, I'm sitting there and they're coming in with, you know, we got $500,000. And I go, well, our brand is worth more than $500,000. So no thanks. We can't trust you to give us the information we need to not look like idiots on this one. So nope, no thank you. You just got 2 experts from Aperture shredded. One of them will probably never work again.
Well, if there's a third trial, I can only hope that we do the comedic rule of 3 thing. So we started with Trooper Paul, and then we elevated to Aperture. So what is the next step up to complete this 3-beat sequence?
I mean, I'm curious to see
12 drinks in.
Yeah, right. I'm curious to see what the ramifications of not just Welcher, but you can't forget Burgess, man. I mean, like the damage that was done to that company through this trial. I'm going to be curious to see what happens with them, because it's like there's just no walking away from that unscathed if you're Aperture, because if you're an attorney that's in the market for an expert, I mean, are you calling them?
I mean, Burgess, I don't think he can ever be called because he can be asked that question over and over. And he still doesn't have a damn degree. But he still doesn't have a degree.
Keep holding on to that dream, baby. Keep holding on.
When you're calling a company like Aperture, I mean, it's their vetting in terms of producing experts for you that you're relying on. Like, that's the entire point of these types of companies. They compile, they get these experts together. You're assuming that the reason that they exist is because they're vetting all these people for you, so that you don't have to do it. Because
they're
I mean,
not just a finder company, though, are they?
No,
I mean, there are
company.
companies that just help you find experts. They actually are the company.
I basically watched
filled with a bunch of consultants.
I basically watched the defense team, Karen Reed's defense team, vet Burgess, like at the table, like right there. That's what it happened. Like, Alan Jackson just reached over with a note to Alessi, and Alessi was like, were you aware that there is no such degree, that Alabama University does not offer such a degree?
Yeah,
like, it happened right there. You know what I'm saying? That's what Karen is doing. She's sitting there on a computer, just searching their social media, searching their LinkedIn, searching everything, and then
when you
boom.
were in the courtroom, you could see all that as it's going on.
I mean, I couldn't see what she was doing. I couldn't see the
screen,
table.
but you see her.
But I could see, you could see them doing stuff, discussing, whispering, and then I saw Alan Jackson hand Alessi a note on a yellow piece of paper while Burgess was on the stand, and then Alessi dropped that bomb, and it was awesome.
I mean, I'm sure that they did this beforehand, but the other thing is I suspect that there was a bit of a surprise on this from Brennan. And part of that is that one of the reasons why you go to a company like Aperture is that you expect that Aperture is going to deliver a product, right? It's the same reason why we have McDonald's around the world. And sometimes when you're traveling, like you hit an airport and you're just like, I'm going to go to the McDonald's because I know it's not going to be good, but it's going to be a McDonald's burger and I'm okay with that. You know, whereas like this
Excellent
other place
analogy.
And so Aperture, what they should be is that if I've got nothing else, I can go to Aperture and they're going to serve me up an expert who is not going to be a disaster, because Aperture, the company, vets its own people. And Aperture has now very publicly had their brand shattered on that, because if I'm going to Aperture now, even if I'm not looking at Burgess, I'm looking at one of the other like dozens and dozens of people, I'm going to be like, how do I know this guy's better vetted than Burgess was?
That's what I'm saying.
And the thing is, I'm sure that
it would be hard
most
not
of
to
the
be honest.
experts on Aperture's roster are beyond reproach. They're probably excellent, you know, scientists and whatever else. But I'm going, I don't know that I'm going to get the McDonald's burger when I go to Aperture anymore. And now I'm hiring somebody that I still have to do the vetting. Because, you know, if I hire an expert and it's just like some psychiatrist who works at a, works at a university and so forth, I still need to go and vet them. Like I need to find their Twitter and be like, did they say something? Because
and
I
then
can
they
tell you
turn out to be a Wonder Bread, pink dough, green pepper burger. That's what they turn out to be.
Eddie Murphy Raw style.
I had an expert I was proposing to call in one trial, and I went and looked through their Twitter. And sure, it was like a year before, but they had said some startlingly racist things.
Wow.
And it was a case where, you know, the race could potentially be an issue. My client's a white guy. He got into a fight with a black guy. And I'm going,
so that's bias.
There's no way in hell I'm hiring this guy as an expert. I don't want to have to do that. Like, you go to Aperture so that you don't have to do that, and now you still do.
And so that you're not dealing with it in real time during the middle of the trial, man.
Oh, absolutely. Like
Brennan had to know some of it because he didn't ask the poignant questions you would always ask. He literally like just
he raced through that qualification of like because normally that's the part where you linger when you call an expert. It's like, so let me let you tell the jury just how amazing you are.
You protect
You've got a
the
degree
president,
in this, right?
You
got a
worked
degree
for
in
the Secret Service.
Yeah.
You've
And
got
how
high
long-
clearance.
How long did you take care of your sick grandmother?
Yeah.
Right.
Yeah, that's right.
Yeah.
All right. So this is getting, I mean, I have to say it's getting scary. If I am the defense,
Yep.
So this is what I wanted to ask you guys. We all seem to be of the, feel strongly that the defense obviously asked Karen Reed about adding the OUI standalone and that she was in agreement.
Yep.
But do we think that conversation included, by the way, the risk of putting this on if they're hung on it revives and puts back into life the possibility that all the charges on count 2 could be brought again?
I mean, that's exactly what they don't want to tell the jury. That's the issue.
No, I'm saying, do you think that they told Karen that was part of the conversation?
Oh, I'm 100% sure they had a full discussion with her. That
for sure.
That team, like
there's
I've
no way.
never seen anything from that team that has given me any reason to doubt them, even when Judge Bev has grave concerns.
Right.
Like what gives her grave concerns about the defense? I'm like, meh. Right. Whereas what gives her no concerns about the Commonwealth sometimes have been like, That was in front of the jury, folks. Like that was a big deal.
That was the biggest of deals.
Karen is running point on that defense team, so she's aware of literally everything that's happening.
Yeah, I don't see a universe in which she wasn't fully advised.
Yeah, I do. And beyond that, I think she was the final arbiter.
But I'm just wondering if she fully understood that the worst case scenario that's about to happen.
Yeah, there's no way. There's no way that they didn't go over that concept with her. And I mean, like even a worst case scenario type situation, I think that probably the conversation would have taken place something in the nature of, look, we're going to try to get her to buff up these slips, especially too. It's our hope, because like when they're going in with that conversation, the slip is what it was going in, and we knew that they weren't happy with it. And we also know that they're acutely aware that she is very reticent to make any kind of changes wherein it makes it seem like she may have fucked up a little bit the first time. And, so they know all this, but, I mean, they had to go through the mental gymnastics thinking like,
I just feel like I would have never thought that was a possibility. I would have never thought they could possibly really get hung on the OUI.
But like this case is that case.
Yeah.
Like there's this part of me deep down that has always believed that this is a case that will be hung in perpetuity, because it's fucking impossible to know what happened to John O'Keefe. And there's always going to be people that just don't believe science for whatever reason. Like there are people.
But I meant hung on a standalone OUI.
I get it. But I'm talking about the bigger picture in terms of exactly what Ian was talking about, the way and the method in which Hank went after the ringing the pathos of it with just trying to get into the emotional side of it, hoping to buy a juror or two in terms of selling them on that emotional aspect of it. I mean, we all know. I mean, like it's always a move for the prosecution. I mean, it's one of the things that they have a huge advantage of over us, and typically, especially in cases where you got a victim that's been injured and or killed, they're going to use that, even though they shouldn't, even though it has nothing to do with what's going on in that room. But they will always try to wring the emotion out of a case in terms of, like victim petting or whatever you want to call it. And, I mean, he did it here. Like it was the first things out of his mouth, and you knew that was what he was going to do. So, it's just like if you look at just the general population, if you just look at Twitter, I mean, I think it mirrors what you're going to get almost every time with the jury. You're going to get like an 80-20 not guilty in terms of if you're able to try the case like this. If you have all the evidence that you need on the science side of it, I think that what we would see in this, if we were able to get information from the jurors, that it had flipped. If it was 8-3, 9-4 the other way because of, during the first trial, that during this trial, it'll have flipped on its head, where you might have one or two people that are hung up on some kind of concept of guilt, and where a vast majority are going to be. But, I just like it, there are just certain cases that exist in this world that I don't think ever can be brought to verdict, and I often wonder if this is that case.
Yeah, I mean, at this point, the Commonwealth should really consider whether or not they really think that they can get to proof beyond a reasonable doubt with any jury, given this case. I mean, do you really think? I mean, how many times do you need to learn this lesson? I guess is a real problem from an ethics perspective, and also how much money you want to bring, and times. But there have been cases where the government has brought the case against somebody multiple times. I'm trying to remember how many times it was in that case Flowers, which was at the Supreme Court a couple of years back, where it was like 7 times or something. The same case from Mississippi or Alabama, I want to say something like that. And then they finally gave up after like the 7th try. But it's like sometimes
6
it gets
trials for the same crime.
Yeah, something like that. Yeah.
And apparently it's the record.
Yeah. So
I mean, like that trial 4, which was the Sean Ellis case, which was a Massachusetts case. I mean, they brought it 4 times, you know, and that was a cop. That was a cop that was killed, you know, and it's like, it's just, but to your point, Kurt, like at some point, just the elected official has to realize that, look, we are like disproportionately allocating so much money to this case that you can't, but like, it's not an unlimited fund situation. They have a budget.
Right.
You have to save money to try other cases. Oh, well, you know, we had to spend another $500,000 on an expert on this. So sorry, we can't really pony up any money of any substance to get, you know, any expert that's worthy in this other trial. And, you know, sorry, family of that victim, we're just going to have to kind of, you know, go through the motions here and we'll do the best that we can. You know, I mean, like at some point that has to be going through somebody's head, right? And if it's not, that's where the voters, that's where the citizens have to come in and say, what the fuck are you doing? Like, what, like enough is enough. We get it. We get it. You think that she killed John. Unfortunately, you can't prove it.
I mean, you have the right to petition the government. It's a First Amendment right. So if you were a citizen of this jurisdiction and you want to politely and respectfully write a letter to the prosecutor and tell them that you think that this is a waste of their time and that this is not a good use of justice. I'm not sure the prosecutor themselves becomes a witness, but whatever, right? Do they still believe in the First Amendment over there? I forgot. No, I forgot they don't really believe in that.
Mark knows exactly. They don't.
Never mind. Strike that. Reverse that.
No. I happen to know of another case where a prosecutor might be called as a witness.
You know what my mistake was there again? My mistake there was actually quoting law. That was my mistake again. I'm so sorry.
Hate to get into pesky details.
That hearing scheduled a year ago about the disqualification motion, which about the prosecutor, we still have to do that.
Yeah.
You're talking about prosecutors testifying at certain cases, but that's for another day.
I think the entire, if they're in Norfolk, that whole prosecutor's office should have been disqualified based on the inverted video alone the first time around, in my opinion. And now with this, all right, you had a special prosecutor and no inverted video, but, you know, false facts presented, x-rays that don't existing, holes in sweatshirts. They need it. It's
I thought that was for sure. I happened to be in the courtroom for that too, when the jury saw the inverted video, and I saw the jury's reaction. And I was for sure. I was like, there's no way that this jury is going to convict Karen Reed. But then lo and behold, you know, turns out 9 of them wanted to convict her, which is with that fact pattern, with all the other problems. So not only did you have all the inherent problems with, you know, the vehicle hitting him and causing the injury or not, as the case may be, but you had all the problems relating to Higgins, Albert, Proctor, Paul. All that testimony was provided in laborious detail. You had much more discussion relating to the flipped videos. You had more discussion relating to ghostly presence on the videos. You had all those things in, and apparently that was distractions or distractors. Distractors. I apologize. Right.
And that was distractors because don't you know, Karen Reed was there. John O'Keefe was there. Therefore, Karen Reed did it. That's how that works, apparently, I guess.
Yeah. I mean, that was always my concern with, and, you know, Lally did that pre-Buttle case where, you know, he tried to get in front of the defense in terms of their third-party culprit and, you know, Bowden shit. But ultimately, at the end of the day, my concern was always like, are you creating a de facto burden on yourself as the defense when you bring forth this conspiracy theory that you have that has some legs? I mean, it's got some smoke all over the place. However, does it have enough to carry the burden that you've created for yourself? And I just found it implausible that you're ever convincing 12 people of it. You know, so that was always my thing. I'm like, just lean into the science completely, you know, but there has to be the element, the proctor has to be there because the taillight ends up in the yard somehow. So you have to have the proctor. And it's like I asked Mark, I think I asked Ian, like, I mean, Kurt, do you think they dirtied Proctor up enough?
No, absolutely not. No, I don't think the reading of the messages with respect to Proctor was particularly effective at all. I mean, I was rewatching Proctor's testimony from the first trial, rewatching the cross yesterday on stream, and just reminding myself like how like laborious and effective it was. Here it was basically like a singular mention, and then it doesn't really resonate. Whereas when it was Proctor on the stand, because he was squirming and all the rest of it, you got to really spend some quality time in message land. So I don't think it was particularly effective. Same problem with Higgins, incidentally. Like, as opposed to him being on the stand, when Higgins was reading the message with, him being squirmy and evasive and being himself, and he was the one reading the messages on the stand, right? That was one thing. In this case, you have Buchanan simply reading the messages, and it just doesn't have the same effect.
Right.
I mean, for my taste, and this is a taste issue, I didn't really like the way they handled Higgins in the closing. So, as long as we're critiquing, I didn't really like that aspect of the closing. You guys might have liked it more. I understand kind of why they have to do it technically, because, you want to give the jury another suspect, because like they shouldn't really care, because again, the standard is, does the state prove it? But like, we got to convict somebody is a real factor. So I understand that, but I didn't really like the way they handled it. And so I thought that aspect was a bit weak. That's sort of what I thought about it.
I thought the way that I took that was I feel like the defense's goal was to basically create boogeymen out of Proctor and Higgins.
Yeah.
Leave a lot to the imagination for the jury, so that they look at them and go, oh man, that's really shady. I don't like that. Look at them. Like, if you don't put a lot of detail to and don't put a lot of context to the video footage of him at the Sallyport or him at the Canton police station, it leaves a lot to the imagination and it looks nefarious. So if you're a juror just looking for something shady, you're going to come up with a lot. You know what I mean? And I feel like that was probably a strategy from the defense to try to achieve that. But that's just me.
I hope we get the murder. Yeah, sorry, go ahead.
To say that's the strategy and clearly what they wanted to do. The question, and I mean, I come out on the other side of this. I got to punch the mouth and drag it out and walk him through nothing he's going to say. Him standing next to the taillight in the inverted video, which in fact is the right rear taillight, and saying, I swear to God, pinky promise, I didn't do it, I didn't touch it, isn't going to convince anyone of anything. Him answering those text messages, like Kurt was saying, it's going to be brutal. And him saying, I'm sorry and I'm a bad person, isn't going to make anybody feel sorry for him. You're a scumbag and you're going to have to answer to this. They didn't even get out the corruption angle, the gift, all of that. You didn't investigate this. You didn't investigate that. There's no
Mark and I are more online because that's the argument in our house with Bob. I don't need it to be super third party, but I need this other shady shit. It even supports planting. The planting. It supports the planting.
I need him to say, I did a fair investigation, which is what he would say.
Mm-hmm.
I had no tunnel vision, but then to tell me factually, when I went down and ordered a tow truck, I had never been to 34 Fairview. I had sent the text that said, don't worry, the homeowner is a Boston cop. I had spoke to Jennifer McCabe, and that's all I had done when I ordered a tow truck to take her car away. I need the jury to hear that from him.
From Proctor? Yep. I don't know. I might have given up on Proctor with the text getting in. The only other piece I would have wanted was buy the gift for my wife. But
here's the problem with Proctor, and it was, to me, in my estimation, the biggest kneecapping of the defense is when she barred Michael Easter from being able to testify, because like the tie-in with the boat.
Got his glasses
I mean,
on
dude.
Yeah.
Kurt's coolness factor goes up as the stream goes. It was like first it was the hat, now it's the shade. So it's.
I was wondering why
it's
the
almost
bottom part of me was. The bottom part of me feels on fire, and I couldn't figure out why, and now I see.
But I mean, like Easter getting bounced, like just kneecap them so much, and you just cannot, like, overlook what Hank would have done with Proctor being able to cross him, which really had to have been the biggest part of that conversation as to whether or not they're going to call Proctor at all. Because I mean, Hank would have done what Hank does, and he would have ran that cross in a way that I think probably, you know, you're never shining that turd completely, right? I mean, Proctor, like a turd is a turd is a turd, and you know, you're not going to be able to clean him up all the way. But Hank would have done some damage in terms of mitigating it, I think, to the point where they clearly thought better of it. You know, I mean, because they're like,
Hank
what other
would've-
reason can you think that they didn't call Proctor when you've been kneecapped by not have, like, because in my world, if you have Easter, fuck Proctor. You know, I don't need Proctor. Like, I'd love if I have Easter, I'm just having Easter on there talking all kinds of shit about all the shit that the guy that they didn't call didn't do.
Brendan,
I
I
would
would
have-
have feeding him answers is the thing, and that's
what I'm saying.
I get the decision. I mean, the thing is Lally on this point was more ethical than, you know, but yeah, I just hate the situation they were put in. They were put in a situation where there isn't really a good answer.
Right.
And they would have had, I agree with kind of both sides on this one. And I would have very much liked to see, you know, I would have very much liked to see more dirt landing on Proctor, or at least, I don't know. I can see the like horror movie villain thing of like, you know, you don't see them, you just see the damage they've done. But at the end of the day, you know, it's better if they've got an actual villain to be like, F this guy. And Proctor really, he's ugly. Like he is, and I don't mean that in like a cosmetic way.
Are you sure?
That in a every detail about him. And to a certain extent, he's one of those witnesses I want to see try to explain things. The problem is he's not going to try to, you know, things like, okay, so this taillight that you testified in a previous thing that you never got near. All right, well, isn't this you there near it? Tell us what you're doing here, right? Like, you know, well, I'm not doing anything. Okay, so you denied that you were near the taillight. You just happened to be at the taillight, not doing anything. You know, and you got fired for this, right?
I mean, you got a lot of the stuff with Higgins. Really, I felt like less got in about Higgins that was important than was missing.
Higgins, I wouldn't call
Proctor.
again, because you're not going to get the very sad. Like Higgins comes off like a sad incel. In
I just want to know. where
He,
you
ma-
parked
he
and
makes
how you
me
got rid of
look
your
suave and like I have game.
I mean, Higgins, but the thing
You
is,
do
if
have
you give him
game,
another
Kurt.
trial, he's not going to get in. He's going to be more guarded. He's not going to get into that thing where he's like, you can see him like actively pining on the stand in the first trial. You can, and it's like the moment in The Simpsons where you could go frame by frame to see Ralph Wiggum's heart break. You know, he does exactly that on the stand as they run him through all of these things, and
He's
they challenge
oafish.
him with, you know, don't you think she was ghosting you? And he's like, snap. You know, like, you can see that happen to him. That's not going to happen a second time.
Not
The
right.
emotional
You're gonna
sucker
get-
punch is gone.
You're
But
gonna,
they don't need it
you're
anymore.
gonna get the Higgins version of Jen 2.0, McCabe 2.0. You know, the
Yeah.
blowout, and like she's just
Still
a
can't change
polished-
that he hit his phone in 3 different pieces on a lot.
Yeah,
I'm with Ali on this. I feel like I would have liked to have seen more emphasis on Higgins in the sense that, like, I mean, let's just talk about the simple in-your-face thing that is that video footage at the waterfall where he is literally the only person that actually showed any motive. Like, there's a lot of motive on Brian Higgins, way more motive that outweighs anything Karen Reed might have had. Like the motive that they're trying to theorize Karen Reed had.
I was like
is-
looking up.
Aw.
Have we seen this dog? Is this you only have one dog?
No, I have 2. One of them doesn't come into my office though. This one.
Oh
Why
my
doesn't the note
God,
let
what
me
a
hold him like that?
lover. Oh my goodness. I'm like over here like watching him walk around getting a occasional butt rub. Oh, what a lover.
5-pound laptop, right?
He's adorable. He's adorable. Yeah, I don't know, man. Like, to me, I just looked at Case, and it's like this concept that Canoni thought that because people watch CSI and all those other fucking shows, they have a concept of what the import of a chain of custody is in evidence collection and why that matters. I mean, you have Hank Brennan talking about a debris field in which I have no idea, as we sit here today, where they found any of that shit in that yard. I mean, am I missing something? Does there exist something that
we're all missing it. The prosecution was missing it. They couldn't even. Brennan shot himself in the foot in his own closing, saying we don't even know when the impact took place. If you can't even point out where it happened, where the crime took place, why are we here? How can you theorize from a template that doesn't exist? Makes no sense.
Yeah, it's crazy. But it's like just the inability to be able to, because, you know, I was somewhat critical of the kind of Bowden, they didn't flex on Bowden because they really couldn't. She limited it to them essentially just establishing on cross that this was a fucked up investigation. And that's what they were left with. And, you know, I mean, they renewed their motion to get him in, and I thought that Hank opened the door. And we talked about this the other day. Ian's like, I think
booted it down.
He kicked it in, you know, but but that was like, because like if this thing comes back in the nightmare type scenario, I mean, these are the conversations we're going to be having, you know, like these are like, if this comes back NGs across the board, well, you know, we're not having these conversations because whatever they did worked. At the end of the day,
right?
You know, it's like it's
All right,
just.
so here's what I need to know: if this somehow gets to 4 Eastern time, and they go home? Are we still of the mindset that they're just still fighting over the OUI? I mean, what the hell is going on?
It depends. Are there any notes which could give guidance?
Right.
Which here we are, 1:30, almost no notes, unless something happened over lunch, which we'll learn about.
10 minutes.
And then you have the other wild card, which is they're off tomorrow. And what does that do in this whole process? A day off of literally just ignoring this. And then they come back for a Friday, and then there could be 2 more days off.
I wouldn't want to come back for Friday.
That's a hell of a lot to imagine is occurring over a misdemeanor after this was a murder trial. And unless they don't understand the consequences, but they haven't asked in over 24 hours. So it's getting bizarre. I'll grant you that. It is getting bizarre.
It's getting bizarre. I mean, that I just expect a note at this point.
Something.
You know, like anything.
Some sign of life.
Yeah. Just
Right.
let us know you're still breathing.
And I think, Mark's got a good point. They're about to be back from lunch, that maybe something happened over the lunch break or just before it, and we're going to hear something. But it's just to not have for this much time to go by, and where we all sort of thought that it was, where things were on this, and for them to not send out the other 2 counts signed off, not guilty, without a question. Like those 2 things combined, I understand you've got I've just making them all the glarers back there that are dug in, but you'd think that all that digging in would prompt at least another question about, all right, now because I think the judge said she was going to put in the letter back to the jurors, this is theoretical, so I can't answer it. Now, if she didn't do that, she did exactly what the fuck Alan Jackson said. You just made them think you can't answer it. Why in the hell would they ever ask it again?
It looked like she was. It looked like she was writing additional things, so it looked like it.
Yeah, I mean, it could just be that simple. That they're still just trying to figure out that verdict form, and there's been changes made to it today. So maybe they're back to square one trying to figure it out. You know what I mean?
I'm convinced you've got the glarers back there. I've got the jurors that are dug in, but what I don't get is how it hasn't prompted another question about
because they're afraid to ask.
Well, and the thing about this case, and I've heard Mark talk about it multiple times, and it's gospel, is that there's no way in hell that these jurors don't know anything about this case. It's different than every other case because this is a case where I am assuming, and I think correctly, that they have a lot of knowledge about this case. So the propensity that there are people in there that came in, dug in, I think is just higher than you're going to get in your normal type of trial. Like, I mean, that has to be taken into consideration as a very distinct possibility that you had people that came in, dug in, and what they saw at trial dug them in even more. And that's where we're at. You know what I mean? It's just like, and like, do any of us think that when these folks go home over the weekends and home every night, that they're not running into that? You would have to put yourself literally in a box. Avoid your TV, your spouse or your significant others watching fucking TV in your house. They're on their phone or their iPad or their computer right next to you. It's like, and you live there, which you're getting geolocated, and they're popping all this Karen Reed shit up all the time. There's no way to avoid it. There is no way to avoid it.
It's all that people in Massachusetts talk about.
Yeah.
For over a year.
Yeah.
Yeah. I mean, that's what I'm saying. Like the more I talk about it, the more convinced I'm like that it's just gonna, like, they're hung. I mean, I've been worried. Like I said, I've been worrying about this thing getting hung again. Anyway,
He just made an interesting point in the chat. I just happened to look over. I don't see it that often, but just reminded me of something I saw earlier. Come Thursday, Thursday they're off, but come Friday, the temperature is, and in New York too, it's going to be I mean, hot, humid, sweltering, and you factor in they're on day 5 or 6 by then. Getting
you literally have you have all the 12 Angry Men elements just building up, man. Does that fan work?
Open the window. Open the window.
Yeah, exactly. The Southern courtroom.
Yeah.
The Southern courtroom look.
Yeah.
Is it true that on the night in question, like, that always happens? There's never an air conditioning in courtroom dramas that take place in the South. It's really weird.
It's true. It's true. I mean, I like you guys have been in there, Mark and Will. I mean, like the talk about the air conditioning and the fan. It seems like cooling is an issue in that building, particularly in that courtroom.
I was perfectly comfortable every single time I was in there. So, I mean, I don't know
the thing
if
is,
it was different or I just got lucky or what.
This actually ends up being a much bigger issue in courtrooms than people ever expect. Like, if I was doing a courtroom TV show, I'd have a day when, like, just nobody could hear anything when the AC is on. Here in Canada, we have courtrooms that alternate between way too hot or way too cold through like, the entire winter months, because either the heater is going bizarre or else or else it's not on, and you see everybody sitting there shivering. And sometimes the heat is set to the judge's preference, which, keep in mind, the judge is probably wearing a suit, and then on top of the suit, they're wearing the robes, and they're cooking. So they're like, well, let's turn the temperature way down. Then you see the witness on the stand going like,
yeah,
can we?
We get that a lot in ours too. I mean, especially in the summer, they'll have it where it's like bone chilling in there, like during, and I'm talking in the summer months when it's in the 90s, they crank the AC. And to your point, I mean, if you're uncomfortable in an environment, I mean, physically uncomfortable because it's either too hot or too cold, I mean, that does affect things. I mean, it's like at this point, you can't discount anything in terms of what's going on back there and how they're feeling. And it's just, have any of you guys ever served on a jury?
No.
We are not allowed to serve on a jury here.
Interesting.
Like literally precluded.
we're allowed to, but for some reason I can't quite figure. No one's ever picked me.
Yeah, me either.
I mean, the thing is I would pick you, and then the prosecution would be like, "Nope, gone."
Yeah, exactly.
For sure.
Person, I'm telling you. I almost got the jury when I was a prosecutor. I couldn't believe that. I'm like, really? Is this really going to happen? But it didn't.
I made the horrific mistake of picking a former prosecutor for Mark. I think I was talking to you about, or Ian, one of the two of you guys. It was like I was using a necessity defense in a DUI case, and it was novel enough to where I felt like I needed a lawyer back there to kind of explain the concept. And
wrong lawyer,
man. She was like done like prosecuting, and I knew her because it was in like one of our main counties. And I'm like, you know what? I'm going to take a fucking flyer on this. I talked to my client. I'm like, look, this woman's a former prosecutor, man. And I'm going to ultimately leave it up to you as to whether or not, like, I'm inclined because of the kind of just unusual use of the necessity defense here. And I explained it to him. I'm like, I think she could help explain it to the jury in a way that maybe we win this case. And he ultimately, and of course she turned out to be the foreperson. And of course she came back guilty, but they did deliberate, I think, like 7 hours on this misdemeanor DUI. So, it was a kind of a...
It took her that long to convince all the other 11 people.
Exactly. Yeah, exactly. Exactly.
At 7 hours on a misdemeanor DWI.
Yeah, exactly. So that was the one and only time I ever even contemplated having, defense attorneys. I'd choose them all day. I'd be like, hey, these are objective people. We have to be objective. That's like literally in the job description. I'm like, prosecutors are very myopic. They really develop tunnel vision on that person that are trying to convict, and to the exclusion of everybody else. So, yeah, I don't know.
I almost got forcibly dragged back to the courthouse for a. It actually took the sheriff's disobeyed a court order to not bring me back to the courthouse because. So when we run out of a jury panel here, like when that's exhausted, what they'll do is they'll just send the sheriffs out to pick people up off the street. And it's like, congratulations, you are now a prospective juror.
Wow.
So
that's crazy.
That is
my boss at the time was running a trial, and it was some obnoxious fraud thing that nobody wants to be a juror on anyway. But they exhausted the potential, the potential pool of potential jurors. And the justice presiding was like, I want you to go out, and I don't want you to accept any excuses, any argument for not being, eligible needs to come to me. And so the sheriffs run into me and they're like, do we grab him? And I'm like, for what? And they're like, yeah, we're out of a jury, but it's your boss now on the defense.
When
so
I pee in the corner, right on the street corner, I just whip it out and pee. That's when I do that.
But I'm precluded because here lawyers cannot serve. And also because I have a blatant and obvious conflict of interest. Like the defense lawyer literally signs my checks. But according to the judge's direction, they should have brought me in for the justice to then say, well, yes. And they're like, we just didn't see you. And I'm like, that works for me.
Wow, that's crazy. That is absolutely nuts.
I've never even heard of anything like that happening.
Well, it doesn't happen often, but you can get kidnapped off the street to be suddenly a juror.
Well, that's why
unnerving.
Yeah,
it is unnerving.
Yeah, the first time I was on with Ian, I'm like the whole concept of hearing how the Canadian system works is fascinating to me because there's a lot of differences, man. There's a lot of differences in terms of because we were getting into kind of suppression issues that that they'll bring up there and kind of just how they handle them, is different than how we handle them down here at the end of the day. like, I just find it fascinating. But you know, I'm a law nerd, so it's like I just find that the differences to be just amazing to me. I think I don't know. I'm really getting worried.
I want a verdict. Come on.
Does anyone know from the interwebs what time lunch actually was, and if it's up? Like, I'm dying to know if something happens like in the next 10 minutes from lunch.
I thought I saw that they were on lunch from 12:30 to 1:30.
Yeah, that's
Should
right.
be any minute they should be back. Also, I think Andrea is about to join us before she goes live on Coburger.
Oh, good. All right, here I gotta take Scout to her hitting lesson, so you're gonna have to play.
All right, make sure she texts Kenna because her friends are like confused. Now she had a hitting lesson the day we were supposed to be doing her party. Luckily, it rained.
Yeah, I was gonna cancel it, and then yeah. So all right, I'll see you guys in a minute.
I'm contacting a source. So they're typing back.
His animal too. All right, because it's getting a little nerve-wracking.
Getting a lot nerve-wracking.
I contacted a source. I'm just waiting for a response, see if there's anything.
What the dog doing?
You made me want to go look for my dog, and then Ian's dog, I don't know, was doing something.
Was that a dog or a moose? That thing sounded like.
I know. Who knows? Who knows? Hey, Ian, was that a dog or a moose?
Apologies. I thought that was I wanted to come say hi, but that was a very much I want to go out right now kind of dog moment.
Mark was wondering if it was a moose.
That's a big one. Sounded like a big one.
He's a big pup. He's a giant dog. It's funny because people see my dogs and they're like, oh, they're small, and then they see them next to me and they're like, what are your monster dogs? we like bigger dogs. It's just the thing. So
all right, the
per my source, there's nothing. They're just sitting around and waiting.
Yep.
There's nothing.
So lunch, it should be up and they should be back. I mean,
send in that post-lunch note, post-lunch clarity.
The post-lunch clarity. I mean, I was actually tried to do a little research. I tried to find one case where the prosecution voluntarily withdrew or dismissed a charge after deliberations started, and I wasn't finding anything. So,
yeah, they say the clock was still running through lunch, so maybe they were still deliberating during lunch.
Does anyone know during lunch?
The clock isn't official. The clock doesn't know.
Yeah, I don't. Yeah, yeah. It kept stopping yesterday. I haven't really invested anything in this law and crime clock that's going and not going and.
Yeah, and Court TV and Law and Crime have different clocks, so.
45. I have to run for a bit.
Thanks for dropping by.
Mark. We love you.
Right.
Bye.
Talk to you later.
Talk to you later. Oh, I hope Andy will let me know if Andrea comes.
DePepe supposedly left a note for the car that he hit on a.
Is that legal there?
Written on a dry cleaning receipt, supposedly.
Yeah, if no one's there, you've got to leave a note. So it was a light tap and it shattered his tail light or the other. What was?
As soon as I can get some blue grease paint, man, I'll be out there and reenact it for you.
Now I just want to know. I want to look up Massachusetts law on, collisions that are unattended, because sometimes, like some places you can leave a note, some places you have to. Contact police and attend and all of those and wait for their attendance. So
it feels like something you would go to a trooper and say, hey,
you're that close.
Because they're all over the place. There's troopers all over the place. So
as long as he left a note with his license plate and his name and his phone number, that I think that's all right. But hey, I'm gonna let Runkle do the research because I don't know shit about Massachusetts. But I know, I tapped a door with my door in a parking lot before, and I just left a note.
Apparently in Massachusetts you could frame a woman for murder. So
not have to leave a note.
No.
Leave a note.
I mean, Oh, Lord. It's scary. It's really scary. I have to think like that the glares initial your like initial feelings that some jurors, the more they are trying to feel cornered by the way they think this looks, like you're making me say guilty when I don't want to because of this, that they're digging in more.
That makes the most sense. Is if we're speculating and using our imaginations as to what's going on in that deliberation room, that tracks the most. I mean, that you just got people who are like, no, we'll sit here as long as it takes until each person is hitting not guilty. And
what do we think?
Where do we write it on the verdict form? Well, draw a square and check it.
You could try that. You could try that.
The question becomes at the end of the day, does that actually ever change the law at the end of the day? And legally, is it still on the table no matter what they say because they didn't reach a decision?
I don't know what would happen legally if the jury actually wrote in like not guilty on each of the sub things and tried to return that. I'm not sure what the answer is at that point.
I would love that. It would be like my birthday.
Bob said that yesterday. He's like just handwrite it in, not guilty. And I was like, maybe if they just lined through them, X.
That would mean the world to me if Bev came back and was just like,
so I've got a note from the jury, and apparently they thought it was okay to just draw a square and check it and write not guilty. Unfortunately, that's not allowed. I'm not going to allow that.
And then they also drew a picture of Mr. Brennan with an extremely small.
Oh my God.
I mean, do you think that there's any discussions in is it district attorneys there, state's attorneys? I forget what it is in Massachusetts. Are they district attorneys, state's attorneys? Anyone know?
ADAs, I think.
Assistant district attorneys. Okay. Yeah. So if the district.
But no, they're special prosecutors in this case and in Turtle Boy's case, because apparently no ADA will take the job.
Well, but they do have some ADAs sitting at the table. So, I mean, do we think the district attorney is like there's discussions going on? I don't know.
So I'm wondering what information DiPietro left on, or DiPedro, or whatever it is left on the thing, because I mean, if he didn't leave enough information, then it could be a hit and run.
Right. So what did he need? His license plate, his phone number, and his name?
It looks like the required information, from what the best I can determine, name, residence address, and vehicle registration number.
All right.
He probably blamed Turtle Boy for it.
Send him a message.
Turtle Boy did it. I thought the little receipt, left it on the car.
It's like,
send him a message, Will, and tell him my lawyers have advised me that you should. Tell him what to do.
He blocked me already. That's not happening.
All right. I don't know who this person is, so
he's an idiot. I mean, he's on court TV almost every night, trying to push this agenda trying to push this narrative that Karen's guilty, defending.
But
Hank
why
Brennan's,
though? That's the thing. But why?
Right.
Sell me.
That's a great question.
And I heard Ian saying that too. Like,
yeah.
Your theological debate.
Yeah, going back to like this discussion from earlier, like that we're all like grifters. I don't know how well these people track us collectively, but we have disagreed about things and at different times, and sometimes we even disagree at the end. We have sometimes we don't always agree about things because we're lawyers, and sometimes yeah. So it's kind of like ask 3 lawyers, get 5 opinions. You know what I mean?
Right.
So. I'm like, if I really thought guilty, I tell you, it's got to be good for the clicks. It's got to be good for some hate watching at a bare minimum, right?
Well, and the other thing is, people don't really understand this, because when you've got every lawyer out there, other than like the Prosecutors podcast, who, so far as I can tell, I don't know what's going on with their, but
I don't think they're a lawyer.
Everyone out there.
If we're talking about the same Twitter account,
no, they are lawyers. The Prosecutors podcast, they are both.
Oh, I'm thinking of somebody else. Yeah, I apologize. Go ahead, Ian. Sorry about that.
Everybody out there has basically come to the conclusion that she should be found not guilty. And the thing is that, like, all right, so it's great to have like a piece of this pie, but wouldn't you be better off having the entire pie of the other side?
Exactly. Right.
Because I'm pretty sure that I could, and like they're like, oh, you're doing it for super chats. It's like, what, you guys don't have money either? Like, you don't think anybody's out there like playing for that? If you were taking the grifter approach would be like, here's how she's getting convicted, she's guilty, like whatever else. And the thing is I started this trial, like I started on the I was disinterested in this until I saw Yanetti's opening on the first trial, and then I went, this is going to be hilarious because it's going to be that they've made a huge promise and they're going to get clowned on this, right? And I said, like, there's no way they deliver on this. It's just impossible to me. And
the defense was acting a fool.
I basically said, like, this is too big of a promise, and I don't see it, right? I don't see that this is going to land. And like week 2, I was sitting there going,
yeah, exactly right.
Why is this not stupid yet? Like, why is this
sounding true?
Like, how is it that they bring in witness after witness and they start off with this witness is going to be the one that, that destroys this. And by the time cross-examination is done, I'm going, nope, the defense is still in the game here. I don't get it. And then by the time the defense's case is done, I'm like, I lean towards the defense, having the correct version of events. And I'm going, at the end of it, at the end of the prosecution's case, you should be sitting there feeling, pretty good. And the thing is as a defense lawyer, most of the time, my arguments are prosecution closes their case. I've done the best I can at poking holes in it. And often I'm not calling any evidence because that's the most common number of witnesses the defense calls is 0. And then I just go, well, isn't it possible this isn't what happened, right? Isn't it possible that this officer who says he saw my client, stealing the bottles of booze from the liquor store, isn't it possible he got the, got the person wrong? He says he saw a guy in a blue jacket, and instead they find my guy in a white t-shirt, shivering in 30 below weather, and they just find a blue jacket like along the running away like path, and you can see the footprints. But isn't it possible like that the footprints cross some other footprints and they might not have the right guy, and my guy just happened to have gone and bought exactly the same kind of liquor in 30 below weather in like a tank top? Like, isn't that possible? And the judge is like, nah. And like the thing is that sometimes the judge, sometimes you've got something better than that, right? Sometimes they find this guy, they conclude he's the guy because they find him in 30 below weather in a tank top, and they say he must have thrown away the jacket. But, if you take away that they found that they had his footprints the whole way, like maybe maybe the chase went through an interior space. Maybe they don't find the booze, or the booze is discarded with the jacket. And it's like, all they've got is that this guy is in the area and in extremely poor weather. And we know that the person who stole the booze ditched their jacket. But this guy could be an entirely different guy who just happened to go outside in crappy weather. And then I'm much more likely to win. They'll say, sure, we think he's probably the guy. We might even think we're really sure this is the guy, right? Like, but that doesn't actually get us to this, is proof beyond a reasonable doubt. That's the defense position usually, right? That is usually
actually a guy with the same jacket but had one arm.
Right, was the one-armed man.
But in your case, there's so much other stuff.
Right. And to circle you back to the whole grifter thing, you get a much larger piece of the smaller pie by being like one of the only like real attorneys screaming, it's so clear it's guilt. It's so clear it's guilt. And I'm going to show you why. And then just saying whatever the hell you want. And joining us now is not only my dog, but the brilliant Andrea Burkhart.
Hey, what's up?
Yay!
How you doing, folks?
Even if the pie was half the size, like half or even a quarter,
I'll be right back.
if you're getting that entire pie, you're doing way better. I don't understand the grifter argument. We're talking about how we're all supposedly grifters, and
Who doesn't want the whole pie? Like, I'm sorry, it's pie, you know, it's in its nature.
I am totally engaged in this John DePepe stuff. Like, people are sending me, like, I see that I have a picture of the note.
I've got a picture of the note right now, and it
Right.
does not look like it meets legal standards.
Ooh.
So it looks like we may have a hit and run scenario in like live.
I'm looking at a video. Somebody videoed him. They're saying that he supposedly tried to walk away until he saw that he was being videoed and then left the note. Like, he was just going to leave it.
But
I'm looking at the video right now.
The note just says, I backed into your taillight. Please contact me. And then he lists his email address. He lists his email address again because it looks like he wrote it very badly the first time. So he maybe thought that it was not clear. And then he puts and then he links his webpage.
Something tells me
he wrote a webpage link on a note
with a lot of emails, a lot of funny emails. Something tells me that might happen.
But apparently the standard, or at least what I'm finding on Massachusetts lawyers' pages, apparently the standard is you have to leave your name, your residential address, and your registration number. And failure to do that is a problem. So that's interesting. The other thing is vehicles right now are built very carefully to save your life if you're in the vehicle. They're not built to survive an accident.
Yeah.
And so they're all full of crumple zones. They're full of all of these things. And you can just get a light tap.
Thanks to Ralph Nader, by the way.
Well, I mean, the thing is it's good that you survive. But my wife got into what looked like a very light tap with a parked vehicle. And the other vehicle was fine because it was a trailer. It's not built to save anyone's life. It's just, it's built to survive. But it looked fine. And, I drove it into the mechanic and I took it in. I was like, so what's it going to cost? And the mechanic had a good look at it. And he's like, you can't drive this home. And I was like, what do you mean? He's like, yeah, you've got like some of these crumple zones have minimally crumpled and it's only like a couple of millimeters, but the car's done. I was like, well, shit. So we actually had to get that towed and we took it to get a second opinion. And the second opinion was scrap it.
Wow.
So I was like, well, shit.
Yeah, I mean, I thought I had what was a fairly minor accident where I ran into one of those bollards, the poles that prevent you from doing that. I swiped one and hit like a quarter panel of my car. And I was like, oh, that doesn't look that bad. And the insurance company wound up paying out like almost $10,000. It was like more than the cost of my car. So I was surprised they didn't total it, but they actually paid it out. Yeah. So it's like weird.
Nice.
Huh. Crazy. I'm going to have a little poetic ending to the Karen Reed trial, guys. Before last year's trial, okay, like a month before last year's trial, I backed into my husband's truck. I broke my taillight. And so it's just been there. I haven't dealt with it. And the main reason is because, it's like if I'm going to have to fix the taillight anyway, you might as well like get cool taillights on the car, right? But then you got to pick them out and you got to figure all that out. And so it just gets pushed.
Did you leave a note
down.
indicating who was responsible?
What's that?
Did you leave a note indicating who was responsible?
I did not, but Jeff knows no matter what, it's definitely his fault.
There you go.
Facts.
His car obviously wasn't supposed to be parked where it was.
Clearly.
But, so yeah, I finally picked out my taillights. I ordered taillights like they're supposed to get here. I get to upgrade my taillights. Very excited about that. It's going to be a nice way to put a little cherry on top.
Like that's hopefully the actual close and not round 3 on count 2.
Oh God.
So Andrea, what do you think if the jurors send out an actual note that says,
yes,
Your Honor, we have found her not guilty on count 2, 1 through 4, and we're hung on 5. What do we do?
Mm-hmm.
Would the Massachusetts law still be like, you're hung on the manslaughter? I don't care what you wrote on that piece of paper.
Oh yeah.
Holy.
Yeah, unless there is a formal verdict that's recorded. Unless there is a formal verdict that's recorded, and they made it very clear you're not allowed to do that. You can't record a formal verdict on the lesser included. You can only do it on indictment by indictment.
Will's that juror back there. I mean, he's given us some wiggle room now, but who said I would stay dug in on not guilty for the OUI?
I wouldn't want to hear it.
I know. It's wild. It's a really crazy situation. But you want a real rabbit hole? I spent some time going down the like, what happens if you get an inconsistent verdict?
Ooh, what is the rule in Massachusetts?
Like lots of people wondering what happens if they go in and like write thing. Like, what if they just write it out themselves, or what if they just like modify the verdict form and get it to say something? And the freaking nightmare scenario that opens up when they do that, because basically now what happens is you've thrown it back into the court to just decide what it means. They get to interpret the verdict form and decide what they think the jury's intention was. So anything you think is a safety valve in this whole process, it's not. It leads more likely than not back to Bev, back to the court, but almost certainly to conviction or retrial, because guys, it's not that way by accident. If you have any question, like how is the law going to apply in any particular given situation, think about what would make it easy to convict people. And that's probably what the law is going to be.
Right.
There you go.
And I think if they sent out the question, like I asked, her answer would be, you must reach a unanimous verdict. Please continue, unless it's after the Allen charge. And then she say, if you can't reach a verdict, a unanimous verdict on one of the 5 options, then you have not reached a verdict.
Mm-hmm.
So that's it. She's not going to tell them it means we can come back for manslaughter. She's never, I don't think she'd ever tell them that. Even
I don't think she's going to tell them anything at all, really. I don't think she's going to tell them anything meaningful.
So there's a theoretical possibility that they send the juror form back with a drawing of Hank Brennan with a very small blue arm, and and she goes, "Well, this clearly indicates guilt on all counts." So
right, because it's up to her discretion to interpret what that means.
Oh, this is the worst.
Are you surprised that we haven't gotten a question at least, or the count 1 and count 3 signed off on?
Not necessarily. I of course have my interpretation of what happened yesterday. Everybody has their interpretation of it. Seems very clear to me. Jury is not giving any serious consideration to a homicide charge. We're dug in on OUI. It's the only thing that they're asking about. It's like the lowest priority, lowest importance thing on this verdict form. So seems pretty likely that more significant stuff is being taken off the table. So the question at this point is just, is anybody, are they going to be willing to throw the trial? Like they know that there are implications of a hung jury. They don't necessarily know what that is, but they know there are implications from not being able to reach a verdict. And so the question is really going to be, are they going to just stick to their guns so significantly over small charge, relatively speaking, OUI, pretty insignificant charge? and potentially risk blowing it up in this nebulous, unspecified, mysterious way that they don't really know what that would be. So I think it's like a game of chicken. It's kind of how I envision it at this point. There's nothing really to gain from more questioning. They didn't really get help from the court. One of the things with jury questions is I think we just sort of we default, I think, assume, we take it at face value that the jury is asking a question because the jury has a sincere lack of understanding about an issue. But I do wonder sometimes if the questions are not necessarily that, but they're almost more of the political process that the jury is engaging in. It's not necessarily I need this information. It's I need something from the judge to be able to batter my opponents with, to get them to come over to my side. And so from that perspective, I think the answers that they got yesterday were extremely unhelpful.
Yeah,
really
willfully unhelpful is what it seems like.
Yeah. They really don't make it clear like how the jury is supposed to proceed at this point. What are they supposed to do to resolve this dilemma that they're in?
Possible, because Kurt threw out the possibility, or I don't know, Kurt said something and then the possibility was, I don't want to misquote you, so I'm just saying it was like something prompted by something Kurt said. Like maybe the jurors were just asking those, maybe they literally were theoretical questions and they were just asking it because they were like starting to talk about, but you guys you do know that if we're hung, they can come back because that's what happened last time. And some of them are like, that doesn't sound right. And they're like, yeah, let's send it out and ask the jury. And maybe that is not what the hell is going on. Is it possible they're actually arguing over substantive charges and not just the OUI?
I'm black-pilled enough to think it's possible. That's
you can't say it's not.
The black pill in me is real at this point. Ronnie destroyed me. I have lost hope.
It's but possible if you want the jury is getting projected into space.
If you want to see something hilarious, there is a clip floating around of John DePetro's show where he says some of the free Karen Reed people are saying I backed into a taillight and cracked it, and it finishes off with there was no collision.
No. Wow.
What?
Dude. Okay.
So you're spreading the rumor. Well,
I listen, dude. All I'm doing is me and Runks here are simply following a development here. That's all we're doing is paying attention to developments in the John DePepe fiasco of taillight smashing.
It's gonna be hilarious if the only person who gets convicted out of this is John DePetro.
I'm gonna lose it.
So I talked about this yesterday and we talked about it a little today. As far as the answer to the question about the 2 times for drinking, I'm like, look, in any other case, in every other case, I could go as far as saying the defense attorneys would be screaming and yelling that you can't do this. You don't have a unanimous verdict. You can't take some people saying she was driving under the influence at midnight and some people saying she was driving at 5, combine them together and get a guilty verdict. But here, the lawyers wanted to give the jurors any way to say convict on the OUI, take it however you want it. I don't care. And then Kurt made an amazing point that technically his point was that that Brennan was right because this is a lesser included, so it should follow the time from the main charge, the manslaughter charge.
No, I agree. I think that's a great point. And we talked about like just one of the odd features of this case is how we're 2.5 years in here now, and there's still things that you never thought of, and it just never even crossed my mind that we would have an argument being made that she's guilty of DUI at 5 a.m. It's got a unanimity problem is part of the issue with it, right? Because if you have some jurors who are like, well, I'm positive she wasn't driving drunk at 12:45, but absolutely was at 5. And then you have, jurors that are like the other way around. You have no idea if they're just like, well, fuck it, she's guilty of something. We'll just evict
people
her.
are being summoned back to court.
Ooh.
Oh boy.
Or I'll stick.
Yeah, Joe.
And after lunch notes and after the lunch verdict, we really enjoyed the lobster rolls, but we're ready to, quit it.
Lobster rolls, very good. Please send Karen home.
Texting Bob headed to court. I don't think he's just dropping off. I think he might have had to stay because it's not that long.
That's going to make it tricky to watch Koberger.
Speaking of which,
I knew this is how this day was going to go. It was going to be chaos.
Speaking of which, since we've been talking about Karen Reed for a while, why don't you catch us up on the latest and greatest in Koberger land?
Oh God, well, Koberger, it's not even a very exciting hearing today. It's just a motion to continue the trial, but it's kind of important because they're supposed to start jury selection on July the 30th, and then the trial itself on August the 11th. So if they're going to continue it, it's like kind of the 11th hour to be making those kinds of decisions. They're having a hearing too on alternative perpetrator, third party stuff, but we don't get to see any of that. We're still in, every probably 4 out of 5 documents that get filed in the case are still coming up sealed. So we don't get to know any of the details yet. That's why the countdown to trial is so significant.
So this is all they still haven't decided if they're going to continue the trial.
Yeah.
And
yeah, the motion just got raised at the end of last month.
Yeah,
I think it was last month. It was in May.
Also, the judge said they had like deadlines to turn over everything. Did all that stuff get turned over? The stuff about
they've done everything. Yeah, they've discovery deadlines, motions in limine have been ruled on, jury instruction, like the questionnaire,
I mean, about the leak thing, that whole leak situation.
Oh, the leak thing. The judge signed orders that directed both sides to have to preserve any communications, relating to the leak. And that's as far as we know, like the scope of what's happened. He said if anybody wants to ask for a special prosecutor to be appointed, I'd consider it.
What?
But there hasn't been an order or anything along those lines that we've seen.
They're trying to kick Santa off the case.
What's that?
They're trying to kick Santa off the case.
To get him off the case.
Okay, what? I couldn't hear. Sorry.
I was saying they're trying to kick Santa off the case.
And I was asking, was it just to read through the stuff, like a special prosecutor to act as the taint team or something?
Yeah, no, they're going to have, they want a special prosecutor to come in and investigate. There was a leak to Dateline. Dateline did a big special, I don't know, a month and a half, maybe 2 months ago now, and had information that allegedly came from Brian Koberger's phone, information about like his web searches and things like that. So caught the court's attention. Somebody would have had to violate the gag order, for Dateline to have this information. So he's invited a special prosecutor, invited them to ask for an appointment of a special prosecutor to investigate violating the gag order.
I wonder who it could have been.
Yeah, who could it possibly have been, right? It's $1 million mystery. And then here's the fun thing, like in the meantime. So Idaho has been one of the few places in the country that doesn't have a reporter shield law. So if you happen to be like, I don't know, a Dateline producer or somebody and you're in Boise, you can be compelled. You can be put on the stand. You can be compelled to give up your source. And, you can be jailed for contempt if you don't. However, Idaho just passed a law adopting a reporter shield over in the last session. It comes into effect on July the 1st. Nice. So count down, guys. Count down.
Wow. So some reporter is just going to be
actually feasibly find out who the source was. If
would that apply retroactively? Shouldn't that not apply retroactively? Shouldn't that be for anything?
At the time that a subpoena is issued, I would think.
Oh, yeah.
So move on it or give it up.
Would it be issued or does it have to be served at the right time?
Ooh.
I might say, you know what? Now is the time to take one of those vacations. They have vacations that put you on an island with no contact. And I'd just be like, I'm going to take 3 weeks on this island. Good luck with process serving.
I feel like your neighborhood people could hide in. Are you like way out is that just in my head that you're out in the middle of nowhere?
No. I mean, somebody who I won't name yet managed to not serve me properly, but have somebody drop something on my porch. So I'm not that hard to serve.
Findable.
But
You're fine.
I mean, maybe one day I'll move off to the woods and just if I ever achieve my goal of being the pro bono lawyer, my follow-up for what I'd love to do with that is move to a property on the woods and come out wearing like a suit that I've intentionally grown moss on and just show up as this figure nobody sees other than
do we want to share the feed of OnlyFans, seeing as we're waiting for them to come back?
I've got it up there. It's little for
I
now.
hate to just be such a quick hit and run, but I am gonna have to dip because I'm like ready to get started in Coburger. But they're going to court. I don't know what's gonna happen, but I'm gonna start my stream and we'll kind of play.
Oh, never mind. It's just the crowd outside. There's the crowd outside.
You're gonna talk. You're gonna talk about Coburger.
My source just told me.
I know. I'm actually going to talk about Coburger today.
Yeah.
Could be a verdict, people. Could be a verdict.
It's 209. It's 209 on the East Coast. Let's do that 227, baby.
Almost 227.
227 verdict, baby.
227 verdict.
227 not guilty verdict.
Thanks for coming.
Thanks for letting me jump in. I'll play it by ear. Maybe I'll pop back in, guys. We'll see.
It was really nice to meet you, Andrea.
Mess of a day. Yeah, you too. Take care.
Nice seeing you. Thanks for swinging by. So I meant to highlight the one that said 227 and I hit the wrong E. It could be a note. I'm trying to find.
We have some 227 merch ready to go just in case.
Dude, it is packed out there. It is a sea of pink shirts in front of the Registry of Deeds right now.
So what are you watching?
I've never seen that many people. Law and Crime.
Okay.
It is wild. Like I've never seen that many people out there.
All right. Let's see.
Lots of pink, not a lot of blue. I see. I don't think I see any.
Yeah, dude, I'm just to the point where I feel perfectly comfortable saying that it's just beyond stupidity if you are saying that Karen Reed is guilty. You're a bad
I feel pretty comfortable at this point.
There's something wrong with you.
Every time
Mandy, how do I fix this back to there? We go. No, that's close enough. I'll make it bigger.
You don't want their stream though, because then they'll strike you.
No, they don't do that as much anymore.
Yeah, no, Law and Crime hasn't given. They struck me about 3 years ago or 4 years ago.
I got a ding from Associated Press UK saying that covering the closing arguments was their footage, and I'm like, MFs, no, it isn't.
Wow.
So I've got that dispute running, and I'm waiting for them to actually properly respond and be like, nah.
Yeah, I mean that's
a lot of pink. I was gonna say I think I see blue, but I think that's actually a uniformed officer. He's like, I'm only wearing blue because I've got to today.
Right.
So pink. Where I thought they weren't allowed. So they're allowed to wear pink in the buffer zone.
Yeah, no signs, I think, and because
I see a sign though.
I do too. Maybe it doesn't say anything about Karen.
Yeah,
or maybe the cops are just like whatever.
At this point, we don't care anymore.
Right.
Maybe it's the juror arguing for a split verdict, or somebody arguing for a split verdict with a sign saying 2 in the pink, 1.
Oh.
Runks is on one today, man.
Well, I have to say, and I've got OnlyFan watching too, guys. As soon as OnlyFan moves, I'll take us off the sea of pink. But I feel pretty confident. I don't know. I was going to say that it could be a verdict. All right. So if it's a verdict, I feel pretty confident that it might be. Well, I guess I can't freaking say. I mean, I'm only worried about the OUI. I was just going to say that it's not guilty, but then I was like, no, maybe it's guilty. I don't know what you guys think.
Maybe it's guilty on the top count across the board, and we'll all be really sad.
No, not happening. Don't scare the people.
I am just hoping that at the end of the day, DePetro gets more jail time than Reed. That would be the like absolute cherry on everything.
I am 100% concurring with you, Runks, on that. Absolutely.
People are still saying that John DePetro ran. Oh, I remember who that guy is. That's that guy that Aiden was fighting with outside one day.
Yes.
Yeah.
I put right over Runkle's face.
It's okay. I'm used to it.
The reporter? Or someone else?
I guess.
All right.
I mean, he says he's a reporter, but he keeps like getting into fights with Aiden and so forth. It's yeah.
It's so funny. It's so funny. Just like Aiden just trolls him.
Well, and then NBC reports, Turtle Boy gets into confrontation, and you see the confrontation.
That was some
Turtle Boy
bullshit.
sitting there doing a live stream, and DePedro is like yelling at him, and like and Turtle Boy's just sitting there like
doing absolutely nothing.
I'm telling you, like the spin-off shows coming from Karen Reed are hilarious. So much fun. These characters, they're like fictional characters, but they're real. It's the most wildest thing. Look at Grant Smith Ellis. Can't believe it's a real guy.
I'd rather not.
I can't believe that's a real guy. Like I can't. It's so funny to me, and they all.
That's Wendy Murphy's kid, right?
Yeah, yeah.
He is exactly what you'd expect somebody who's spent their entire life being educated on law from Wendy Murphy to be.
Thing. I said the same thing. Like he is like as soon as I listened to Wendy Murphy on Court TV talking to Julie Grant, I was like, oh, that just explains Grant. I'm like, this guy gets a pass with me now. Like this is a perfect explanation.
So is there a counter color? Do the anti-Free Karen Reed people wear blue, or is that a different one?
Yeah.
Well, they do.
Yeah.
I haven't seen any.
There aren't any.
I saw a green shirt, but I mean, I haven't seen any blue. Is it possible that they like gave up when the jury questions came in, or they're like, you know what? It kind of doesn't seem like the car hit John O'Keefe. All right, so here comes I'll share this tab. Here comes Karen's mom. Here comes Karen.
20 hours. It's been 20 hours.
Well, here they come.
I really like that color that she has.
Yeah.
What color would you say that is? Like lilac?
Baby blue.
Baby,
I don't know.
yeah,
I'm the last one. I'm the last one to ask. I shouldn't even be talking.
Microdots is in chat and he's saying that this has to be it. Microdots is feeling anxious and predicting it's the verdict.
Ooh, a little bit of anxiety.
Oh, Alan Jackson gave the
I love you. Yeah.
I think that's what it looked like. Yep.
Yeah, he was asking people to stay
that was
quiet.
Nettie, though.
I mean, this could be a verdict. So what we should stick up a poll, except I don't know how to do it. Somebody stick up a poll if we can do it. That would be either not guilty OUI, guilty OUI, or not a verdict, but a question or a note.
I don't know how to do a poll on your channel, so
I'm telling Mandy in the background that so they know. So because I think they know how to do it, except Mandy's not there. All right. Well, I'll just read out what you guys are all saying. What do you guys think? Not guilty on OUI, guilty on OUI, or not even a verdict?
I'm gonna say they're stuck on the verdict form. That's where I'm going. I think it's just a question. I don't think it's a verdict yet. I think the fact that there hasn't been any questions since yesterday just tells me that there's a question. Before it's just a guess. You guys would know better than I would.
I mean, we'd all know about the same, I think. And
I know what I hope, but
yeah.
Right. I hope it's a verdict, obviously. If it's a verdict, then what is your guess? Guilty on OUI, not guilty on OUI?
My guess is guilty OUI, not guilty everything else, but that's my guess.
That's my best guess.
Yeah, me too.
My guess is hung on the OUI and not guilty.
Don't say that. That's not a verdict. That is called not a verdict.
I'm just saying this has been my position since yesterday morning. And I have no reason to believe otherwise at this point. You know, it's just where I'm feeling it. I hope I'm wrong. You know, like I hope it's not guilty all the way down.
I hope it's a clean sweep for defense. That would be
yeah.
And that would be just so delightful to watch. I want to see Brennan come out of the courtroom, and I want to see his interview. I want to see Lally. And if Lally's interview, he should just be like, give him like a little shrug and a smirk. And
there. I'm not with that guy, Arrow.
Dude, Lally in person is one of the most unimpressive people I've ever seen, dude. Like, he's just not. Yeah, when I see him, I almost feel sorry for him. He's just slumped, not confident, just defeated. Doesn't look like he wants to be there. You could just feel it when you're around him.
Turtle Boy on Twitter said the Reed team was told to come back by the clerk. When the jury has a question, they're told this. They were not told there was a jury question. That's what Turtle Boy says for whatever value it has.
Okay.
I mean, typically we're told there's a verdict, there's a question, one or the other. But if they have been told each time jury's got a question, and this time they were just told to come back, that might be a verdict.
Either that or we've decided to mess with the jury because we haven't done that in this trial yet. We want to kick someone off the jury because, you know, they're too pro Karen Reed. We haven't done that yet.
All right.
We're going to eliminate people who are pro acquittal until we get the verdict we want.
I am actually gonna jump off because there's somebody else's channel that wants me on over
Go
there.
For it. Go for it. We're glad that we've had
you've got a cooler place.
Right?
I wouldn't call it cooler, but I mean she's my homie, and we've been kind of collabing. Yeah. So and it feels like the right place to go. You know what I mean?
Fair.
All right,
man.
I'm
was
just giving you grief,
amazing.
man.
I feel unworthy having been on this panel. You guys are brilliant and amazing, and this is probably easily one of my favorite panels I've ever been on. So thank you guys for having me.
Well, thanks
Seriously.
so much for coming. We appreciate it.
And I'll be in touch for future stuff with all you guys, actually.
Awesome.
If you guys are cool with that. But
go ahead, Will. Go hop on. Thank you.
All right.
Bye.
Love you guys.
Love you. Wow, I can't believe Bob's not here. Like, I just cannot believe that Bob's not here. He's like, he can get in on his cell phone from like, if he's just like sitting. Oh, I thought I heard noise, but.
You heard a dog. I should let the dogs in again because
there's a verdict likely,
around.
Possibly. What are you doing?
But they should be in if there's a verdict. So I'll be right back.
Apparently the news is reporting they believe there's a verdict. So that seems to be the scuttlebutt, as the Little Mermaid would say.
The question just becomes, did the not guilties on the, I'm just focusing on the OUIs. Did the guilties give way, or did the not guilties give way? Like, who gave in? And it might be 227. It's crazy.
Yeah. That'd be pretty.
This somehow ends up to be 227. I don't even know what I would be thinking.
Yeah, no. Well, yeah, I have a shirt ready to go on the chance that it was a verdict announced at 227. I have the merch ready.
$1 on that, on this whole betting thing? Is that a thing you could have picked the time?
I don't know, man. On the profit on that one, I don't know.
You could have won $1 million, $1 billion, picking the exact minute that a verdict comes in. Oh my goodness. This is crazy. Everybody's thinking it's a verdict. You got the use of different verbiage this time by the clerk. Somebody just put something in the chat that according to Sue O'Connell, a court officer walked by me with a medium-sized envelope with the back fastened closed. All right, people. Wait.
Yeah, that doesn't make sense. Because usually
question.
Yeah, usually the jury hands the verdict to the bailiff in open court when there's a verdict.
Right.
It wouldn't be the verdict, presumably.
Right, now almost seeming like it could be a, yeah, but they didn't, do they usually they might put them in envelopes? Yeah.
Yeah, there's usually an envelope for the verdict form.
All right. Well,
but it almost certainly wouldn't be in the position of a court officer.
The verdict wouldn't, right?
No.
Right. That would be a question. Or the bailiff. She might be just calling the court officer, oh, Lord.
We're literally trying to tea leaf read what is in the envelope at this point. This is great.
This is great. 2:27, for those of you that don't know, is the time of the
here we go. Something's happening. Let's do this thing. Is the volume on?
Yeah, let me make sure.
Yep. See, I'm glad I double checked.
Thank God.
All right. I appreciate you all getting back here. During the luncheon break, I received word from a court officer that the jury had knocked on the door, indicating that they had a verdict.
Holy shit.
Before I could even summons everybody into court, shortly thereafter, they knocked again and said they didn't have a verdict.
Oh, my
So,
God.
I asked the court officer to tell them to put that verdict slip in an envelope and seal it. And to give it to us. Paul, do you have it?
Wait, so they do have one verdict?
I don't know.
I haven't seen this. It's been sealed. I'm now going to seal it in the legal sense. So this is sealed. No one will have access to it. It will be preserved and made part of this record. I'm going to ask it to be marked for identification with the word jury, Chrissy, just to keep it separate and apart from everything else. So it's marked for ID with the word jury.
No, they need to ask. They need to find out, do they have a verdict on any counts? No. They've got, I feel like they have a fucking verdict on something. Oh my God. The 220 feeling of the first verdict.
So we do not have a verdict because, as we all know, there is no verdict until it is announced.
We are all painfully aware.
So we are still awaiting a verdict. Because it took a while to pull this together, I would ask that everybody remain in the building until the end of the day. So
Wow.
I'll see everybody later.
Wow.
Wait, what the fuck is happening?
They
had a verdict and then they didn't have a verdict. And the first verdict that is not a verdict has been placed into a sealed envelope
and
is
filed
sealed.
under seal.
Yeah.
What does that mean?
All right, everybody. We'll just explain it to everyone again. So the jurors alerted the court staff they had a verdict. The jurors then alerted the court staff they did not have a verdict. The judge asked for whatever sheet that they used to come to a verdict and then change their mind on a verdict and put it under seal in a file that is also sealed, closed. And no one's looked at it. No one will look at it. It will be a part of the record should anyone need to look at it later.
Yeah. So my question is, the jury, when they're back there, they only have one copy of the verdict form. So if they spoiled the copy that's currently in the envelope, at what point were they given a new copy and by whom, under what circumstances, and so forth? How do they have a verdict form now?
Did she just leave the bench? Is that what happened?
Yeah, she noped out. She's like, yeah, we noped out because.
Okay.
Yeah.
I feel like that's all that's a very good question. She should have said on the record, counsel, I've provided them, or I'm going to provide them. I'm about to provide them. I'm not going to have them come out and give it to them. I am going to have them come out and give it to them. What is happening?
What in the fuck, man? Oh my God. I don't understand. I still don't understand it. So they knocked, they said we have a verdict. They then knock again and say, just kidding.
Right.
Apparently.
But how did they get their hands on this envelope?
Well, then the judge asked them to take whatever verdict sheet they used to come to a verdict and then uncome to a verdict, whatever they did when they came to a verdict, they took that one, even though they've changed their mind and it's not been accepted or any of that, it's in an envelope so that it's, part of the record for later.
Well, for the second time in this trial, the text message has been deleted at 2:27.
Holy
Kurt?
What?
No.
No. What's your real name, Auntie Deb, or do I just call you Auntie Deb?
I'm Jimmy.
Jimmy, hi, I'm Allison.
Nice to meet you guys.
So what are you thinking?
I'm thinking that I was just getting a coffee and I heard rumblings of things going on. So I was like, shit, I gotta see this somewhere. Mandy sent me a link, so I'm like, let me just see what the fuck is going on here.
Yes.
And come to find out, another M. Night Shyamalanian twist in this goddamn fucking, my blood pressure's not good after
That is an appropriate comparison because his movies are awful. So
yes. And she keeps trying to make this the Sixth Sense, and it's not. We can't see the dead people. We don't know what's going on, hon.
Right. I mean, I feel like it's time that this should prompt a discussion between the lawyers and the judge about, do we follow up in some way with the jury? Do we ask them, have you reached a verdict on any of the counts? That's it. That's it. I mean, is that not appropriate at this point, Kurt?
Because they were
yeah,
trying to get to the truth. And
I would think so.
That's not what this is about. This isn't about the truth.
Yeah, I think that it would be totally appropriate to maybe ask some clarifying questions or, see what's going on. But we're not going to
clarifying questions like what and the fuck.
Right. Oh my gosh. Oh my gosh. People are still asking for us to explain it. I mean,
how?
Yeah, well, I mean, the legal explanation is that the jury is entitled to change their verdict, and any juror is entitled to change their verdict up to the moment it is read by the court. So usually,
when they're polled, right?
And even when they're polled, because the question is usually some version of, was this and does this remain your verdict?
Right.
So like up to that moment, right, a juror can be like, oh no, I changed my mind. And sometimes juries are polled and they're like, no, we don't agree, or it has been known to happen. So from a legal posture, that's correct.
Juror back there who felt like I caved, I gave in. And if that's the case, in my mind, it's someone who thinks she's guilty on an OUI and agreed to go not guilty because she was pressured. That's what I think. I don't think the glarer of the jury, and Jimmy, just so you know, Sean, Will, the glarer, had been with us, and he says he would have stayed dug in on not guilty, even on a DUI, even if it made it hung, even if he even if he understood the risk that could let them retry her on manslaughter. He was not going. It would be very hard to push him to feel forced to say guilty on the OUI. So with that juror in my mind, I feel like we could, and everybody, I'm speculating, that there's a juror back there who wanted guilty on an OUI, agreed because of pressure to say not guilty on an OUI, and then had like a, either a breakdown or stood up and said, no, I can't do it, I'm not going to do it type of moment.
Could be.
What if you're writing this movie, Jimmy, what happened back there?
Oh God, what happened back there?
This is fictional.
They're all trolling us. They're all trolling us.
Yeah, no, that's it. Yeah, they're definitely trolling us.
They're drinking. They're having a good. They're watching us, being like, let's see how much more we can make these fuckers freak out. Like they have you on screen and they're trolling us. This is Jury Duty season 2. This is what this is. we are the main character, and everyone else is
the main characters. Ian, if you had to write the script of what really just happened, was it a juror pressured, changed their mind? We know it's fiction, we know it's speculation. Go for it.
I suspect that a juror, like that they're at 11-1. A juror is like, okay, fine, I'll do it, and then when they, and then is like, no, I'm not doing it, and. Right.
But no guess which way that juror would have been going. Did they switch to a not guilty or did they switch to a guilty? On the OUI, we're just assuming this is all on the OUI.
I don't know. For me, that's a coin toss.
And Kurt, chances this has nothing to do with just the OUI in your mind.
At this point, it's like wrong answers only is the only thing I'm thinking to myself. Like, what is going on in there? What's going on in there is one of the jurors wants to get in that last second poly market bet because they have the inside information. They want to make sure to get that bet registered so they can really cash out when they return the real verdict. That's what it is.
Oh, Lord. We've been talking about that. Apparently, you can gamble on anything. We didn't know if you could gamble on the 127 deletion of the verdict, but I mean, 227.
Speaking of which, Polymarket, for those of you who care, and by the way, once again, Polymarket is just a betting website. So these odds are just based on what people are willing to bet on. So that's how they're calculating that. To be found guilty of murder or the vehicular manslaughter DUI, 24% chance is what they're currently predicting. And those odds have gone up, incidentally, since earlier this morning. Yeah, it was down at 14%. So the probability of conviction, at least from them, has gone up to 24%. And
I bet they're basing that on time alone in my estimation, but I have no idea.
And for McCabe is back there betting all of it.
And for acquittal, for acquittal across the board last night, it was 80%, is now currently sitting at 51% to acquit across the board.
Wow, it went down that much.
That's a good feeling.
Yeah. Which still leaves an implied 25% chance to hang or convict only on the DUI.
Right. If we're going to trust so for that kind of betting, because I know nothing about what they do they consult lawyers? Are lawyers actually following things in their update? Like,
who knows?
People bet.
Who knows? Same way people bet on anything. But prediction markets have, whether or not there's enough money in this prediction market for this to be true in this case, I don't know. But prediction markets with sufficient capital in them have found to be pretty good tools. Like the prediction markets were more accurate with respect to, for example, the election than the mainstream media polling, just as to pick an example. So prediction markets can be a somewhat reliable indicia. It's a whole like wisdom of crowds thing. Yeah.
Oh my God.
It's like if you ask enough people how many beans are in the jelly bar, their jar, their average will be really, really close to the right number. It's a thing.
Oh my goodness. Brass Tracks loves you, Auntie.
Love you, Brass Tracks.
Java Cat, I feel like I've been rickrolled.
Yes, very much so.
What is rickrolled?
We're no strangers to love. You know the rules, and so do I. Full commitment's what I'm thinking of. You would get this from any other guy. I was gonna tell you how I'm feeling.
Too early.
Wanna make you understand. Never wanna give you up. Never wanna let you down. Never wanna turn around and desert you. Say a lie. Never wanna say goodbye. Turn around. No, his name is Rick Ashley.
Oh.
And it was a YouTube prank.
Oh, it was a YouTube prank. See, I can get none of those references because I
know you don't. I've watched you before. You don't get a lot of references about things.
I don't do social media a lot. I don't like, my friends would be like, have you seen the blah, blah, blah? And I'm like, no, like it's their joy when they like get me for a night and they can like pull up YouTube or whatever and like show me things that everyone else has seen that I haven't seen.
Wait, I can do it better. 1 second. Never gonna give you up. Never gonna give you up.
In the stream.
Auto-tune. Oh my God. Oh, look at that. We got So Fucking Awesome, aka Rob. We now have a rehomed verdict to go with the dog. I got that by a friend of mine.
Yeah.
Started
poor Chloe, poor Coda.
The Sofa King, and I use it all the time. Sofa King.
I educated that Coda's a transgender dog and ran away to Vermont to be its like true self. Because Brian Albert's not accepting. You know what I mean? So they're like, I can't be who I really want to be here. They keep saying I'm a monster, and so they ran away to Vermont, like where Arkansas.
You got
I'm not sure if that's a voice changer or just a really awful connection.
Somehow Kurt's auto-tune voice changer went onto Jimmy's sound.
Let me fix my shit. Hold on.
It's like the press the oh, I'll keep an eye for him when he comes back. And Bob's just sitting there silent.
We sometimes sing on my channel too, so if you like the singing, you can come hang with me. We do some singing.
Back from the thing.
Did you hear Kurt and Jimmy's song? I tried to.
Yeah, it was amazing.
I loved it. I thought it was phenomenal.
Your sound's no good either. You're out.
All right, later.
We'll see you soon. Now I need Mandy to make us look better. I hate when we're like the big cubes, but we can see, and Runkle's got the OnlyFan face.
I also had to answer the door because I ordered something for in the event of a verdict. At least,
no!
Verdicts.
He was ready to celebrate.
Possibly. Potter is also going completely crazy because there is some exceptional thunder going on here. And so when I let Potter in, he ran inside and danced on top of, I've got a laptop set up right there. And he was like, I am in a panic. And I'm like, oh God, dog. New verdict, apparently.
I am appreciating some of the puns that Chad is coming up with. This verdict has now been rehomed.
Verdict.
Yes.
Brian Higgins
we don't have a verdict until we have a verdict in court.
Brian Higgins is no longer the only one with blue balls.
Verdict.
Wait, are you
Welcher
saying
already? Welcher probably has them.
Have you heard something else, Mandy, or you're just saying that?
Verdict.
I can't,
Okay, we got you. Just stop.
I can't tell what she's doing.
I mean, people are saying that the verdict is in, but
again,
just yelling yes.
God, jurors still deliberating.
You can't be serious. Really? Seriously?
I mean,
We're
it's
doing.
not
Are we
surprising
doing
if
this
they
again?
had-
Are we doing this again? Seriously? Really?
I don't know.
If they do this to me twice, I am rage quitting. Oh no! The OnlyFan crashed. Oh no!
No!
Someone fix OnlyFan. Bring it back. Bring it back.
Back to Boston 10. It's coming. It's coming. It's coming.
Oh my goodness. Yeah, Turtle Boys apparently tweeted that.
No
So
one can touch it until the jury comes back again.
Oh wait,
to
I don't
say
want this.
officially.
Turtle Boy tweeted it too?
Apparently.
Oh Lord. All right. So now we have a real verdict. All right, I'll put back on long crime because
I don't believe you.
she was like, it is too close to 227. Or one of the jurors is like, it's too close. We're gonna have to. All right, share. Do you guys see OnlyFan now?
Yes, thank you.
Okay.
Make sure that volume's on, so we don't have that problem again.
Yeah.
Thank you. Have you seen Miss Mandy's shorts, by the way, where she does songs related to this trial? She's done some AI songs. She has a really great OnlyFans song on her channel.
So not the Mandy here, different Miss Mandy.
Yeah, she's really she's got a great bopper of a song on her channel for OnlyFans.
Joe Flipperhead says that sealed envelope says NG. I guarantee it.
It better. I swear what.
Something else will be turned in later. You watch. All right. I don't know. Oh, that's Mandy again. Mandy, you have no signal. You're like frozen again. Just start screaming verdict. She's already.
Miss Shorty,
on.
not Miss Mandy. I said Miss Mandy. I apologize. Miss Shorty. Apologize.
Oh,
Wrong
Miss Shorty.
channel.
Oh, I've heard of Miss Shorty.
Yeah,
I
she
don't
does. She has a great OnlyFans song. So sorry for wrong name.
No, it's so they said a verdict again.
Mm-hmm.
And I mean, that might not be that surprising if they were at 11-1 and then one person had had cold feet and then they bring them in and then all 11 people yell at them again and they're like, all right, I'll do the thing.
Mandy, try to get Jimmy back.
Verdict means truth. What is the truth?
A false memory verdict at 227.
Mm-hmm.
Did they rehome to avoid the 227 not guilty? Oh, Lord. 2 trials, 2 verdicts. Why not? I mean...
That's right.
Right.
2 trials,
Oh,
2 trials, 1 verdict.
Rob?
The jurors have a Dever false memory. I thought there was a verdict.
God.
I mean, maybe they did just mess up the sheet.
Until they actually poll the jury and all of them say, yes, that's my verdict. I don't believe you.
Right. We're not, that's it. We're going through the whole polling before we accept this verdict. Chris says, did you read the story where Rick Ashley was rickrolled by a friend of his and was super confused? So Rick rolling means you get rolled, like you get
It's just where it's just where you play that video. The fact that you don't know this is charming.
Okay. All right. I'm back to it. That's right. You guys said it was like a TikTok or whatever.
It's older than that. It's like a 10-year-old, if not older than that thing at this point. It's ancient by internet standards.
And I'm pretty old, but yeah, I was like, I'm done. I'm not doing social media. I'm not watching people's stupid videos. I'm not, no, And I was often busy. Mickey says, there's never a damn dull moment. I'm still here in complete shock while also singing with you guys. Larisha emailed her dance party to Auntie Deb to Auntie Deb's song. We'll have to wait to see if he comes back. Sorry, never got his autograph. My nephew loves Auntie. Jimmy's probably like, your nephew loves me. Thanks. What's that movie with Pauly Shore as a juror? It feels like that.
Pretty sure it's called Jury Duty, is it not?
Oh yeah, that sounds right. Yep. At Defense Story Podcast, Sue just posted at 1:58. Court officers were looking for a clerk. At 2, word went out to bring the defense and prosecution back. All right.
She did ask him to stay in the building, so they should be right there.
They should be right there. This should not be, I hope Bob said gotcha after Bev reneged. A butt dial verdict at 2:27 is insane. Yep, the deleted one. What next?
The verdict is a butt dial is a funny.
It is. Oh, my friend Cammie Brown. She was on here yesterday. She's in Boston. She says, I'm freaking out. I guess all of Massachusetts is. I mean, obviously and all over, but you've got to know that they're more dug in since it is their tax dollars. Hard at work here. Hard at work. I mean, between the two trials, how much have taxpayers paid, do you think?
Well over $1 million.
Right.
Probably not at 2, but in that range.
Oh boy.
There might be some possibility of EDB. Can I share the link if I can get EDB on?
Yeah, that'd be amazing.
All right, let me see what I can do.
I don't think she does panels these days, but
no, she might for this because I think she's traveling.
She is traveling
she's traveling, so she can't do her own.
Give it a try. Absolutely.
I can't even type. That's my friend who just texted me. That's who she watches with.
Oh, apparently she's gone live on her own channel.
Okay, well, never mind then. So much for that plan.
Yeah.
Oh well, it was worth a shot.
Right. It's. They didn't leave the building. Aiden says verdict. She's re-looking at it.
Wow.
So now we've heard the verdict is back. The verdict is back.
That would have been cruel. It would have been super cruel if they had the verdict when I was at the.
I just realized I'm wearing blue, and now I feel like a jackass.
I mean, I am also wearing I don't have anything pink, so.
I mean, this was an issue this morning for both of us. Bob first had on like a really baby pale pink shirt, and everyone's like, that's white, that's gray. He went through 2 button-ups before he found what really in real life looks more red than it is appearing pink. And this is sort of salmon-ish, but the only other pink thing I had was like a hot pink Express shirt from 1990. So this is actually my daughter's oversized t-shirt. Yep. Thanks. Thanks, Melmo. We heard.
Somebody
Kurt was trying to get Emily. Kurt was trying to get Emily to come live with us because she's traveling. So our friend Cammy Babe texts like she's dying, and I was like, I know she watches Emily. I'm like, oh, we're trying to see if Emily would come, and then it was like, never mind, Emily's live. This is taking a while.
I'm dying. I was literally in like a, like where they do hitting practices. So I was looking at like some kind of like industrial park, like batting cage, and you guys are all like, "Oh, there's a verdict." I'm like, "Oh my God." I'm like, that would be just my luck. That would be so apropos of life if I missed after covering the trial every single day to miss the verdict. Oh my God.
So do we know, is Aiden back in the courtroom?
Yeah, I'm emotionally eating and I'm starving.
Aiden is texting saying that Karen Reed is giving hugs to her team of interns and lawyers are hugging the parents. So,
wow,
seems like it.
Wow.
Alan Jackson apparently is pacing.
All right, so you guys, you all of us know what it feels like after you've been told they've reached a verdict as the attorney.
Oh, I thought you meant once we had a verdict, no verdict. I'm like, no, never been told that.
No, none of us know that. But like this kind of like this dead zone between after they told you there's a verdict and when you're kind of sitting there waiting with your client, waiting for the jury to come in, waiting for that, like that feeling.
I spend a lot of time talking to my client during that and telling them things like, okay, so I need you to like chill out because, I mean, especially for something like this, you probably don't want her going, yeah, in your face, like that, something like that. You just want her to, and I tell clients like, just nod respectfully, smile to whoever, but you don't need to, you don't need to like rub anyone's nose in it. Just, yeah.
See, I don't like law and crimes.
Jurors still deliberating.
Right. No. We gotta put
alarm verdict.
No, we got to put.
Are they? I don't know.
Who's the genius? Why are you going Boston 10? They've been our ride or dies.
All right, because I wanted the wait, is this Boston? No, that's law and crime. And this is Boston 10. Let me see. Boston 10. They don't have the OnlyFans up.
Oh, really?
Yeah, I don't know what they're doing.
No. I don't know. Shit in the bed. I did.
Did they hire on Amber Heard?
And they have verdict reached in Reed murder trial.
Yeah, Boston 10. That's what I'm looking at here, but it's outside the courthouse.
Other business, they were here.
I mean, should I share?
Yeah,
that?
you don't want to play that because they'll hit you with a.
Yeah.
Okay. Share this tab instead. We'll go back to OnlyFans. But I want to update our thing to say, allegedly.
Allegedly, the verdict is in.
Second verdict seems might be in. All right, that's what we got. Second verdict might be in.
We've had first verdict, but what about second verdict?
Yeah, exactly.
Yeah, I'm doing allegedly the second maybe verdict is in.
All right, so now I'm back to and Jimmy is back with us.
I'm at Starbucks. I'm hiding at Starbucks because I heard the verdict is in, and I need to be with people to watch this. I have to, so I kind of have to be quiet and a little bit appropriate because.
Yeah, we'll see if you
ready for whatever our next layout will be when we make the screen big.
So what's going on? What's going on?
We
Now
think we have
there's
a
a real
verdict, maybe.
Maybe.
What do you mean? What the fuck does that mean? What do you mean?
Well, we already had one false verdict, so who knows? Did you miss that from? Did you miss that from like 30 minutes ago?
No, I was in my car having a friggin' miscarriage.
He was here with us. He was here with us. So Aiden has said the verdict is in, right? Kurt, is that what he reported?
Anyone else shaking? Anyone else shaking?
Yeah, I'm like, I was just telling everybody like what it feels like when you're a lawyer kind of in this.
I just lost you. I just lost the audio. I just lost it.
You can't
Can
hear
you hear me?
You.
We can hear you.
I can't hear you.
We can hear you.
Shit, I can't hear you. Fuck. Hold on.
Okay,
that's awesome. Oh Lord, I can't hear you. Shit.
Awesome.
The audio wasn't very good anyway, so.
Oh Lord, I can't hear you. Shit.
And now I'm hearing feedback.
No, that's me. That's me. I was copying the link.
I muted him. He's muted.
Excellent.
Oh Lord. Oh, they updated their thing. Oh, I think he's back. Hold on.
I don't believe it.
Can you hear us,
I can't
Jimmy?
hear you guys. Hold on.
He still can't hear us.
Audio, microphone. Fuck.
All right, live now.
Okay. Is it working now?
Hear us? Verdict is in.
Maybe. Hello.
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 We can hear you. Can you hear us?
No. Okay,
We
great.
hear you.
We can hear you.
Let's not do this for verdict watch, please.
Yeah.
He's muted himself. We've got him muted until he can hear us, and then he can unmute. He's just.
Oh man.
Oh Lord.
I'm good.
Yes.
Okay.
All right.
I'm in the corner. Okay.
Man.
I'm like,
You're coming in real hot too.
What does that mean? What does that
You
mean?
had too much coffee.
Well, dude, it's a big fucking day. It's the biggest day of my life.
Oh man, this is a big day.
I gotta pee. I haven't peed in like 3 hours because I can't. I feel like if I pee, the world's gonna end.
Do not
Hell
take
yeah.
the stream into the bathroom, sir. We don't not need a stream on a stream. It's
Stream on a stream.
Dual streaming.
Bring a new meaning to dual streaming.
Oh man, this is a lot. This is a lot.
Yeah, I can't move. I'm standing in one spot. If it gets busy, they're fucked because I'm not moving.
This is a lot, man.
Ellie Starr says it's gummy time in Colorado. Insanity in the membrane, anxiety.
I have a feeling for her, it's always gummy time.
Mm.
God. It's
Bob,
wild.
you gotta. You're
Bob,
on
is
the
that
phone
you
again.
making noise again?
No, it's got to be Jimmy.
You can take me off.
No, I'll
Thank you.
just mute you. It was Jimmy.
So something came through at 1:53. Court guards just brought in a first aid kit and an AED to the side room.
It's because there's a couple of older parents. They're just being precautionary.
Wow.
All right, so right, people, just bear in mind that no one should know the verdict yet. So as Ian is saying, they are being precautionary.
And I'm sure that because they don't know the verdict here, they've got all of the security to get Karen Reed safely out of the building, regardless of where she's going. They're going to have, because I mean, they've got to be concerned that somebody out there, might do something stupid or whatever else. So, I suspect they're on all hands on deck on the security right now.
Yeah, I'm looking at on Boston 10. They've got a dual stream of OnlyFans and the outside. I can share this tab.
Share it with us. Listen.
You guys, do you think if she's found guilty on the OUI standalone that Bev would take her into custody?
No.
Yes, I do.
No.
Wow.
No.
I think she would.
No. Not even she would stoop to that level.
That right. I'm like, dude, it's a misdemeanor. Like she's out on bond. I'm like,
that would be outrageous to take.
That would be unbelievable.
That would be
on a
unbelievable.
First offense DUI. Give
How
me
many
a break.
unbelievable things have happened in the past 2 weeks?
Oh, look, people are really they're like,
wow. This is a minute. This is a moment in time, man. Like, wow, this is crazy.
His presence is strong.
I mean, I could be wrong, but I don't really feel like if it were guilty, that there's really a strong chance of rioting. But
I mean, there is a possibility of rioting. There's a possibility of somebody taking a shot at her. There's a possibility of all sorts of things.
I
You really
suppose.
think that someone would do that?
Yes.
Yeah.
Who knows? Yeah. I mean, can't put anything past anybody these days.
That's fair.
I mean, you've seen some of the crazies on.
Yeah,
on
I
this
mean,
one,
and
so.
it's like the fact of the matter is we live in a world gone mad. You know, I mean, this like we're in strange times indeed.
That is a pretty big crowd outside, man.
Yeah.
I mean, I've gotten death threats, so I mean, they're hilarious death threats because they're like, you know, I'm in the States and I'm like, okay, cool. Y'all bring your guns across the border and
good luck with that.
We'll just see who wins the quick draw competition on that one.
Oh man.
Also, if you could let me know when you'd be coming so I could load the flamethrower, it would be really appreciated.
I have to go get water, but I don't know if I can do it.
I mean, I want to get up and change my shirt, but I know the second I do that I'm going to miss the whole thing. That's my problem.
All right, maybe we both should run because I'm going to go get a drink, Kurt.
Oh man, you're on the clock. 1,000, 2. It was ballsy. It was ballsy. It's how I felt when I was stuck in rural Elburn, Illinois, at the hitting lesson. Man, oh man. Man. Man, oh man, oh man.
Yes, and for the people who
Told you.
still inclined
Told
to
you.
send me death threats, keep in mind I find most of them hilarious.
You missed not the perfect time. Allie, you better hurry up. She's on the bench.
Allie might also be on the bench right now, so.
Oh my God. Oh my God. Oh my God.
Is the audio on the stream?
Oh my God. Is the audio,
Is the audio on?
Yeah.
It is?
No, it's not.
Nope.
Okay, we can hear her now.
Yeah, having it muted is like the ultimate.
What a nightmare that would be.
Mr. Foreman, on docket number 2282CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty? Not guilty. So say you, Mr. Foreman? So say you? No. Do you agree? Yes. Do all of you agree? Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty? Not guilty. Is not guilty or guilty about that charge or any lesser included charge?
What?
Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with blood alcohol level of 0.08 or greater. Correct? Yes. So say you, Mr. Foreman? So say you all?
They made the right call on the OUI inclusion.
Defendant at the bar, leaving the scene after accident resulting in death. Defendant not guilty or guilty?
There you go.
Oh, you hear outside.
Jurors, hearken your verdict as the court records it. You, upon your oath, say the defendant on 001 is not guilty, on 002 is guilty of operating in the influence of liquor, and 003 not guilty. Thank you.
Wow.
There you go.
Jurors, everybody
Wow.
please be seated.
The most expensive OUI of all time.
No doubt.
Send you back to services complete. I'd like to come back and talk to you a little bit afterwards. So thank you very much.
All right.
Wow.
Wow.
What a glorious day for Karen Reed. After all this, man.
Oh, look at the tears. Wow,
Holy
you
shit,
them
man.
outside.
Acquitted in the murder of her boyfriend, John O'Keefe.
Queef? Who's that?
Switched.
I don't know if it was
Boston 10.
New boyfriend. Who dis?
I switched.
Holy shit.
Holy shit. That you've been found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the request not to seal form, which is posted on the trial court's website on mass.gov. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, you will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
It's not taking her in.
Well, she hasn't said. I hope she doesn't.
Okay.
Sidebar.
Sidebar. What the hell you need that for?
They might have a stipulated punishment. They might have talked it out.
No, it's possible.
They might just say, "Hey, we've agreed that a $100 fine is appropriate if that's all she gets."
Andy, stop.
Yeah, please,
Wait,
no.
I don't think they do that. I've never, Kurt, have you ever had, after a verdict comes in, that the parties agreed to the sentence?
All right, so Ms. Gianetti, you ready to go forward today as well?
There you
go.
Doing immediate sentencing.
Recommendation.
Immediate sentencing.
Moves for sentencing, we recommend probation 1 year, 24D program.
Yep, that's standard.
That
That's
everybody
standard.
else gets on a first-time OUI.
Good for Brennan. I'm going to give him props for that.
So I'm happy to do it. All right, thank you all.
Oh my God!
Solid props to Brennan. And you know what? Good for the
002,
judge.
unless you included offense of operating under the influence, 1 year probation.
Good for the judge.
The 24D program is. Thank you.
Wow. Yeah. Props to Brennan.
Goodbye, indeed.
Wow.
Oh, gosh. That is so touching.
That's amazing. Holy shit. Wow.
You got your life back.
Suck it, pro conviction people.
Yeah. Go fuck yourselves.
I mean, the actual full right outcome. And I'm sure.
What did she get? 24 months or 12 months?
No, it's a 24D program. It's a special
probation.
program.
Yeah, 24D program.
I don't know what that is, but whatever.
I'm going to give Brennan serious props for it.
Yeah.
Like 100% for.
You can unmute yourself, Jimmy. You're muted still.
Wow.
Well, we can't hear you though.
I'd love to see the crowd outside. Is there a feed that shows the crowd outside?
All right, let me see.
Yeah, they're going nuts.
Here we go.
I'm sure they are.
Wow. Yeah, we want to see it when she walks out. It's going to be pretty explosive.
I'm sure that Court TV will switch over to that at some point, but this is good for now, the dual stream. Wow, you could hear them cheering so loud in the courthouse. It was like a thunderstorm out there.
Apparently, according to Turtle Boy, the crowd was instructed not to react. Apparently, that didn't work.
There's Aiden. There's Aiden.
Yeah. Wow.
Yeah.
Wow.
Let's hear. I'll turn the sound on.
Allowed to leave. She is a free woman. She
Can't hear it.
Wow.
All right. I can't imagine the feeling for this family, for Karen Reed. And yes, it's so unfortunate for the O'Keefe family because many of them may very well think this is the person who committed the offense. But I feel like you sit through that trial and you have to understand how the jury came back the way they came back. And I wonder if secretly they do question it.
They should be mad. Like, even if they think that Karen Reed is 100% guilty, they should be mad at the police.
Yes.
And I know they're going to come out and they're going to make a statement against Karen Reed. They're going to make a statement against her defense team, all of those things. But they should be furious at the police because either the police allowed guilty parties to go away uncharged, or they did such a sloppy investigation that it was impossible to, determine. And that's who they should be mad at. And
are you guys hearing this? You're not.
I'm hearing it. It's amazing.
Yeah.
Team quite yet, and I do want to point out
When she walks out, it's going to be epic.
Bedlam.
Are you guys not hearing this?
I'm hearing it.
Hear it.
Yep.
My guess is they will be allowed to go out.
Just you're probably going to eat a strike if you're not careful about playing it. So just.
Wow.
She is free.
Right?
I have a whole bunch of people on Twitter who I have to chirp right now.
Tell them I said this.
What TVU are you?
Wow.
They're showing a different. Boston Penn's showing like something different, but.
What TVU is it? Who's the podium?
Mandy, can you cover the law and crime?
I think I can put up the law and crime border.
I just cleared the rest of my day.
Wow. This is amazing.
I mean, that's.
I'm not even kidding. I cleared the rest of my day so that I can do this.
That sense of catharsis is real. I can't even begin to imagine how she's feeling.
Oh my God.
Not guilty, Dad.
Wow.
That is amazing.
Oh, he's coming out.
It only took 20 hours, well, in 2 years.
Not guilty on everything but the OUI. Everything but the DUI. Oh, he closed the door.
2 years, 20 hours, 2 verdicts, 24D program, 227. Suck on it, everybody.
Oh, man.
There you go.
the chant.
That's right.
There you
Not
go.
free Karen Reed. Karen Reed's free. That's right. And I agree with you.
Say that is, I was losing faith in the system, and
Yeah.
But yeah, as you said, Runkle, kudos to Brennan for
I give him
just
serious props. He could have come in and asked for.
could have been a
2
dick.
years.
Could have been a dick, and it's just like doesn't matter.
No, but it says something after all that to at least.
One moment of ethics. Yay.
Yeah. Wow.
Melanie says Karen Reed has always been factually innocent. Suck it, Brennan. At least Lally was able to convince some people. I'm relieved for her. What does that say out there? Corrupted CPD and MSP.
Something.
Oh, please.
Should I turn this up?
Turtle Boy is noting that he can't actually stream right now because everything's too loud.
Yeah.
Also,
all those phones sucking off the tower.
Yeah, that too. I was a little surprised by just like how fast the verdict was read. I mean, it was just like so quick.
Yeah, it was very quick. MSP needs a reboot.
Take the super jet down. I can't see.
Oh, I'm sorry.
Oh, there's Ian. Hi, Ian.
I was looking at the other screen. I wasn't on the. Hey, DePietro, you think this is funny? Loser.
Now they've got to turn around and charge DePedro because we need to know, will DePedro get a higher sentence than Jerry?
I turned the volume down a little bit until she comes out.
Well, I know a few people are going to be having a rager tonight.
Everyone will be drunk driving in Canton tonight.
Yeah. Canton's the DUIs are gonna be epic tonight. Gonna be big money night for Canton.
I'll tell you one person who won't be driving drunk.
The thing is, I would be shocked if she wasn't put on a plane to somewhere the hell else.
Yep.
This is not a safe town for her to hang out in.
Not today.
Yeah. She should have. I would have asked, actually, in the terms of my probation, that I'm free to leave the state.
Even if they don't have her leaving the state, just like, I mean, I quite likely would have had a, like a cabin in the forest somewhere. Just
hold up somewhere.
And yes, Self Wiggins, guilty on the OUI. She got a year probation, which is the sort of default standard for somebody. And I will give Brennan credit. That is a reasonable thing to do.
Yeah.
He thought about it. He was like, I've already taken enough shit.
It's very clear to me they talked about it beforehand.
Yeah.
Like in this time, they said, hey, it's looking like she might get the OUI. What are you doing? Like, where are you at on that, Brennan? And I'm betting he said, you know what? If it's just the OUI, I don't care. Like, that's it. Seeing a request in chat to go through the verdicts.
To go through
the simple
verdict?
thing is not guilty on everything except
the OUI.
The OUI.
Yep.
Lesser included.
Yep. Not guilty murder 2, not guilty manslaughter, not guilty leaving the scene, and then guilty of standalone OUI. For that, she got 12 months probation and what is it called? The D24 program?
D24, yeah. And Christy, you can bet the attorneys and Karen are going to speak when they come out. I feel pretty confident about that, but you never know. Meek says, I'm so happy Karen can breathe now. Words cannot express how happy I am. Second Hook says, I'll just read it instead of put them up. I didn't see John's family there. I wasn't looking now that we mention it, but what's the story there? God bless Kate and her, Karen, maybe, and her team of outstanding lawyers. Becca Wise says, this is huge for anyone who has ever been unfairly charged, tried, and convicted, and even convicted. Things changed as we shed a light in dark places of our justice system and demand accountability from leadership. No.
Wow.
Karen is free. Thank Danielle Lewis says, Karen is free. Thank you, Allie and Bob, for your coverage. Our friend Cammie Brown, who you were with us yesterday, she just texted me that she teared up. Let's see, because now I lost the text. She said, I teared up at her legal team's reaction. Morrissey resigned.
Wow.
Yeah.
So the 24D program apparently allows her to maintain a driver's license, I'm seeing.
Nice.
Wow. That's
potentially. It requires her to attend for 90 minutes per week for 16 weeks for counseling, self-help, a victims forum, and an alcohol program exit interview is what I'm seeing on. So
sure beats prison.
Oh, 100%.
Wow. God. What she must feel right now. What she must feel. The relief. Oh,
apparently she doesn't even have to install, like, there's not necessarily a requirement for an alcohol interlock.
Nice.
Yeah.
That's interesting.
So, I mean, in theory, she could, once she gets all the paperwork done, if she can meet the standards for the, for being able to drive, she might be able to drive home.
Nice.
That is amazing. Amazing.
I mean, it's just such a shame that we see with our eyes how much has to be done to fight the beast that is the government. Like, this is not doable to any normal, average person, to the not even normal and average. She got so lucky that these lawyers wanted to continue to fight, and that they, I mean, this is not what happens. Every other case, someone's in jail for the rest of their life.
It takes a lot. It takes a lot to beat a case like this. It just
we all just
apparently it took like $3 million.
Yeah, I mean, and a team of lawyers that tried the second case on the arm.
Oh, I mean, the amount of money it would take to hire this team.
Yeah, no joke. Lots.
This is like, I'm just gonna say, OJ's defense team, they called the dream team. I actually think that Karen Reed had a better team. I think that the dream team qualification has been taken away from OJ and has gone to Karen Reed's team.
I agree.
The amount of money it would take to pay these lawyers, Ms. Little, Mr. Jackson, Mr. Yannetti, Mr. Alessi, Mr. Wolf, all of that, like, to pay this team would be multiple millions of dollars.
Yeah. Yep. I mean, that would have been
like per
at least
hour,
$2 million just there.
like per hour alone. Just
per hour of them,
like what, 5,000 combined?
Yeah,
I think that right. I was thinking like 500,000 each lawyer just for this second trial, and that's that's understating.
I mean, I've got legal shit going on right now. For a Supreme Court appearance, I fundraised a little over 50,000 Canadian.
Wow.
And that may not end up being enough. We'll have to see.
Yeah, I mean, and like to your point, Ian, like OJ's team, there was no continuity. Like these lawyers were truly a team. They worked together in a way that OJ, like, you just had a lot of names with OJ. They brought guys in.
But this was like watching an engine.
Yes.
Every lawyer is a different piston moving in, a precisely timed sequence.
Yes.
And they work together like no team I've ever, because I've been on defense teams before. And it's hard to work together in synchronicity because we're used to being independent, solo sharks in the water kind of thing. And now you've suddenly everything's got to synchronize.
Yeah.
I am astounded, and I don't know that we will ever see a team quite like this one. It is, but I mean, just think about this. If you were not in Karen Reed's shoes, where, and we got to give tremendous credit to Aiden Carney, Turtle Boy.
Yep.
Because he brought attention. He made a lot
absolutely,
of this
100%.
happen.
100%.
I want to give tremendous credit to Yannetti, because Yannetti was the first guy with his feet on the ground. Jackson did a tremendous job in terms of, I mean, he did a lot of the he's kind of the face of the A-team on this one, if that makes sense. You've got Alessi, who is brilliant at dealing with the scientific and the very difficult arguments sometimes. And, Ms. Little, we didn't get to see as much of, but she came out and she was obviously doing a lot of work behind the scenes as well. I would love to hear, honestly, Ms. Little, if you're watching any of these things, I would love to hear, because, I mean, she didn't get to speak as much, but you can see she's working hard in that courtroom.
Oh, yeah.
Oh, yeah.
Because when everyone else is talking or whatever, you can see she's sitting there, she's working. This was such a good team, and they were backstopped by a whole bunch of students whose names we don't know and we may never know. But I mean, all of those students had a chance to participate in something that is monumental. It's for the ages. It's a, I mean, if you're one of those students, this is going on your CV, right? Like this 100%. And if you're a defense firm out there and one of these students comes to you and is like, I want to work for you, fucking hire them.
Yeah.
Right.
Like
100%.
I mean, every one of these students, if they don't have a guaranteed, seat where they're not just being like, hey, here's a chair, but where they're being offered like a premium rate because this is clearly somebody who's above and beyond, then that's also an injustice, right? Like,
wow.
Yeah.
If they need a new intern, I'm available.
I don't think. Does anyone know with getting one conviction that takes malicious prosecution off the table, or are the other counts possible?
I don't know for sure.
Kurt was talking about that earlier. I don't know if you had dipped out.
Yeah.
You'd kind of like dipped into that concept of whether or not it's going to preclude her from doing it.
So
the one question I have, and this is an appellate thing, and I assume if she appeals the OUI, does that put the manslaughter back on the table?
No.
I assume not.
No, right. I thought it for a second yesterday, and then I was like, no, because it is an implicit acquittal of each of the charges ahead. So double jeopardy would attach to the other ones.
Yep.
Yeah.
If it was a plea deal on a lesser included, then yeah.
Yeah.
I mean, I also just, I mean, I'm rambling because I'm a little overcome here. This is a bit of an emotional thing because I was just, you know, I was watching this and I was worried that I was watching an injustice, unfolding again.
Right.
Yeah.
And, but I mean, I also just want to give my tremendous thanks to each and every person on the jury.
Yes.
Because it's clear that they did not just rule on emotion. Brennan came in on his close and he made the emotion pitch. Whereas the defense, in the one case where the defense is pitching the science, the defense is here going, the collision never happened. And I'm glad that they listened to that. And they clearly took their responsibilities seriously. They spent several days on this. They have given up weeks of their life on this. They have, and I'm sure that there were some difficult arguments in the back. I'm sure that there were some moments of, tension between jurors.
Yep. And I'm thankful for those people who wanted to say no, those people that felt like Will, wanted to buckle down and still say not guilty on everything, even in OUI. Thank goodness for you jurors who changed your mind, who might feel like I didn't want to cave. I wanted to stand up for myself. I wanted to stay firm. You did the right thing. Karen Reed thanks you. The whole world thanks you.
Yeah.
So don't doubt yourself, whichever jurors are out there, because clearly that's what was going on back there.
Yeah, because we could say definitively now that's what they were hung up on. That's what the battle was. I mean, clearly. So
I don't think she's likely to appeal because the probation.
Yeah.
No chance.
Yeah. No chance.
Yeah. Why? Why?
I mean, the thing is if I
wouldn't.
Yeah. No, I wouldn't.
I might offer the appeal for free, but
heaven forbid I win and they send it back for resentencing. You know what I mean?
They are the ones who requested. They're the ones who requested the OUI charge. I
gotta ask a U.S. thing. Can they appeal conviction only and not sentence?
No, you can appeal either one. Well, no, not in that sense.
Because I mean,
only appeal the sentence if it's. I mean, it's got to be.
If it was pure, like if this was a Canadian case and I got this result, I could see going. I would like to appeal the conviction only, and I don't think and the prosecution would be in a difficult spot for appealing the sentence because
no, you can do that. You can conceal conviction only and not raise any issue with the sentence itself.
Yeah.
But I mean, I'm sure at this point in her life, she just wants to move on.
Yeah.
She admitted she was too intoxicated to go on the highway. If you wouldn't have driven on the highway, then that means your driving was somehow, some way.
Yeah.
Impaired.
The standard, I looked it up, like the Massachusetts standard is you don't have to be a bad driver. It's just if your intoxication is to the point where it interferes with your driving to some extent. Right. And so this is something that trips up, people when they get up on the stand, because the prosecutor will say, well, do you think your reaction speed might have been like just a little bit slower? And they'll say yes. And it's like, you're done. You're cooked.
Right.
You just agreed to it on the stand.
Right. So if she said, I wouldn't have driven on the highway in that condition, then she just said her driving was somehow affected.
Yeah.
I do have one question. I'm not sure if anyone knows the answer to. When at the end, the clerk said you have 10 days to send a note to somebody to seal something. What are we sealing?
Verdict.
Sealed. I think
verdict.
No, I think the whole. I could go back and look, but I heard it at Aiden Carney's when he got found not guilty. I think even everything is sealed unless you want it unsealed. So like the fact that this even happened to you is sealed unless you request it to be unsealed.
And the thing is I can't see why she would want it sealed because, like, you Google her, you're gonna see this, right? And they noted that if she has it sealed, that she's not going to be able to pull a record of her acquittal.
So then she'll send that notice, or her lawyers will.
Oh, I mean, Christ, if I was her, I'd have that framed on my wall, and I'd have a copy, I'd have like a stack of copies for any time I have to apply for a job, that you can just stick that in there, right? This is, yeah.
What are they doing? Did they sneak out a back door?
Wow, man, they're
Probably.
gathering themselves. They're probably. Weeping,
they're probably
hugging.
There's probably people crying back there, right?
100%.
Sure. Scared Valley podcast said people all over one today, not just Karen.
Yep.
The justice system won.
Sus Bavaria said, I'm sitting in Germany crying because I'm so happy for her. Wow.
I mean, this was a huge win for the justice system in this country and people's faith in it, that it works or that it can work. I mean, it was huge. It's a huge day. The defense bar, man, a huge
so
day.
Huge, but it's also a little bit deflating because the chances of someone else getting this powerhouse team, this is what it takes, though, guys. This is what it takes. So does it work? Is it restored? It's like, yeah, it's restored, but then reality sets in that no one else can get this. This can't be recreated. It didn't work once, for God's sakes. I mean, it was a hung jury. That's something, but
yeah.
Like, is Mandy going to try to actually chime in, or
can you hear me?
We can.
Yep.
Okay, I just wanted to clarify. They did say John O'Keefe.
Yes.
Right?
Yes. Yes. 100%.
That man will live in infamy for that.
That was Boston 10.
That is a fucking travesty within itself.
It really is.
Especially for that guy's career.
Right.
I mean, I'm just going to say, this is why the mainstream media is kind of losing coverage, because they couldn't get somebody to actually look at the pronunciation of the name before they're doing the coverage. They've dropped somebody in to be like, look, there's a whole bunch of people who have an opinion.
You work in this,
I don't know shit about the case.
You work in this market and you don't know the name O'Keefe?
They were probably listening to Defense Diaries and caught on to Runkle's little innuendos he's been dropping all out.
Thanks, Ian.
Yeah.
Should somebody came up? Should we? Aiden's live. Should we stream a little?
Oh, hell yes.
Let's see what he's doing.
Oh, hell yes.
We'll keep an eye on if there's going to be a presser. We'll jump back to it. Yeah, pull Aiden up, and we'll chat with them. We'll celebrate. Man, what a day!
What do we do? What do we do now? What do we do now?
I mean, the thing is,
Why you gotta
I've
bring
been
me down,
looking
Kurt?
forward
Why
to
you gotta
doing
bring me
other
down?
coverage because, yeah. You
Is
just
that
muted it.
now? That looks old.
You've also got the volume on super low.
All right. Maybe this isn't right.
There you go.
Guys.
Maybe the one. Yeah. There you go.
Thank you, Mr. Chair.
Oh Jesus!
Wow, there's
This is it. He doesn't have a signal.
Karen Reed. Shame on you,
The network's probably a bit. The network's the network's a bit overwhelmed, so we've got a potato.
Continue to believe this. It's farce that John O'Keefe was hit by a car. John O'Keefe was not hit by a car. John O'Keefe went and said Brian Alberts got the shit kicked out of him and a dog bit him. And then they threw him on the lawn like trash. And in his closing, he had the audacity to suggest that Karen Reed problem for using an analogy about a buffalo on a prairie.
Yeah.
They treated him
that
like,
pissed me off.
like trash day on Tuesday. That's the way they treated John O'Keefe. So I don't hear a word, Hank Brennan, ever again. Ever. I hope this follows him forever like the loser he is. That's what he is, a loser. So we're still waiting out here. I have not had a chance to see the Reed family yet. As soon as the verdict was read and the sentencing was put in, they immediately whisked us out. I didn't get a chance to hug the Reed family like I wanted to. But I was able to kind of do this thing with Reed, with Janet Reed, with Karen Reed. And so I'd like to see them before they leave. I mean, that'd be cool. Where's Kelly?
Kelly will be there when they're coming out.
Where's Kelly?
Sure we'll be able to see. I think near the
Okay.
cars.
I'm gonna go down near the cars. We're gonna go down to
Go somewhere where you have a signal.
Oh no! Like go to a parking lot, like an underground covered parking lot. And,
Right. Blast off into space. Engineers know you can do it.
Yeah. I'd love to see the equations on that one.
Right.
Canton cover up 1. Now we're up to part. Canton cover up part 520. Not guilty. That's it. That's the whole thing. Not guilty. Not guilty. Not guilty. There we go. That's the next. That's the final installment of the Canton cover. AM Live. We have 40,000 people right now on my street. Holy shit. Yeah, we have Kelly Reed here. This is Bill Reed's first cousin. Yes, Kelly has been here.
Oh, so that's Kelly Reed that's been on our stream.
Going to all court hearings. You know, she loves the family. Her and I become friends throughout this process. It looks like we're in some anticipation here, folks.
All right, looks like it's coming out.
Here, flip it to where we can see it.
That's a lot of pink, baby.
Oh man, there she is. Here, go to Boston 10.
I did.
There, and Karen Reed holding her right hand over her heart.
Wow.
To the crowd. The other times that they've left the courthouse over the last few days, it's been with silence. They've been encouraging the crowd.
They're making the sign of the devil.
I
love you.
This time, this is a victory walk.
love
She has been
you.
acquitted of all of the murder charges in this case, convicted only of a lesser included charge of operating a vehicle under the influence. This crowd has waited a long time to hear from her. Let's listen in as well.
Number one is I could not be standing here without these amazing supporters who have supported me and my team financially and more importantly, emotionally for almost 4 years. And the second thing I want to say is no one has fought harder for justice for John O'Keefe than I have.
She's not
and my
wrong.
team.
She's going to get criticized for it, but she's not wrong.
Thank the jury. Thank the jury, Karen.
And her dad is sitting here looking like an absolute badass.
Yeah.
What does it say about justice? I'm going to leave it. I'm going to leave it to Karen. Her dad has a comment. Let her dad.
Yes, I want to hear from her dad.
Me too.
I want to acknowledge
Look at that. They're losing their shit.
of our daughter Karen. The support
the support of the entire Reed extended family. I want to acknowledge the greatest team.
Yes.
Attorneys. Our first one that we found was David Yannetti.
Yeah.
We added Alan Jackson and Liza Little. Bob Alessi, you know about. All right. It was a fantastic team, but we needed them all to defeat this. We thank everybody for their support from the heart. We love you all of the content providers who help spread the word. Thank you so much. God bless you all.
Hey, we got some love, boys.
We don't. The thing is, I don't need a shout out or anything. It's nice that he throws it in there, but
are the lawyers
I
not
am
going to talk?
There, David Yannetti.
I'm just so happy to see the that we had a result here.
Wow.
Mr. Reed.
Wow.
Lally Brennan, you want to say any comments? Over some thoughts?
I'd love
You know what? If I'm Brennan at this point, you know what I do? I get up and I say, it was the Commonwealth's responsibility to put this in front of a jury. The jury has made the decision.
Yep.
They have come to a result. It is a just result because that is the basis of our system. The jury evaluated all of the evidence. They evaluated a case that I fought as hard as I could fight. But you are innocent until proven guilty in our country, and Karen Reed is innocent.
Yep.
That is the reason we have a system of trial by jury, and then walk on into the into the sunset. And I mean, if Brennan actually made a comment like that, I'd give him respect. I don't think he's gonna. I think he's gonna either just no comment his way out of there, or he's going to say something like, we disagree with the result. The prosecution should never be disagreeing with the result of a jury. They put on their best case, and that's their job, right? You put on your best case, and the jury decides legally. So,
right. See if they're talking anymore.
And people are aware of what's happened. I gotta go.
What's the message? I got you, sir. I'm right behind you. I got you. All right, you.
They got everybody.
Wow. Yeah, they out. They're gonna bring Karen to an undisclosed location and open a bottle of champagne or 5 and celebrate a great day for justice. Man. Wow.
Christ, at this point, if I was in Massachusetts, I'd be volunteering to wherever she is, I'll sit in a car with a shotgun waiting to make sure nothing goes down. Because I'm already seeing people online basically going, and making not quite overt threats, but the subtle threats, and I'm like, ooh.
Are you seeing subtle threats already?
Oh yeah, I'm seeing one way or another, Karen Reed will get hers and that kind of shit, and I'm like, yep. So
forever mindful or forever MJ-ful said the way David cried when hearing the verdict, as well as the rest of the lawyers, they had their hearts in this. OMG, what a team. What a great group of individuals. Thank you for making history.
Man.
It was a lot. And it's, as much as I want to be on a high and be like, the system can work, I just keep coming back to, for this one person, for this one time, because all things aligned, that she was able to have supporters that helped her, lawyers that helped her, family that helped her,
Coffin Daffer just posted half an hour ago saying, I hope she gets the maximum of 2.5 years. It's like, well, by the time you posted that, she'd already gotten probation. So sucks to be you, Coffin Daffer.
Yeah, she had to turn. If you'll notice, she turned off the comments.
Yeah, well, that's kind of her go-to.
Yeah,
I'm also going to have to dip in 15 minutes because I've got what is it? I agreed to go on and do an interview with Law and Crime.
Nice.
And I'm sure they were like, where do you think the jury's at? Well, I've got an opinion.
On the evening of February 9th, 2004, almost 18 years ago, Maura Murray crashed her car on Route 112 in Haverhill, New Hampshire, never to be seen again.
The mysterious disappearance of Maura Murray is a story that's been told hundreds of times by strangers. But absent in the story you've heard are the voices of those who knew Maura, those closest to the investigation. Not anymore. I'm her sister, Julie, and from media pressure, this is the untold story of Maura Murray. Join me as I cut out the noise and reveal who Maura really was with exclusive interviews.
It's terribly frustrating. Fred Murray has been frustrated since the day his daughter disappeared with the response from police.
Peek into the investigation.
How did that happen?
Did somebody hit a wrong button?
No, I don't even have anything Maura Murray anywhere near my computer. I stopped sharing my screen. I tried to reshare a different screen.
The way that was shared, it seems like it was a direct upload to your backend. Someone clicked a
video
backend.
clip. Yeah, it's a video.
So
clip
someone on your backend clicked the play that video clip button.
Yeah, it had to have been. And Mandy's not even here. It had to have been you, babe.
I didn't, babe. I touched.
Guilty.
Okay, I mean,
We need another trial. We're going to spend $1 million on this. We're going to hire the Aperture guys, and they're going to paint themselves. I don't know. Well, I guess they might have to paint themselves pink this time, rather than the particular choice of blue paint. So,
Man, what a day! What a day!
we got a lot of supers to go through, babe.
Yeah.
I noticed it says comments 10,000. There's a few chats today.
Yeah.
333 super chats. You guys are doing pretty good. I have to at some point read the super chats that came in on my channel too.
Yeah, we will. Everything that came.
Wait,
through.
are they up here? Because I'll
No, because I'm not sharing that way. I'm the way I'm doing this. I'm not streaming it through StreamYard. I'm just capturing the entire window and streaming it in an OBS. We're doing it. We're doing it down and dirty style.
Yeah.
So you have supers that you have to answer as well.
Oh yeah.
All right. Well, do you want to read one of yours?
Let's see. I have to pull them up. Which where are they? Hold on. Was not ready for that.
I'm just saying. I'll
$4.99 from Robbie M. After all they've been put through to get to this point, the DUI OUI conviction is minute at most. Even the IUI conviction is still a victory for. I agree.
Yes.
It is absolutely a victory.
Absolutely.
Victory.
Oh yeah, and for whatever it's worth, that does mean she loses her federal firearms rights, so she can't celebrate by going shooting. That's very sad.
Is that
you can't go visit Ian?
I don't know whether it means that or not.
I actually have a hard time getting across the Canadian border.
That's my
which is
understanding.
unfortunate, because otherwise, if she came here, I would say,
Now what are we doing?
stop clicking buttons.
I didn't do a damn thing.
But,
There's something in your. I didn't do a damn thing. As she's holding up the remote in her hand.
No, that's babe.
Otherwise, I would say, if the U.S. won't let you play with guns, come on up here. I've got guns. We can go shooting. I've got a World War II Luger. We can go shoot that.
So wait, is that statewide? Is that federal? I'm unaware.
Yeah, 18 USC 928G.
Every
4.
state conviction of a DUI.
Well, no, because in this particular case, it's any sentence in which the crime is capable of being more than 1 year, and she was convicted to a crime that has a maximum sentence of 2.5, which qualifies.
Can I just also say that is some absolute bullshit? That the U.S. should, like, Canada doesn't take away your firearm ability because
But you can't even enter the country from the United States if you've got a misdemeanor DUI conviction.
I mean, she should be able to get her gun rights back. Like 100%.
Well, yeah, she can petition the Attorney General for returning of her rights, because they actually are doing that now. They weren't restoring rights for like 40 years, but they actually restored a couple pieces of rights recently. So she can petition the AG.
That's like saying if you're convicted of drinking alcohol, period. Like, how is it any different that you drove means you can't have a gun, but you drink and you can have a gun, but you just can't drink and drive and have a gun?
I don't know.
Is it any?
I don't invent these rules. I'm just here to tell you what the rules are.
Wow. Well, the therapist said at 8:30 this morning, why did the defense ask for OUI as a separate charge instead of a lesser included?
They had to.
The defense can't ask for a separate charge. That has to be an indictment brought by the prosecution. Are they betting the jury won't convict on the lesser, since that would mean guilty on full count 2? No, they were betting that they would convict on that if they felt the need to convict on something, and that would bring this case to a close, and their gamble paid off. It took a while, but it paid off. Boston Colleen says, do you guys think the media coverage is so intense that the FBI will feel it necessary to pursue the real story when Karen is acquitted?
No.
Nope.
FBI doesn't care.
Nope. What do you got for us on civil law?
In terms of what?
I don't know if you want to. I want to make sure you've got time to read in your supers. If you.
I mean, I'll do them later if I need to or something. But OSR for $10 said finally over. Thanks for the quality coverage on civil. And by the way, just want to say thanks for all the people that were tuning into me today. I really appreciate it. Really appreciate everyone's politeness and courtesy in the chat. We had a really good chat over there today. So a lot of fun today. And it is validating to me having so many people be there. It's like, you feel like you're doing something right. So having people tune in was very uplifting. So thank you for all that.
Yes.
Thank you, both of you, for joining us. This was amazing.
Yeah.
And you're on Court TV, you said tonight, or Long
Crime, I think. And I also want to give a shout out to Trooper Proctor, who I understand is right now collecting John DePetro's taillight and sprinkling them over some other crime scene.
Oh no, they're never going to get a conviction then. Oh no.
Where are they going to find? Where are they going to find snow today? I hear it's like 100 degrees. That's going to be challenging.
Well, no, it'll be the humidity level.
Oh, okay.
Used to the
it was buried under the humidity. I see.
Sure that I agree with you 100% on your police work there, Lou.
Drive down like OJ style. That's what they're airing right now.
But shout out also to the FBI for
saving
this by providing us with the ARCA and stuff like that. So they did some good stuff.
Where it came from.
Yeah, I'll give this little audio clip.
You ask for miracles, I give you the FBI.
Yeah, man, what a day. Yeah, I am so thankful that both of you came and hung today. Hung today. And
I'm just glad that the jury didn't hang today.
Right.
Tell me about it, man. Like, that would have been just a nightmare scenario. So it's always fulfilling when you have a day like this. It's kind of like you're living vicariously through that team, that defense team, if you've been on that side of the bar, because you know what that feeling's like.
Well, they hung for like 20 hours, which is longer than Brennan hangs.
Yeah. Because he's got that little blue arm.
Yes.
I love it.
Well, guys,
I mean, if Welcher gets fired, how's he going to afford blue paint?
It's going to be tough.
He goes through a bucket of that stuff a day.
He could get a job at many kindergartens across the state.
Also, I'd like to congratulate Burgess, who right about now is probably getting that notice of termination. I hope you have a great career ahead of you.
Gonna be 3 months.
Yeah.
The school applied to said, please don't even don't even try to come to our school anymore. We don't like it seeming like it takes 18 years to get a degree.
I think it's going to be like 3 months, and then they will say, we have decided to go in a different direction, or more likely they'll pull him into a meeting. At the end of that meeting, he will submit a resignation letter, and they will say, we offer our congratulations to Mr. Burgess, who has decided to pursue other opportunities in food service or, aluminum can collection. And
Lunch lady. So, all right, you guys plug your channels right now. I demand it. I know that we've been throwing them up in the chat, but tell everybody where they can find you if, for whatever godforsaken reason, they don't already sub your channels.
Well, I'll start because I promised my chat that when the verdict was announced, we would do a merch giveaway. So now seems like a good time if anyone wants to head over there. So we're gonna do 8 giveaways at $20 of merch. And that's in celebration of me passing 150,000 subscribers like 2 days ago.
Congratulations.
So
Wow.
I know. Yeah.
Well
so,
done.
So in honor of that, I'm giving away 8 times 20, which for the purposes of this exercise is 150. And we're going to do that over at my channel. And you can follow me at Uncivil Law. It's the cool place to hang with all the cool kids. We cover a lot of cases over there. We also cover a lot of Supreme Court stuff, and I'm behind. There was like 5 cases on Thursday from last week. There was a big case out of Tennessee today dealing with what was it? Dealing with gender affirming care. Tennessee banning gender affirming care came down from the Supreme Court today that I have to cover. So some controversial cases sometimes, covering a lot of that cases. So you can check us out over there at Uncivil Law. And for the moment, I'm looking forward to not doing streaming every single day. So that's great.
Oh man,
Subscribe if you haven't already. Let's get Kurt up to the 200,000 subscribers.
Let's go.
All right. Well, thanks, Kurt.
And
go do your giveaway.
All right, we'll do. Thanks.
Bye.
Thanks,
Bye-bye.
Kurt.
And you can track me down. I'm at Runkle of the Bailey. If you put in.
All right, guys. How you doing? We're going to do a giveaway. It's going to be fun. Yeah, I think we'll do the 8 times 20 thing. That sounds good. Let's find some clips that we can use so that you can enter. Hold on. Let's see. I need to set this up. Give me a second. Talk amongst yourselves while I set this up. And we'll do one thing that you only have to enter once, and then we'll just do 8 draws because that makes sense. I have to get rid of that little thing that's on my screen. So you only have to enter one time, and 8 people will win because I'll do 8 draws, and that will be good. Excellent. All right, so let's see. Let's see what looks good. Oh, this is perfect. All right, so now I have to set up the bot to look for the thing that you type into chat. Let's see. I go over to Nightbot so I can set it up so it can listen for the thing. Continue talking amongst yourselves. How do I sign in? I know. I just want to sign into the bot. Okay, great. All right, so I need to set up the keyword. Great. All right, do that. Great. All right, and then the name of this is going to be This is a lot of effort to go through. Lol. All right. Cool. Great. Why are there entries in the giveaway already? That doesn't make any sense. Reset entries. Yes, would I like to reset entries? Yes, I would. Yeah. Great. All right. Oh, Lord. I'm a competent streamer, I swear. Okay. Let me read the rules. What's the phrase? I haven't told you yet. I'm still trying to set things up. Castrol, give me a chance, man. Come on. All right, let me read the rules. These can be obtained by typing the command !rules. And they will tell you the rules so that you will understand the rules. But I will read them for you because we're doing this. All right. So here are the rules. One, first of all, it's void where prohibited. No purchase is necessary. You must be a subscriber of the Uncivil Law YouTube channel to enter. Paid membership is not required, nor does it provide any advantage. Drawing is at random using the giveaway feature built into Nightbot. Uncivil Law will provide you a phrase that must be typed into the YouTube chat on the channel Uncivil Law in order to enter. The phrase must be typed in all lowercase into chat exactly as provided by Uncivil Law in the YouTube chat. Variants or typos may not be counted. 1 entry per YouTube account. Winner must send an email to kurt@uncivillawllc.com before 5 p.m. Eastern Time the same day the contest runs. The email must include the winner's YouTube username. The email must include the item or items from the Uncivil Law merchandise shop located at uncivillaw-shop.fourthwall.com the winner wishes to select. The total price of the item selected must not exceed $20. If the winner fails to send the email by the deadline, fails to designate the items, or if the price of the designated items exceeds $20, the winner forfeits any prize. Fantastic. Okay, great. We all understand those things. And let's do the little giveaway thing.
Sidebar giveaway.
Okay, and the phrase, as told you by the wonderful video, the phrase is, we reached 150K subscribers, because that seems particularly appropriate. So please type that phrase into the YouTube chat, all lowercase. Please don't modify it. 1 entry per person, so forth and so on. Great. All right, let's go ahead and also, while we're waiting, we will tell you some of the fun, exciting items that you might win from the YouTube giveaway, merch giveaway, in honor of us hitting 150,000 subscribers. Thank you all for doing it. Remember, 1 entry per person, and we will draw 8 names. So 8 people will win, because that's how that works. They will be distinct people. Nope. All right, go ahead and keep typing that phrase in. Remember, you can type it multiple times just to make sure, but only 1 entry per person, but cool. So let's go ahead and get that started. All right. Let's look at our merch shop and some of the items you could win. Some people apparently don't understand what it means to type it exactly. I don't know why. This is why I have the rules, and people still don't understand. I don't know what I need to do, but that's okay. All right, let's look through some of the items you could win. All right, let's see. All right. Callie the Bee Fish welcomes you to the Uncivil Law merch store. Many fun items that you could win or buy. There's lots of cool stuff that for you and me, lots of interesting stuff for all the rest of it. So good times. I swear I should just like ban people who type like other versions of the phrase or something. I swear to God, they're just doing it deliberately. In any event, we have a not guilty, not guilty, not guilty shirt that is new. You could win this prize if you like, because it's less than $20. So you could get this shirt in pink if you like. You could get a ham sandwich thing. The verdict delivered at 227, but the verdict wasn't delivered at 227, so it doesn't make sense. We have a not guilty mug. That's cool. Very exciting. We have the ham sandwich mug. That's also exciting. Fun times. We have Don't Be a Hankhole. That's fun. We got Sidebark mug. We got, of course, Lexus in space, because your Lexus might suddenly wind up in space. All those things. That's a real risk. Truth is subjective. Proctor the Taillight Fairy merch. That's fun. That BS degree that you've been getting, currently pursuing that BS degree since 2008. Very, very real. Truth is subjective sticker because of aperture. We got, of course, unexpected black hole. One of our winners recently decided on this item. I think the person who won today decided on this item, or earlier today, one of them at least. So we've done multiple merch giveaways today. So one of our winners earlier today picked this item and was sent the code for that. So that's exciting. Sidebar drink glasses. Sidebar mug. Spinny fan, only fan. Merch. Don't be a dick. Always good stuff. Don't be a dick tumbler. Some ARCA stuff that you might like. Of course, we've got the Evidence Collection Cup 2.0. Clear. If you prefer a clear version, you could get that mug. Or cup. We've got House Long to Die in Cold, the sticker featuring Chloe. Chloe may be dead, but she lives in our hearts. The You Are Muted, You Are Unmuted mug, a couple people have chosen this recently. It says you are unmuted in green on one side, and on red it says you are muted on the other side. All those good stuff. By the way, did my mods announce the giveaway contest on Twitter or something, just to check, because I do want as many people to enter as possible. So did they announce this? And if not, like, now would probably be a good time. We've got the Uncivil Law mouse pad, which is back in stock. It was out of stock recently. I recently ordered that. That was cool. Evidence Collection Cup sticker. Got an Uncivil Law tote bag, although that's more than $20, so you'll have to pay for that one yourself. But you could buy that. That'd be good. We got the Uncivil Law Evidence Solo Cup in glass, of course. A couple people have chosen this one. So you can get that glass tribute to the solo cups that are Evidence Collection Kips in our right. Great. We got a large mug, so you can get the larger size mouse pad if you wanted. That would be fine. Learning from the misfortunes of others, someone recently who won picked this item. So you could pick that. The tumbler. We got, of course, Callie the Bee Fish. You might want a Callie the Bee Fish sticker. You can get the jumbo sticker. You could put it on your phone, like so. You could put it on the laptop or the back of a laptop so Callie can be with you in your journeys. The Uncivil Law logo holographic sticker. You enter by typing the phrase that I put in chat. The one I just put in chat just now. Type that phrase exactly. You can cut and paste it if you like. But type it exactly as provided, and that's how you enter. One entry per person. Of course, we've got a Callie the Bee Fish wanted poster. Mug, I designed this one. So that was an uncivil design. I also designed I designed this mug, the Learning from Misfortune mug. I designed, I think, the sticker. I designed the You Are Muted and You Are Unmuted mug. So a couple of these are me. Most of them are Jenks. Let's rewatch the verdict, shall we? I want to rewatch it. I want to rewatch that verdict being read because it was pretty quick. I was surprised by how quick it was. I really was because it was so fast. Let's see if we can watch. Okay, this is interesting. Let's see. All right, let's see. Let's see. I once like this is a version that's like complete, I think. Well, I don't necessarily think it has everything. I want the let's see this. Okay, NBC Boston, I think, is probably going to have what I need. Yeah, let's do NBC Boston. They'll have what I need. Okay. All right. All right, let's watch this verdict be read again. Because I, was with the panel. I'd really like to enjoy this moment. Personally, I'd just like to enjoy it. All right, cool. Let's watch this thing.
That they could hear the chants as those came out and those supporting either police officers or John O'Keefe or however they want to present themselves. At times they could be, yelling back and forth at each other. All of that was sort of in the back of that deliberation room. Yeah. And that's been eliminated this time. And you have to be impressed that the crowd is silent. I mean, they have held to that. Alan Jackson, the defense attorney, went up to them and said, you need to quiet down. And I believe, Glenn, am I correct, that that's when the international sign for I love you came into play?
All right, we're going to go inside the courtroom now. We can see that Judge Beverly Cannoni is back on the bench and she's about to address folks in the courtroom.
All right.
Let's listen in.
I appreciate you all getting back here. During the luncheon break, I received word from a court officer that...
Okay, that's the wrong moment. So I need to go up instead. I need to go, let's see. All right, let's...
12 jurors came to a conclusion on those 3 charges. We are now going live to the courtroom.
Will the deliberating jurors remain standing? Defendant remains standing. All other parties may be seated.
Your Honor, may the record reflect that 12 deliberating jurors and 6 alternates are present.
Yes.
May I inquire?
Yes.
Mr. Foreman, members of the jury, have you agreed upon a verdict? Yes. Thank you. May I see the papers? Mr. Foreman, have the verdict slips been placed in this envelope and have they been in your presence ever since? Yes.
So fast.
Mr. Foreman, on docket number 2282CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty? Not guilty. So say you, Mr. Foreman? So say you? No. Do you agree? Yes. Do all of you agree? Yes. Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty? Not guilty.
Of?
Is not guilty or guilty of that charge or any lesser included charge? Lesser included. Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct? Yes. So say you, Mr. Foreman? Guilty. So say you all?
Yes. Guilty.
003, what say you? Is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty? Not guilty. So say you, Mr. Foreman? Yes. So say you all? Yes. Jurors, hearken your verdict as the court records it. You, upon your oath, say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
All rise. Your call me.
Defendant Karen Reed has been acquitted in the murder of her boyfriend, John O'Keefe. Karen Reed has been acquitted in the murder of her boyfriend, John O'Keefe. However, this jury found that she is responsible, that she is guilty for one of the lesser included offenses, and that offense is operating a motor vehicle under the influence of liquor. Let's listen in again.
Found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the request not to seal form, which is posted on the trial court's website on mass.gov. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, you will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
Okay, we would be prepared to go forward today.
Okay. Okay.
All right, they just said they're looking to set a date for sentencing. Prosecution says they are prepared to move forward today. I think the most startling part after we heard the verdict was the volume of the cheers that you could hear right
You could hear it very clearly.
The courtroom.
Very clearly, you could hear those cheers. And sentencing, as you mentioned, JC, would be the next step. It probably will happen today. We know from our own research that the offense could be punished up to 2.5 years, but that is very rare for a first offense. Probation is more likely for a first offense, so we'll have to see what the sentencing is ultimately. Looks like there are some things getting worked out inside the courtroom. Let's listen in again.
So the standard that everybody else gets on a first.
God damn it, talking over the court. Fuck you. Fuck you talking over the court. I'm trying to listen to what the court's saying. Fuck you, NBC Boston. Fuck you. God damn it. Can I get a clean feed so I don't have to listen to some bullshit as I'm trying to listen to what's going on in the court? Fuck you. When the winner's announced, well, I was giving as much time for people to enter as possible. I haven't announced a closing of it. So, but yeah, I should announce it because the winners are supposed to enter before 5 p.m. Eastern time by the rules. And they only have like 40 minutes. So yeah, in the interest of picking the winners so that they have time to send the email. So they'll have 40 minutes because they have till 5 p.m. Eastern time. So that's coming up pretty soon. Let's go ahead and do the drawing now. Or I'll tell you what, just to make sure that, you all have had a chance to enter, I will give you 60 more seconds to type the phrase from now. So if you would like to type the phrase, you have 55 seconds as we speak to enter the phrase. The phrase is exactly this. You can cut it, you can paste it, you can type it, please, exactly as provided. There are 147 of you currently entered. So, you can type it again if you want. Just saying, because, you can enter once. So if you want to be sure, that'd be fine. And we're just going to do eight draws. You've got another 20 seconds. What is the email? The email is contained in the rules. Read the rules. It will tell you what to do. That's why they exist. All right. Okay, let's do it. Zark winners. Congratulations, Zark. Congratulations, Untamable. Congratulations, Rebels Waltz. Congratulations, Matthew Manor. Congratulations, Miss Mandy Reacts. Nice. Congratulations, Petrified. Congratulations, 24 Hours In. And congratulations, Carla 45. You are our winners. Congratulations to all of our winners. The entries are now closed, and congratulations to all of you for winning. Exciting. You all get up to $20 worth of items. You've got about 40 minutes to send the email. What's included in the email is contained in the rules. Read the rules. It will tell you what to send. I have had people not win because they did not follow the rules. I've had to send emails to people being like, nope, that wasn't what I asked for. So please try not to be one of those people. That'd be great. All right, fantastic. I am not re-rolling today, Miss Mandy. If you don't want it, you can forfeit it, but I'm not re-rolling it. So if it's yours or nobody's, that's the way we're doing it. I'm not re-rolling. So it's yours or nobody's. Pick one. You don't have to send the email. You don't have to claim it, but that's the deal. Great. Let's watch this again.
You are unmuted.
Will the deliberating jurors remain standing? Defendant remains standing. All other parties may be seated.
Your Honor, may the record reflect that 12 deliberating jurors and 6 alternates are present.
Yes.
May I inquire?
Yes.
Mr. Foreman, members of the jury, have you agreed upon a verdict? Yes. Thank you. May I see the papers? Mr. Foreman, have the verdicts been placed in this envelope and have they been in your presence ever since? Yes. Mr. Foreman, on docket number 2282CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty? Not guilty. So say you, Mr. Foreman? So say you? No. Do you agree? Yes. Do all of you agree? Yes. Thank you. 002. What say is the defendant at the bar not guilty or guilty? Not guilty.
Of.
Is not guilty or guilty of that charge or any lesser included charge? Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct? Yes. So say you, Mr. Foreman? Guilty. So say you all?
Yes.
003. What say is the defendant at the bar leaving the scene after accident resulting in death? The defendant not guilty or guilty? Not guilty. So say you, Mr. Foreman? Yes. So say you all? Yes. Jurors, hearken your verdict as the court records that you upon your oath say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back to services complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
All rise.
That was pretty quick. Yeah, that was quick. And that audience that crowd outside is real.
Media, please exit the courtroom immediately. Karen Reed.
Not yet.
Hold on, everyone. Karen Reed. Ms. Reed, can I have your attention? As required by statute, I must inform you that the records regarding the charges that you have been found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the request not to seal form, which is posted on the trial court's website.
I don't even know what that means in this context.
I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, you will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
We can. We would be prepared to go forward today.
Okay. Okay.
Sidebar. That was kind of a sloppy reading of that, like with like guilty or not guilty. It's like, well, there's multiple options. So what exactly are you asking me? It's like he seemed confused. The clerk seemed confused. Has he been drinking today? What the deal? And also, I don't know what it means to seal the records with respect to the not guilty convictions in this context. What does that mean? Like, if she'd been found not guilty across the board, I understand what that means. That would just be sealing all the records. What does it mean to seal records with respect to the not guilty when she was found guilty on some? What does that mean? What records? I don't know what that means. Does it mean anything? I don't know. I don't know what it means. I don't know if there's anything to seal. I'm confused.
All right, so Ms. Giannetti, you're ready to go forward today as well?
Yes, please.
No one can read the form? I guess, but what's the point? So I suppose you could seal literally the verdict form itself, but what would be the point? I mean, I don't understand. The fact that she was found not guilty at all, do they literally seal the fact that there was like even a charge at all? Do they seal that? I don't know what it means.
Mr. Brennan, what's the Commonwealth's recommendation?
Your Honor, the Commonwealth moves for sentencing. We recommend.
All right, so Ms. Giannetti, you're ready to go forward today as well?
Yes, please.
Okay, Mr. Brennan, what's the Commonwealth's recommendation?
Your Honor, the Commonwealth moves for sentencing. We recommend Probation, 1 year, 24D program.
So the standard that everybody else gets on their first time OUI?
Certainly.
Okay.
We ask that she be treated no differently, no better.
So I'm happy to do it.
Thank you.
All right. Thank you all.
1 year probation, 1 year probation on docket number 002, the lesser included offense of operating under the influence. 1 year probation. Thank you. The 24D program. Thank you.
Immediately. All right.
Goodbye.
Goodbye indeed. Goodbye indeed. Goodbye forever. Goodbye indeed. Goodbye forever. What a moment of catharsis. What a great moment of catharsis. How wonderful. Is that Bev over my shoulder? You bet your ass it is. You bet your ass it's Bev over my shoulder. She looks upon me just like she looks upon you, with that scowling demeanor that we've come to love. And we may never see Bev again. That's very, very sad for all of us to contemplate. I know. We may never again see that woman or hear her voice. I know you were all disappointed. That is very sad for us all. I understand. The first envelope that they didn't open, that is not what they were referring to. That was going to be sealed in it. That was going to be sealed no matter what. That is not what they're talking about when they're talking about sealing records. That was always sealed. That is sealed. Yeah, that is always sealed. No one's ever going to know what's in that envelope. Probably. Yeah. I have to say, I do really like that color suit. We were discussing earlier exactly what it is. I said maybe lilac. People in chat were saying maybe it's a powdered French blue. I heard. I'm not exactly sure what that means, but okay. Powdered French blue, I heard. But I like that color. Let's turn our attention outside the courtroom for a while. Yeah, 24D is it's just the name for the program. Someone on the other chat looked it up. It sounds like it's like 90 minutes. It's 90 minutes a week for like 16 weeks, and you get to learn that alcohol is bad for you or something. That's apparently what it is. That's yeah. Okay, yeah. Do I have color blindness? No, I don't have color blindness. What the fuck kind of question is that? Fuck you. McCabe put out a statement. That's exciting. We'll get to that in a second. We'll get to the statement from McCabe in a second. Periwinkle? Periwinkle works. Oh, you can't see. Sorry, my bad. Sorry, my fault. My fault. That crowd is amazing. Leslie trying to do his thing. I'm not feeling that.
I just want to say two things. Number one is I could not be standing here without these amazing supporters who have supported me and my team financially and, more importantly, emotionally for almost 4 years. And the second thing I want to say is no one has fought harder for justice for John O'Keefe than I have and my team. Thank you.
So you want to see it reopened? Karen, you want to see the case reopened? Should the case be reopened?
No, the case cannot be reopened.
Alan,
this case is over.
No, I mean the case is searching for someone else. What did you say? Just what did you say about justice?
I'm going to leave it. I'm going to leave it to Karen and her dad. Her dad has a comment. Let her dad make a comment.
Mr. O'Keefe, what did Thank you, Mr. Reed. I want to acknowledge the strength of our daughter Karen, the support of the entire Reed extended family. I want to acknowledge the greatest team of attorneys. Our first one that we found was David Yannetti. We added Alan Jackson and Liza Little.
I don't think it's absurd to describe that as a very light purple. I don't know, man. I don't know. Yeah, I mean, yeah, I don't think I'm absurd for saying that that is a light purple. But you know, whatever, I guess. We have a disagreement about the color of the thing, I suppose.
Verbalizing, you know about. All right. It was a fantastic team, but we needed them all to defeat this. We thank everybody for their support from the heart. We love you all of the content providers who help spread the word. Thank you so much. God bless you all.
You think it is absurd? The color of Karen Reed's suit. The thing I was talking about earlier when I said I wasn't sure what color it is, that would be the thing I was referring to. What color is her suit? Yeah, I mean, yeah, yeah.
Thank you so much. God bless you all. The investigation.
Let's do this.
Yeah, I mean, yeah, lavender. Yeah, one of the guides I'm looking at is calling it a lavender, which is kind of a purple. Yeah. All right. So. Yeah, I wanted to look it up. All right, cool. Very, very cool. Very, very nice. Awesome. Excellent. Very good. All right, so let's read some super chats that came in. And I guess give this stream an end. Or unless we want to have further debates about the color, I guess. Let's see what we got. Lone Star Medic gave $10. Adam Trapp gave $5. Lone Star Medic said, thanks, Kurt. Thought it was funny and that con law wise significant for future cases with the ethics statement. Also, thanks you for reading. Alex Witterud for $5 said, just call yourself Shannon the Tech Stream Clock. It's feature not bug to be 8 seconds off. Yeah. Lone Star Medic for $5 said, here's an R5 for the portal reference. Thank you. And on the joke for $5 said, can the jury find them guilty without finding her guilty of manslaughter? Yes. Red Guy 1234431 said, is she just guilty of DWI, not guilty of manslaughter? So sentencing for the random dead body in the snow would be irrelevant. Under Massachusetts law, that's correct. Mopsy became an uncivilian. In on the joke for $5 said, in your opinion, should jury be able to hang on to OUI without hanging on the manslaughter? Should they be able to? Probably. Cervantes for $2 says, I prefer can't understand normal thinking. Thank you. Karen Cars 10 said, if one of the questions asked if we think she was framed, what box do we check? Nice. The Chugi Show Live for $4.99 said, how is it they aren't able to just find her not guilty on everything? I don't know. Maybe the jury will provide us some insight down the road about what they were thinking and why. Kiwi New York Upstate for $20 says, why can't they just have an open discussion with drawers and both sides of the case to actually resolve instead of sending cryptic questions and responses back and forth? Just the way that we've been doing things forever. And that's one of the reasons, like, it's just tried and true in what we know. The system, you know, the devil, you know, and all that. Frenchie's mom gave £6 or 6 years to say congrats with 150K. Miss Mandy Reacts sent a super chat or sent a gift membership. Karen's Cars 10 said, jury question number 5. Can we cross out the name of defendant and write in other people on the charges? Yeah, really. D Echo became an uncivilian. Karen Cars 10 sent 10 gift memberships. Deftonese Anthony sent 5 gift memberships. Goo Eyes sent 20 gift memberships. Tony P sent 10 gift memberships. Ocean Beach for $4.99 said, you notice the question in the jury called her Karen, not Miss Reed or defendant. Was it really the defense who added it? No, it seems like the defense added it. That was definitely what it seemed like to me. Greg asked for $5 Australian. Can you all talk about the worst judge you've had and why? I don't do a lot of trial cases. My work was mostly transactional, so I can't really intelligently comment. But this judge is worse than any I've seen by far. Morel became an uncivilian. Christy sent 10 gift memberships. Cody for $5 says, is it likely that after this trial that Bev ends up censured or impeached? Absolutely not. No, 100% no. She will continue doing what she does. There will be no penalties or sanctions for Bev or Brennan of any description. No. Michael Crandall became an uncivilian. Michael Crandall says, Chloe's been found. She's been seen in a telescope in the backs of a Lexus SUV in space. James Carson sent 5 gift memberships. Violet Lotus said, when they choose jurors, do they ask about personal past experiences relating to OWI? They might have. I don't know. It might have been on the jury voir dire form or not. I don't know what questions they asked. And incidentally, the voir dire itself was not televised, so I don't know what questions they asked. Paul Young sent 5 gift memberships. Keila Mila 0513 became an uncivilian. Gabriel Sparks sent 20 gift memberships. E. Laydown for 999 said court will be closed tomorrow on June 19th. Does the jury want to wait until Friday to keep deliberating? Apparently not. Jin Decker sent 5 gift memberships. Elise Newell said, if the jury 6-6 to the DWI after the Allen charge, what happens? That would mean they would hang on all of count 2, which would allow the manslaughter to come back. Just Rhonda sent 10 gift memberships. Trevor Smith sent $5. Welsher is selling the Lexus to himself through a straw buyer. Anna Long for $5 said, let's say a McAlbert or Higgy or Proctor had a pang of guilt and flips. If they came forward, would that drop the case immediately? Probably not. The Shuki Show for $10 says, we may be dealing with a jury that feels like they aren't providing a satisfying resolution to who killed John if they find her not guilty. That may cloud their judgment. Perhaps. People do want a resolution, so that's fair. Westy Ware Dog Kilts became an uncivilian. Bob sent 5 gift memberships. My cast name is sent 5 gift memberships. The Mike Rep for $5 says, there's no statute of limitations on the misdemeanor OUI. There probably is, but it was a lesser included of the felony, so it comes along for the ride. Just Rondi sent 5 gift memberships. Lynn Britton for $5 says, my mom was hit by a car Monday, thrown 15 feet. None of her injuries are consistent with JO. Thank you. Golden Hermit for $4.99 said, the trial's the punishment for OUI, not guilty, done. Let's get her home. Kiwi New York Upstate for $5 said, seeing how the world is flat, her SUV definitely hit him. Y Page for $5 said, since his CV said pursuing bachelor's, would Brandon have actually asked about a degree? Just so he couldn't answer the question, he hasn't gotten it yet? I don't know. Helen Queenie for $5 says, what's everyone's theory about the dollar bill size of 34 Fairview? I think it was broken at Waterfall, Higgins through glass. Maybe. Maddie Reitman for $4.99 says, if Proctor collabed with Aperture, they could very easily turn into Megamind with their blue paint. Fair. Nikita Dicta for $1.99 said, jury holding out to fuck with Bev, not guilty. If they really wanted to fuck with Bev, they could have just asked every thought that crossed their mind. Just send her questions that are unrelated to anything. Just send her random questions. That would be the way to fuck with her. Mark Lynn for $4.99. If no verdict today, anyone willing to give odds on the Commonwealth trying to bump a juror by Friday? Yeah, I think that the fact that we didn't have a juror bumped off this case was amazing, right? Westy Ware for $5 Australian says, if I was a juror and the first set of questions were basically answered with figure it out yourselves, I can't answer, I would not want to ask more questions. Fair enough. MN for $4.99 said, do you think it's possible at this point that they're hung on a different part of count 2 and not the DWI part? I don't know what they're hung about, and I don't necessarily want to draw any conclusions. I don't know. Maybe there was one person who wanted to convict on maybe it was 11 people who were ready to convict on the DWI, but one person really wanted to convict on manslaughter. Maybe that was the thing that had to change. I don't know. Maybe we'll learn more if the jury talks to us and tells us, but I don't think you can necessarily draw any conclusions about who was hung up on what. Richard Arnold for $5 says, a courthouse HVAC renovation has got to cost less than what Commonwealth paid to Aperture. I don't know about that necessarily. This is probably a historic building. So any renovation that would be done is probably prohibitively expensive, assuming it can be done at all. But thank you. JTH839K said $4.99. How can 5 a.m. for DWI be allowed as lesser charge for a charge that took place at 12:35? It can't really, but that's the universe we're in, apparently. Depend Girl became an uncivilian. Depend Girl sent 20 gift memberships. Kyle from South Park for $2 said, wouldn't be surprised if the jury quiet quit. Rosemary J for $5 says, Karen team on the way back to court. Miss Mandy for $2 said, free Karen Reed, not guilty 100%. I dig in too. Mark Lyon for $1.99 said, need DiPetro's blood serum results 6 hours from now. Yaroslav Nikchev said, Alessi is guilty of first-degree murder of the state's case for $4.99. Kim Jong-un for $4.99 said, even glorious North Korea isn't bad like this court and judge. Yashlof for $1.99 said, we got a quantum verdict. Jorge Guzman for $2 said Schrodinger's verdict. The KKF 101F for $5 said, This is jury's revenge for all that BS they had to deal with during the trial. Michael Crandell for 499 said the jury's verdict was sucked into a mysterious appearing black hole and appeared in a Lexus in space and was eaten by a dog. Facts. Billy's Momazilla for 279 Canadian. Bev will pull only if all not guilty. Well, you saw what they did, so yeah. Don Lionheart for $2 said Rick Rolling is 18 years old. Great. Just Rhonda for $2 said Court TV Sharon said verdict's in. Apparently it was. Chop Trials for $4.99 said I'm a new subscriber to Defense Diaries because I still don't understand Rick Rolling either. Which student which? Can someone explain the 227 curse? That was the time of the deleted call. It was 227. Or deleted text message, the deleted Google search. The KKF101F said waiting for a verdict is like Burgess degree. They say it happened, then didn't, and seems like we've been trying to get it since 2006. Yaroslav for $2 said bathroom breaks on jury watches for the week. Entry required for 20 SEK said, will jury poll calls a mistrial? No, it's perfectly standard. Roan Cowart for $5 said, laughing my fucking ass off. Less probation than a Minnesota lawyer got. Mama 6 became an uncivilian. Monet sent 10 gift memberships. Robbie M has been a member for 27 months. Robbie M sent 5 gift memberships. Janine Emerald for €249 said, faith in humanity restored, love you, Karen. Jules for $2 said, can she appeal just the DWI? Yes, she can. I don't think she will. For every possible reason, I don't think she will. But she can. Candy Marie sent 50 gift memberships. Very, very generous. Thank you, 50 gift memberships. It's very nice. Bobby Dread for $5 says, thanks to you all on Uncivil Law Stream for your humor, insight, analysis, and perseverance. Congrats to Karen Reed, free at last. Michael Crandell for $4.99 says, does John's family have a civil claim against Canton PD for mishandling of the investigation? No, they don't, because there is no duty there. Space Emerald Doll for $2 says, probation means she can't leave Mass, right? I don't know the answer to that question. I don't know what the standard probation terms are. I don't know the answer to that question, but that's I don't know. Joseph Fazio for $4.99 says, at least one read wins this summer. Fantastic Four will suck. Robbie M for $4.99 said, after all they've been put through at this point, the DUI OUI conviction is minute at most. Even most of the OUI conviction is still a victory for her. $10 from Melissa Soar. Finally over, thanks for the quality coverage. Marvin CZ sent 50 gift memberships. Very, very generous indeed. Thank you. Subpoena Colada became an uncivilian. B. Frank has been a member for 4 months. Mama Belts has been a member for 23 months. Jacob Papoff, 6 for $1.99 said John's family was not there like they knew. Maybe. Heidi for €5 said, thanks for the coverage. I had a blast. Rosemary J for $10 says, once again, I'm proven right. Once again. I do try to get it right as much as I can. Greg S for $5 Australian said, McCabe family statement regarding today's outcome was pathetic. We'll read it in just a second. Greg S for $5 Australian said, appreciate your coverage, Kurt, 6 a.m. in Australia. Violet Ellie said, thanks for covering this trial, Kurt. You're welcome. The Bob 3 for $2 said, DUI guys X, McAlbert's made a statement. We'll cover it in just a second. Beach Nut for $4.99 just gave me that. And Leslie Howerton said, I never cried until a verdict until today for $4.99. Thank you very much. That's very cool. Let's take a look at this stupid statement that was put out and see what we can do in terms of the stupid statement. The stupid statement from Jennifer McCabe, Matthew McCabe, Chris Albert, Julie Albert, Colin Albert, Nicole Albert, Brian Albert, Kerry Roberts, and Kurt Roberts. Today, our hearts with John and the entire O'Keefe family. They have suffered through so much and deserve better from our justice system. While we may have more to say in the future, today we mourn with the John family and lament the cruel reality. This prosecution was infected by lies and conspiracy theories spread by Karen Reed, her defense team, and some in the media. This result is a devastating miscarriage of justice. Well, fuck you too. Fuck you. Fuck you and your stupid thing, and fuck off. All right. Apparently, if she, I don't know whether or not this is true or not. If she successfully completes the 24D program, they don't get a guilty verdict. I don't know whether or not that's true. So it might be true. It's possible that if Karen Reed, well, I don't know. It's possible that if Karen Reed completes the program, that maybe the verdict goes away, but I don't know. I'd have to look up the specificity of state law. Apparently a movie is coming relating to all this. So that's something to look forward to. Like, we don't already have enough movies relating to this somehow. Who will play the parts? That's the real question, right? All right, is there anything more for us to discuss right now? Not really. A pardoned Proud Boy is apparently suing the U.S. government. That sounds like stupid. When it take conditional discharge? Well, maybe, but maybe it's by operational law, right? Maybe it's in the statute. See, that's what I'm thinking, right? So maybe the statute says something on this point. So a conditional discharge would be one way of getting there, but it's possible there's something in the statute, which is like wise, like I'm not sure, because I don't know exactly what they're quoting from. So in some situations, it might be a conditional discharge. I mean, this is guilty by a jury. So I don't think it's true. That doesn't sound right. But since I can't swear to it, it's like I'm not sure. It doesn't sound right, but yeah. Let's see what's going on Twitters for a second. Robert Downey Jr. I like how you won't speak to something you aren't sure of. Yeah, well, I like to be a good legal education channel, right? And so it's like, well, you know, it could be true. It could be true. I mean, it sounds plausible that, you know, it sounds plausible, although a bit unlikely, because this is just a straight guilty conviction. So in some situations, it might be part of a conditional discharge, but this wasn't a conditional discharge. This is a straight guilty. So the only thing left is that the statute itself provides that, you know, if you do something, therefore something. Like, I mean, that could be the law. The legislature could have passed that law. I don't know. But, you know, it's possible that, you know, despite the guilty plea of X that, you know, still somehow it still goes away. Doesn't sound right. Doesn't sound like something the legislature would do, but they could have. So, you know. I think I got this case about right. You know, I think I got this case about right. And we still don't know, by the way, and I think it's worth making this point. We don't know, and maybe the jury will tell us more, but as we sit right now, I don't really feel that we have information about exactly where the jury was hung, right? We don't know if it was like, we don't know if it was a compromise thing. We don't know if like 11 members wanted to convict, but one member just wanted to straight not guilty and they had convinced the one person, or maybe 11 members were ready to convict and one person wanted manslaughter and that was the compromise. Like we don't know. We don't have enough information to know where the problem was, we just don't have enough information. So, you know, I think that, and I still think like, because I never factored into when I was doing predictions, I never factored into or attempted to, I never factored in and never attempted to factor in like information relating to demographics or age or anything like, so I never tried to factor that in. My predictions were based off like just 12 random people. And like, so I think, you know, I think my predictions were reasonable, even in retrospect, you know, with the odds, you know, the 20% chance to convict thing seems like a reasonable bet, even in retrospect, but maybe we'll learn more. But like, even if we learned much more from this jury, I'm not sure how much it would change, because my predictions were based off of like any random group of 12. So even if this jury is like, we determined that we weren't going to do the manslaughter like within the first 5 minutes, and then we spent the remaining 20 hours talking about the DWI, I still don't know if my prediction is wrong, although one could quibble on that about that, but whatever. You love the background with Norman Rockwell? Thank you. I love Norman Rockwell too. Actually, they're both Norman Rockwells. There's Norman Rockwell to my right and left. So we got 2 Norman Rockwells. All right, mods, is there anything more that we should discuss? I mean, we could discuss U.S. Supreme Court stuff, although we could also do a separate case about that or a separate stream about that. But, there's 1,000 of you here, and so that's fun. So we could talk about U.S. Supreme Court stuff because some interesting U.S. Supreme Court stuff happened today that was controversial. Is there what more should we talk about? Is there we could try to watch Aidan Kearney's, we could watch Turtle Boy's live outside the courtroom. We could try to watch that for a while. Let's watch Aidan Kearney's thing for a while. Let's watch Aidan Kearney for a while and see if we get anywhere. It's going to be a little potato because there's a lot of people there and the bandwidth kind of sucks, but it's going to be a little potato, but we'll do what we can.
Not guilty, folks. Not guilty. Not guilty, not guilty, not guilty. Not guilty, not guilty, not guilty. It's over. Fucking over. Let's go. All right, guys. Outside Northfield Superior Courthouse. There are thousands of people here, dude. Thousands and thousands of people. Copters all over the place right now. When I was inside that courtroom and I heard those magic words, not guilty, not guilty, not guilty, it took about 20 seconds because of the delay, and then I heard it. I heard the explosion, and it was deafening. It was deafening. This is the most amazing. I have dreamed about this day for so long, guys, what this would feel like, and it's better than anything I could ever imagine. It's better than anything I could ever imagine. This is the most validating thing ever. And it's over. It's over. Karen Reed is never going to jail. Karen win the towel. He could have asked for 2.5. They convicted her of DUI. He could have asked for a sentencing hearing. He could have asked for 2.5 months in jail, but he didn't. He asked for probation because he will never show his face in the courtroom again. It's too humiliating. He will never show his face here again. Hank Brennan's too much of a coward to ever show his face in this courtroom again with that stunt he pulled over the last 9 months. Ever. He signed up for this. He couldn't do the job Adam Lally could do. Adam Lally convinced 9 morons that John O'Keefe was hit by a car. Hank Brennan couldn't convince a single one of them. Not one person could he convince. Not one that John O'Keefe was hit by a car. He signed up for this. He took your tax dollars, took close to $1 million in your tax dollars to put together this farce. He knows that John O'Keefe wasn't hit by a car. He knows it. And he did it anyway for the money. For the money. That's all he did it for. And for the notoriety. Well, now he's famous. Now he's got that notoriety. And it's because he's the biggest loser. Hank Brennan is a loser, and John DePetro knows it. John knows what a loser Hank Brennan is. Look at him. What a loser. 2 losers drawn to each other. Loser. Hank Brennan is a loser. He lost. He lost. And he got paid $1 million or so of your taxpayer dollars to lose. And the way he put that defense together, that prosecution together, was the shittiest scumbaggery I've ever seen in my life. All the tricks he tried to pull. And guess what? Didn't fool a single freaking person. Not one person on the jury was fooled by his bullshit. Not one. What does that tell you? Not one. 12-0. 12-0 not guilty on all three counts. They threw in a DUI. And Hank didn't even want to go to the sentencing. He didn't even ask for any time in jail for that, because that would require coming back here for a hearing, and he's not man enough to do that. He's not man enough to come back here, face free Karen Reed, like the loser that he is. He's going to go talk his shit somewhere else and continue to disgrace himself. But the stain of what he did here for the last 9 months will forever be on him. Will forever be on Hank Brennan. Shame on Hank Brennan for what he tried to do to Karen Reed. Shame on Hank Brennan for lying, to continue to lie to the family. And I continue to believe this complete farce that John O'Keefe was hit by a car. John O'Keefe was not hit by a car. John O'Keefe went and said Brian Alberts got the shit kicked out of him and a dog bit him. And then they threw him on the lawn like trash. And in his closing, he had the audacity to suggest that Karen Reed had a problem for using an analogy about a buffalo on a prairie. They treated him like trash day on Tuesday. That's the way they treated John O'Keefe. So I don't hear a word from Hank Brennan ever again. Ever. I hope this follows him forever like the loser he is. That's what he is, a loser. So we're still waiting out here. I have not had a chance to see the Reed family yet. As soon as the verdict was read and the sentencing was put in, they immediately whisked us out. I didn't get a chance to hug the Reed family like I wanted to, but I was able to kind of do this thing with Reed, with Janet Reed, with Karen Reed, and so I'd like to see them before they leave. I mean, that'd be cool. Where's Kelly?
Kelly will be near there when they're coming out.
Where's Kelly?
Sure, we'll be able to see. I think near the
Okay.
car.
I'm gonna go down near the cars. We're gonna go down to.
I know.
Yeah. Canton cover 1. Now we're up to part. Canton cover up part 520. Not guilty. That's it. That's the whole type. Not guilty. Not guilty. Not guilty. There we go. That's the next. That's the final installment of the Canton cover. I am live. We have 40,000 people live right now on my stream. Holy shit. Yeah, we have Kelly Reed here. This is Bill Reed's first cousin. Yes, Kelly is free. Kelly has been here for the entire process, going to all court hearings. You know, she loves the family. Her and I become friends throughout this process. It's just amazing. It looks like we're in some anticipation here, folks. We're so confident. Where's she from? There she is. Can you hold this for me?
Oh, hi. You can get it on the here. You can get it on the live. How do I turn it around? Turn it around so you can get it.
I can get it here.
Right here.
Yep. Not gonna try it. I have to flip this cam, guys. So we can't hear anything now. It's too loud. Too loud. It's just crazy. This is too crazy here, man. It's too crazy. So you try and close.
Go, Maiden, go ahead.
Okay, I'm coming. I got swept up in the garage.
Thank you. Thank you.
From all of this, all of these shots. We need to know right back to that individual. Everybody's going to support behind these issues. Can you start the motion now? What went through your mind? Tremendous thanks to Almighty God, Jesus Christ, relief. Thank you.
Over. Thanks, Anna. It's over. Yeah, baby. 2000. That's right.
Another year with information circulating in the public. People are aware of what's happening.
Not right now, John. Not right now. Getting an interview right now.
I don't think you saw it, right?
John, what about some of these people? Deanna's here. Yeah, how are you? So you got it for us. Congratulations. So proud of you. I'm so happy on you guys. You guys did so much. Thank you so much.
You did it.
Thank you, sure. Appreciate it. Congratulations, you guys did this. The interns did this, guys.
Hey, we need a
First legal experience. Yeah, we're gonna get something.
save this.
Thank you guys. You guys are the unsung heroes of this. You guys are the unsung heroes. Whew.
Thank you.
You guys are gonna have great legal careers. What a start. What a start. They couldn't have done it without those guys and gals. They were the brains behind the operation. Brains, wow. Whew. What an emotional experience. What an emotional experience, folks. 56,000. Let's go. Let's go. Let's go check the crowd out. Emotion. Oh, it's over, brother. Thanks, man. Appreciate that, man. How we doing, guys? There it is. This is it. Thank you, guys. Thank you so much. Thank you, guys. See you then.
We did.
Yes, we did.
Full circle.
Yeah. Kevin's himself. Wow, that's intense. Thank you, Allison.
Try to blow yourself up?
Yeah, sure. There you go. You're welcome.
Yes. Yeah, sure. Thank you so much. Yeah. What's going on in your heart? How are you feeling right now?
Overcome with emotion. It's the most emotional, intense feeling I've ever felt in there, and I wasn't the one on trial, but I feel like I was. I've been covering this for 2.5 years. I've got my own charges out of this, and just getting to know the family, and what I've been thinking about this day for 2.5 years, what it would feel like, and this is better than I thought it would be. It's just amazing.
Do you take some credit to, this case just becoming so high profile? I know you were following it from day one and, all the interviews and things that you did. Do you take a little bit of credit for?
Well, I don't want to sound too cocky, but I think I had a little bit to do with the crowds that you're seeing here right now. And of course, the money that was raised, that was the big thing. We raised over $1 million for Karen Reed's Legal Defense Fund. Without that, there's no ARCA. There's no Dr. Laposada. This stuff costs money. Flying these lawyers in constantly, voir dire hearings. That stuff adds up. And so I built the apparatus and the infrastructure here that allowed Karen Reed's legal team to be able to go to dinner, eat food, get experts, and it all paid off. You saw what it got you there in the courtroom.
There were many layers to this case. What do you think drove the crowd of supporters' passion to just keep supporting Karen Reed and to keep advancing this case?
So what I think drove their passion for me is that she's obviously innocent, and anybody can identify with this because everybody's got a sister, everybody's got a mother, and they imagine themselves as a Karen Reed. What would you do if that was somebody that you loved? I have a daughter. What would I do? I look at Bill Reed. He's like a model father. Like, I want to be like Bill Reed, when I grow up. I want to have that kind of relationship with my daughter that Karen Reed has with her daughter. And so it's just that they have a beautiful family. That's why we're out here. And everyone in their life has met a Jen McCabe, a Brian Albert, a Colin Albert, and especially a Michael Proctor. And they know, they can relate. It was a very relatable story.
I'm just curious, do you think now you also maybe advocate to see what really happened to John?
Oh yeah, I mean, I'm never going to stop. I mean, but it's really, I don't have the resources that the FBI has, So I don't know what, I hope their investigation is ongoing because John O'Keefe's murderers are still free. People who killed John O'Keefe are still out there because this jury decided 12-0 that person wasn't Karen Reed. And so I hope that the Norfolk County DA's office pursues that, but I won't hold my breath.
I won't either, man.
Free Turtle Boy. I have it back here on July 7th. I got my own charges that I picked up from my activism in this case. So I will be back here 7th for a retrial hearing.
And what other case?
As far as crime stuff goes, this is the first jump in crime, so I don't know.
A lot of questions for cases.
Oh, for sure. It's like one that sneaks off the top of my head. A young girl from Lowell named Emily Davis, who was killed in 2021. Her boyfriend, Devontae DeGray, was abusive towards her. And her story has been told motivated a few years ago. Maybe she didn't have the resources. It didn't take off the way that this story did. But she died from, they said she died from falling out of bed and hit her head and fell out of bed. And she lived with a boyfriend with a long history of domestic violence, and something doesn't smell right. So maybe I'll do that story because this is not the first person that has been put on trial for murder, and it's certainly not the first guilty people that have with murder for a person. Thank you guys. Appreciate it. Oh man, this is. Oh man, 75,000 people watching. This is intense, man. Intense.
Thank you.
Thank you very much.
Very much.
I appreciate that. Thank you guys. Anyways, yeah, sure, let's do it. Yeah. I have. Of course you can.
Thank you.
You're welcome. Thank you. Oh, of course you can. Thank you so much.
No, thank you.
Oh,
My
happy ending. Huh?
thank you.
This is what we all need. Can I get a picture with you? Of course you can.
I love that.
There we go.
Thank you.
You're welcome.
Good job.
No problem. Oh, there he is. Okay. Yeah. I'm going to talk to them. They want to do it. Is it going to be a while or? No. Yep. Cool.
Say something.
Testing 1 2 3. Testing 1 2 3.
Yep. Stuck yourself.
I'm picked up those. See, they're on the pink over there. It's one of my former students, KJ. Katie Jones from Shepherd Hill Regional High School. I coached her in track. She was a great shot putter. She's a very good shot putter. Great athlete, great student too.
That's how you free Karen Reed.
We did it. We did it. It's over. It's over. It's over. Oh. 2.5 years in the making, guys. It's finally over. Oh my God. I wish I could have when the food on the way out. I came out right after the I could just do the booze on the way out. I'm like, oh no, I have to follow that.
All right, I think we got the point on that one. That was a lot, man, but he seems happy. And apparently had 75,000 people watching his live. That's a lot. 75,000 people enjoy potato. I mean, I believe it. I believe it to be true for at least in part. All right. Let's do something else. Mods, where are we in terms of Karen Reed coverage? Are there other videos I need to watch? Other things I need to react to? Other clips I should be watching? What do you think, mods? Or do we move on to other things? I think we're done with the Karen Reed stuff. I think we might be done with the Karen Reed stuff. Yeah. We might be done with the Karen Reed stuff forever. If there's a juror interview, I'll tune in for that. I mean, like there's jurors interviews, especially if there's like any lengthy to them. Incidentally, by the way, if you served on the Karen Reed jury and would like to come on my channel, you are more than welcome. I will be happy to talk to you about your experiences and what how long to decide charges. I will, yeah. Hey, mods, you've been pretty good recently about getting me those interviews. Mods, you've been doing pretty good on getting me those interviews. Where's my juror interview, mods? Where's my juror interview? God, there's too many cases that have been coming out recently. Shit, man, we are so behind on Supreme Court shit, man. God damn. They're deciding too many cases. They're deciding too many cases. All right, let's do the same-sex marriage thing or same-sex transitioning thing. Let's deal with transing the kids because that's in no way controversial. Let's discuss transing the kids. That's a good way to get everyone's attention. The U.S. Supreme Court decided transing the kids case today. Yeah. So let's discuss that. That's good. All right. We turn our attention to United States of America versus Skrmetti in their capacity as the Attorney General of Tennessee, wherein we will read the following. In 2023, the state of Tennessee joined a growing number of states that restricted sex transition treatments for minors by enacting the prohibition on medical procedures performed on minors related to sexual identity, Senate Bill number 1. So Tennessee, like many states, says not so much with the transitioning the minors. We'd really prefer that you not do that. And they passed a law prohibiting their doctors from doing that. So that's the law they passed. Moving on. The relevant law prohibits healthcare providers from prescribing, administering, or dispensing puberty blockers or hormones to any minor for the purpose of enabling the minor to identify with or live as a purported identity inconsistent with the minor's biological sex, or treating purported discomfort or distress from discordance between the minor's biological sex and identity. So you might be able to prescribe the hormones for some other purpose, right? There might be legitimate medical purposes to prescribe someone under the age of 18 hormones, but you can't do it for these purposes. You cannot do it for the purpose of transitioning or reducing discomfort with their biological sex. That is not permitted. Great. At the same time, the relevant law permits healthcare providers to administer puberty blockers or hormones to treat a congenital defect, precocious puberty, which is, where puberty comes in way too early, disease or physical injury. So you can use it for those purposes. So hormones are permitted, but not for the transitioning purposes, but for other purposes. 3 transgender minors, their parents, and a doctor challenged the relevant law under equal protection. Good fucking luck under equal protection. All right, so let's define equal protection really broadly. To start with, equal protection requires the government to treat the same category of people the same, but that allows them a lot of category in determining what the same category is, because what is like something else is very much a issue of categorization. So like you have to be able to articulate a difference that makes sense. So basically, as long as the government can articulate a difference that makes sense, they can do it, right? So if you wanted to treat, I don't know, what would be something that wouldn't make sense? You wanted to treat left-hand people different than right-hand people. Like left-hand people can't get driver's licenses. Okay, why though, right? So what about left-handed? And it has to be tied to the difference, right? So what about left-handedness prevents you from getting a driver's license? And, in the absence of an answer to that question, you're going to have a problem, right? So you need to be able to point to a difference and show why it matters with respect to the difference that you want to do. But as long as it makes rational basis, you'll be fine. So as long as you can basically point to any reasonable difference, you're going to be fine. So that's equal protection in a nutshell. The district court partially enjoined the relevant law, finding transgender individuals constitute a quasi-suspect class. And so that's another thing. Like if you're discriminating on the basis of a suspect class, that's another problem. So, but even in a non-suspect class, you'd have a problem if you can't differentiate the difference. So if you were treating them differently on a suspect class, race, sex, for example, those are suspect classes, right? Handicap status, maybe, right? Those might be suspect classes. So if they're suspect classes, then you're going to need to show more. Not to say you can't do it. You might be able to do it, but you're going to need to show more, right? If it's like, okay, I want to treat handicapped people differently. Okay, but why though? And if you can justify that, maybe, but they're going to require a little bit more. Okay, great. So in any case, the district court found that these transgender minors are a quasi-suspect class. So, we need to have some sort of elevated review. And that SB1 discriminates on the basis of sex and transgender status, and SB1 was unlikely to survive intermediate scrutiny, which would be correct, right? That's basically discrimination on the basis of sex is intermediate status. So if you want to discriminate on the basis of race, then strict scrutiny. If you want to discriminate on the basis of sex, intermediate scrutiny. It's easier to discriminate on the basis of sex than race. But you still have to satisfy intermediate scrutiny as opposed to mere rational basis. Remember when I talked to you about that before? Like I was like, okay, we want to treat like left-handed people differently than right-handed people. Or another one, we want to treat poor people differently than rich people. Those are not considered suspect classes. So as long as you have any rational basis, it'll be fine. Rational basis review is the standard. If it's a quasi-suspect class like sex, then intermediate scrutiny. If it's a suspect class, strict scrutiny. That is sort of the way we deal with that. So we're going to treat transgender status equivalent to sex as an intermediate scrutiny. That's what they tried to do. The Sixth Circuit reversed, holding the law did not treat in heightened scrutiny and satisfied rational basis. As I said, that would be the normal standard, right? We want to treat rich people differently than poor people. We want to treat left-handed people differently than right-handed people. We want to treat people with blue eyes differently than people with green eyes, differently than brown eyes. Like, why? Maybe there's a reason that makes sense. Maybe there's a reason it makes sense, but you're going to have to justify that. Like, why are you treating the brown-eyed people differently than the green-eyed people? Why are you doing that? And if you can point to a rational basis, which isn't much, but if you can point to a rational basis, then fine. But you can't just do it for the hell of it. You got to point to a reason that difference matters. That's the normal standard. So they're like, okay, just rational basis review then. This court grants cert to determine whether the relevant law violated equal protection. Held, Tennessee's law prohibiting certain medical treatments for transgender minor is not subject to heightened scrutiny under equal protection and therefore rational basis. So it is not a suspect class. It is not a quasi-suspect class. Therefore, standard rational basis, and therefore basically any reason that passes the laugh test will be fine, right? And the rational basis is basically any reason that passes the laugh test. So as long as there's a reason, any reason that makes any sense, right? It's going to be upheld. So, yeah. So there's that. SB 1 is not subject to heightened scrutiny because it is not classified on a basis that warrants heightened scrutiny. On its face, SB 1 incorporates two classifications, one based on age, allowing certain medical treatments for adults but not minors, and another based on medical use, prohibiting puberty blockers and hormones for minors to treat certain conditions but not other conditions. Classifications based on age or medical use are subject only to rational basis. So we've had that issue before, like, can we treat young people differently than old people? Rational basis. Medical treatment, generally speaking, rational basis, right? I mean, why are you treating some people differently medically? There's a lot of reasons that you treat two different people medically. Well, this is the state imposing it, so it's a little bit harder. So you're dealing with it in categorizations as opposed to the doctor, right? The doctor can treat two patients differently because, well, first of all, they're not the government. And even if they were the government, finding a reason to treat two patients differently but is not hard. But here we're talking about categories of people, not individual patients. But it's like, what is the reason to do that? And, yeah. The plaintiffs argue that SB 1 warrants heightened scrutiny because it relies on a sex-based classification. But neither of the above classifications turns on sex. So they're like, this isn't sex. It's not. Rather, SB 1 provides healthcare providers from administering puberty blockers or hormones to minors for certain medical uses regardless of sex. So it treats men and women the same, or boys and girls the same in this case, right? Neither boys nor girls can get it. Boys and girls are treated the same, and boys and girls are sex. Which, yeah, that's what we mean by sex. We mean male and female. Neither male nor female can get it. So there's no discrimination. It's the same. Yeah. While SB 1's prohibitions refer to sex, the court has never suggested that mere reference to sex is sufficient to trigger heightened scrutiny. And such a approach would be especially inappropriate in the medical context where some treatments and procedures are uniquely bound up in sex. Yeah, a little bit, right? So, sometimes you are making things because men and women are different sometimes. And so that would be really weird. Great, moving on. The application of SB 1 does not turn on sex. The law does not prohibit treatment of certain medical treatments for minors of one sex while allowing treatments of minors for the opposite sex. SB 1 prohibits healthcare providers from administering puberty blockers or hormone to any minor to treat gender dysphoria, gender identity disorder, or gender incongruence, regardless of sex. It permits providers to administer puberty blockers and hormones to minors of any sex for other purposes. And while a state may not circumscribe or circumvent the Equal Protection Clause by writing in abstract terms, it does not mask sex classifications. So if it really is sex, but they try to pretend it's not, or if it really was race, but they try to pretend it's not, we're not going to be fooled. So if they wrote it in a race neutral or sex neutral way, but it's not really race neutral or sex neutral when you actually try to apply this in the real world, right? Then, you know, like, for example, like, suppose that we want to discriminate against people, I don't know, suppose we wanted to discriminate against people that have breast cancer as opposed to like other kinds of cancer. Okay. I don't know why we're doing this, but let's just pretend we are. Okay. We are going to say, like, for normal cancer patients, you can have chemotherapy, but for breast cancer, not so much. I don't know why we're doing this, but we're doing this for some reason. All right. Now, that is a sex neutral thing on first blush, because both men and women can get breast cancer. However, the rate of breast cancer for men, I believe, is something like 100 to 1. For women, it's been a while since I looked it up, but I think it's roughly the ballpark. I think it's 100 to 1 ratio. So for every 100 women that get breast cancer, a man will get breast cancer. It's possible, it happens, but you know, not so much. So maybe the reason we passed this isn't because we don't like breast cancer for some reason. Maybe the reason we're doing this is because we don't like women for some reason, right? And maybe that's the problem, right? Or something like that. So some issue like that, maybe. Okay, great. Moving on. Yeah, it's just an example. I had to come up with an example off the top of my head. I had to come up with an example off the top of my head that discriminated, I had to come up with an example off the top of my head that was facially neutral, but when applied in the real world wasn't. So breast cancer is what I came up with because I know that the ratio of breast cancer for men to women is about 100 to 1. So that's what I came up with off the top of my head. So I am pressing on. Men get breast cancer. I know. As I said, Peggy apparently not listening or not understanding. I know men get breast cancer. I said that men get breast cancer. What about this is confusing? Holy shit. God damn. Finally, the court rejects the plaintiff's argument that by design, SB 1 enforces government preference that people conform to expectations about sex. To start, any allegiance of sex stereotyping is misplaced. True, a law that classifies on the basis of sex may fail heightened scrutiny if the classification rests on impermissible stereotypes, but where a law's classifications are near covertly. Incidentally, by the way, I learned recently that word used to be pronounced differently. It changed with Eisenhower, or like around the Eisenhower, or it changed around Eisenhower or Kennedy era. So I learned recently that word used to be pronounced differently. So, you know, in the we're always learning things differently. We're always learning things differently, or learning new things. I'm going to reread that sentence, and I'm going to reread it with the old pronunciation just so I can be cool. This is how I've decided to be cool. I'm going to read the sentence. I'm going to read it with the old school pronunciation so I can be one of the cool kids. All right, let's do it again. But where law's classifications are neither covertly nor overtly based on sex, the law does not trigger heightened review unless it was motivated by insidious discrimination purpose. No such argument has been raised here. And regardless, the statutory findings on which SB 1 is premised do not themselves evince sex-based stereotyping. SB 1 also does not classify on the basis of transgender status. The court has explained that the state does not trigger heightened constitutional scrutiny by regulating a medical procedure that's only one sex can undergo unless the regulation is mere pretext for invidious discrimination. So the mere fact that only one sex can have the treatment is not sufficient to prove sex discrimination. So it might be, but it's not sufficient. Like, so again, like, why are we doing this? But yeah. In a case, the court held that a California insurance program that excluded from coverage certain disabilities resulting from pregnancy did not discriminate on the basis of sex. In reaching the holding, the court explained the program did not exclude any individual from benefit because of individual sex, but rather removed one's physical condition, pregnancy, from the list of compensatable disabilities. The California insurance program, the court explained, divided potential recipients into two groups: pregnant women and non-pregnant persons. California apparently thinks only women can get pregnant implicitly, which is nice to know. Because women fell into both groups, they reasoned it did not discriminate against women as a class. The court concluded that even though only biological women can become pregnant, not every legislative classification concerning pregnancy is sex-based. So again, just because only women can get pregnant or only men can have prostate cancer doesn't necessarily mean it's sex-based inherently. We might have to look past it. The mere fact it overextends to one sex may not necessarily be sufficient, but it might be an indicia that might cause us to look a little bit deeper. As such, absent of showing distinctions involving pregnancy are mere pretext designed to affect invidious discrimination against one sex or the other, lawmakers are constitutionally free to include or exclude pregnancy from covered legislation or on any reasonable basis, just as with respect to other physical conditions. So I don't know, again, what scenario this would be or what legislature is doing this, but let's suppose the legislature said, we're no longer going to cover breast cancer because we just don't think it's a priority. We want to put more money towards, I don't know, heart disease or something. I don't know. At that point, that's just a policy choice, right? So I don't know what legislature is making this decision, but they could, right? Because it's like, well, how much money do you give breast cancer versus colon cancer versus lung cancer versus prostate cancer versus, bone cancer versus skin cancer versus whatever? Like, how much money do you give these things? And if the legislature said, you know what, we don't think breast cancer should be our priority, so we're going to defund it. Instead, we're going to use the money to, insert other worthy cause here. Then at that point, that's just a policy determination. Unless you can show they were doing it specifically because they don't like women, as opposed to, we just think other things are more important. You might very much disagree with that assessment, incidentally. You probably do. But, it's a policy decision and legislature is going to legislate. So, there's that. By the same token, SB 1 does not exclude any individual from medical treatments on the basis of transgender status. Rather, it removes one set of diagnoses, gender dysphoria, gender identity dysphoria, and gender incongruence, from the range of treatable conditions. Incidentally, by the way, for what it's worth, the practice of medicine, as I'm sure you can appreciate, is on the first instance a state-regulated concern. So like first principles, the practice of medicine is regulated by each individual state, and each individual state gets to determine what is and is not valid medicine, and that is and can be a political decision. Right? So, because it's a government of the people, not government of doctors. Right? You might ask yourself, who's the legislature to regulate medicine? But it's the government of the people, right? Not a government of doctors. So if the legislature wants to say what is and is not medicine, that's a political decision. All right? Because, what's the alternative? So, yeah. SB 1 divides minors into two groups, those seeking puberty blockers or hormones to treat the excluded diagnoses, and those seeking it for some other reason. While the first group comprises only transgender individuals, the second group encompasses both transgender and non-transgender. Thus, although transgender individuals seek treatment for gender dysphoria, gender identity disorder, and gender incongruence, just as only biological women can become pregnant, there's a lack of identity between transgender status and the excluded diagnosis. Absence is showing that SB 1's prohibitions are pretext designed to affect invidious discrimination against transgender individuals. The law does not classify on that basis. Finally, Bostock versus Clayton does not alter the court's analysis. In Bostock, the court held that an employer who fires an employee for being gay or transgender violates Title VII prohibition on discharge because of sex. The court reasoned that because Title VII, because of test, incorporates traditional but-for causation, which directs courts to change one thing at a time and see if the outcome changes. Applying that test, the court held that for an individual to discriminate against employees for being homosexual or transgender, the employer must intentionally discriminate against men and women in part because of sex. Right. Right. So like, how do you know if a person is gay? Right? Like this is, yeah. How do you determine if a person is gay? A person is sexually attracted to a man. How do you know if that person's gay? Right? A person is sexually attracted to a man. How do you know if the person's gay? Isn't there only one way to make that determination? Isn't there only one way to make the determination that the person themselves is male? How else can you do it other than by saying they're male? Right? If they're male, they're gay. If they're female, they're not. Right? So there's no way to make the determination about whether they're gay or not without reference to their sex. Right? So, yeah. So if you're discriminating against gay, you're implicitly discriminating against sex because two people marry a man. Two people, well, different men in this case, because bigamy is still illegal. Two people marry two different men. One of them is male. One of them is female. Why am I discriminating against the male and not the female? Isn't it because the male is male, which is what makes him gay? Yeah, so you have a problem now, don't you? Yeah. In such a case, the employer penalized a member of one sex for a trait or action it tolerates in the other, namely being attracted to males in this situation. The court declines to address whether Bostock's reasoning reaches beyond Title VII context. Unlike the employment discrimination at issue in Bostock, changing a minor's sex or transgender status does not alter the application of SB 1. If a transgender boy seeks testosterone to treat gender dysphoria, SB 1 prevents a healthcare provider from administering to him. Yeah, incidentally, whether he's transgender or not. Right? So, like, yeah, there's that. Sexual preferences in sex? I didn't say it was. Are we confused? Do I have to go through this again? Someone in chat said, Proctor's doing an interview tonight, really? That sounds hilarious. Someone, yeah, Pat says sexual preferences in sex. I didn't say it was. Do I have to go through this again? How do you know if a person is gay? A person is sexually attracted to a male. How do you know if the person is gay? Isn't it because they're male that makes them gay? What else could it be? Right? If the person were female, it wouldn't be gay. It's only because they're male they're gay, right? That is what gay is, right? What about this am I not being clear on? No? Yes, very much so. Okay. Let's try this again. You tell me. All right, you tell me, since you say I'm wrong. You tell me. A person is sexually attracted to a male. Okay? A person is sexually attracted to a male. You tell me, how do we determine if the person is gay or not? Tell me. How do you determine if the person is gay or not? A person is sexually attracted to a male. Tell me, how do we determine if the person is gay or not? Anytime. Anytime since I'm wrong, we'll be fine. What's the answer to this question, Pat? Anyone? You're just reinforcing my point by disagreeing with me by saying you're reinforcing my point by saying no, Kurt. You're telling me that saying no, Kurt, is reinforcing my point? How? I'm confused. I don't understand. You asked them? There's nothing to ask. There's nothing to ask because I've told you they are sexually attracted. In fact, this is just a fact. I am telling you. You don't need to ask them. I am telling you they're sexually attracted to male. They are sexually attracted to male. This is not a question that's in dispute. I didn't say no. You literally said no, Kurt. You literally said no, Kurt. I'm looking right at it in chat. Go up about 20 chats and it's there. Jesus Christ. A gender fluid person, but I didn't say this person's gender fluid. I said they're sexually attracted to a male. What are we doing here? Yeah. Pressing on. If a transgender boy seeks testosterone from treat gender dysphoria, SB1 prevents a healthcare provider from administering it to him. If biological sex were changed from male to female, or female to male, as the case may be, SB1 will still not permit him the hormones he seeks because he would lack a qualifying diagnosis. The transgender boy could receive testosterone only if he had a permissible diagnosis, like a defect, like a congenital defect. And if he had such a diagnosis, he could obtain the testosterone regardless of his transgender status. Under the reasoning of Bostock, neither his sex nor transgender status is the but-for cause. SB1 satisfies rational basis review. Under that standard, the court will uphold statutory classification so long as there's any reasonable conceivable state of facts that could provide a rational basis for classification. SB1 clearly meets the standard review. Tennessee determines that administering puberty blockers or hormones to minors to treat gender dysphoria, gender identity disorder, or gender incongruence carries risks, including irreversible sterility, increased risk of disease and illness, and adverse psychological consequences. The legislature found that minors lack maturity to fully understand these consequences, that many individuals have expressed regret for undergoing such treatment, and the full effects of such treatment may not yet be known. At the same time, the state noticed evidence that discordance between sex and gender can be resolved through less invasive approaches. SB1's age and diagnosis-based classifications are rationally related to those findings and the state's objective of protecting minors' health and welfare. The court also declines the prevent. You do understand that even if you said that a woman who's attracted to a woman is gay as opposed to lesbian, it doesn't change my hypothetical, right? Like if you call a woman who's attracted to a woman gay as opposed to lesbian, then like you're still, oh, never mind. The court also declines the plaintiff's invitation to second guess the lines SB1 draws. States have wide discretion to pass legislation in areas where there's medical and scientific uncertainty. Recent developments demonstrate the open question that exists regarding basic factual issues before medical authorities and regulatory bodies in the area, underscoring the need for legislative flexibility. $5 from Matthew Moselle. Hey, Kurt, a lot of the coverage of things like Scottish cases are in Karen Reed screams and they're hard to find. Could you re-record the clip and re-upload? Maybe, that'd be fine. This case carries with it the weight of fierce scientific and policy debates about safety, efficacy, and propriety of medical treatments in an evolving field. The Equal Protection Clause does not resolve these disagreements. The court's role is not to judge the wisdom, fairness, and logic of the law, but only to ensure the law does not violate equal protection. It does not. Question regarding policy are thus appropriately left to the people. Roberts delivers an opinion of the court in which Thomas, Gorsuch, Kavanaugh, and Barrett join, in which Alito joins in part. Thomas concurs, Beto Ferris concur. Sotomayor dissents, in which Jackson and Kagan join in parts. So this is a 6-3 opinion, unsurprisingly. Unsurprisingly, the liberal women of the court apparently do not understand logic and reason and are a bunch of assholes. So, yeah. Proctor is going to speak out tonight. Holy shit. I'm probably going to get copyright struck for streaming that. But I really want to stream. I really want to stream 2020 interviewing Proctor. I really want to stream it. All right. So what else should we talk about? We could discuss other Supreme Court cases, but I feel like I just went through a thing with basic terminology and you. Yeah. I should probably read the dissent and like mock the shit out of it. That'd be great. Let's read some of the dissent and see exactly how deep the stupid goes. Maybe that's unfair. Maybe they have some good points and will convince me somehow. I mean, we haven't read it yet, so maybe they'll convince me. This should be good. Let's read the dissent for a while and see exactly what the point of the stupid is. Did I see the nuclear waste ruling? No, not really. You asked what in a super chat earlier. I read all the super chats. What was your question, Jules? I'll be happy to answer it again because we love you. Oh, can she appeal the DWI? Yeah, sure. She can. I doubt she will for every practical reason. But yes, she can appeal the DWI. I really don't think she will. I have a lot of doubts on that one, but she could. Where's Proctor doing this interview? Good question. Especially since she got a nothing burger sentence, the same as anyone else. You know? Oh, no problem, Jules. You're fine. We love you, Jules. We're always happy to accommodate you. We love you. And you don't drive me crazy very much. I don't think that's true, Eddie. If you know for a fact that's true, it would have to be true because of a statute. I seriously doubt that's true in this situation. That doesn't sound right. I don't know for sure, but it doesn't sound right that it will be wiped off her record if she completes the class. That doesn't sound right. Would it reopen the manslaughter charge? No. No, it wouldn't reopen the manslaughter charge because only by finding not guilty could they have moved on to the charge. So the not guilty finding is implicit because only by finding not guilty could they have moved on to 5 because of the way the instructions were written in the jury verdict form. The not guilty finding is implicit. So it doesn't reopen the manslaughter charge. Does it stop her from suing, Jules? We don't know. I'm not sure. I'm not sure whether it stops her from suing. I don't know. I'm not sure. That answering that question would take quite a lot of case law research to try to figure out for sure. Yeah. That's a complicated one. Excuse me. Canada would work to reopen. Maybe, but not here. Especially not with the verdict form that they had. It wouldn't. No. It could reopen the sentencing, which is potentially a problem, but. Peggy is a moron? Yeah, I kind of figured out that one. All right. Justice Sotomayor wants to write some stupid. Along with Justice Jackson and Justice Kagan as the part. Yeah. Let's read some stupid from the dissent. To give meaning to our Constitution's bedrock equal protection guarantee, this court has long subjected to heightened judicial scrutiny any law that treats people differently based on sex. If a state seeks to differentiate on that basis, it must show that sex classification serves important governmental objectives and that discriminatory means employed are substantially related to the achievement of the objectives. Such review knows intermediate scrutiny allows courts to ascertain whether the state has a sound, evidence-based reason to distinguish on the basis of sex or where it does so in reliance on impermissible stereotypes. Today, the court considers a Tennessee law that categorically prohibits doctors from prescribing certain medications to adolescents if and only if it'll help the patient identify with or live with a purported identity inconsistent with the minor's sex. Yeah, but that goes both ways. Yes, there's actually a scheduled interview somehow. There's actually a scheduled interview somehow. Wasn't her first DUI? Yes. A law conditions the available medications on the patient's sex. No, it doesn't. Tennessee law expressly classifies on the basis of sex and transgender status. No. And I can't be bothered to read anymore because the preamble is just full of shit. Where's the Proctor interview? It's on 2020 this evening at 8 p.m. Eastern, 7 Central. So it's on in 2 hours on 2020. Sounds like a whole pile of stupid. Let's watch the promo for this thing. Let's watch the promo for the stupid.
Reed, not guilty of killing her boyfriend, Boston police officer John O'Keefe. Now breaking tonight, new interviews, new details from inside the courtroom. To the new exclusive.
You're the first person from inside the investigation to speak out.
People need to know. They're all hearing one side.
With the lead investigator who is dismissed from the force.
One of the texts that you sent about Karen Reed is that you said hopefully she kills herself.
Karen Reed, The Verdict, the 2020 new special, breaks tonight on ABC.
Okay. All right. How fast am I going to get copyright struck for doing this stream? That's what I want to know right now. Probably pretty fast, right? I'm just going to get torched for doing this by copyright law, aren't I? I really want to cover it though. I really want to cover it. God damn it. How you doing, Travis? That was a good, you liked my review of the Supreme Court? Thank you. That's very kind of you. Yeah, we're doing some Supreme Court review. We're behind by cases too, man. Let's see if there's anything else that looks interesting that really got my attention. Let's see anything else from the Supreme Court today that looks interesting. Something dealing with nuclear licensing. EPA. Dealing with refinery exemptions. Watch party. I wish I could. Yeah, watch along party. I wish I really could. Yeah, maybe on Twitch I can do it. Maybe we'll do a react on Twitch. Clean Air Act. Dealing with air standard stuff. Blah, blah, blah. Okay. Prison Litigation Reform Act requires prisoners. Okay, this deals with. All right, this has to deal with prisoners bringing complaints. That's kind of might be interesting. Maybe I'll do that one. Let's see what else we got. Okay. What qualifies as a second habeas petition? That's a little geeky, but interesting. Discord watch? Discord watch is a good call. Yeah, okay. So if we can find a way to stream it, and I'm not sure how we're going to do that because we have to find a way to stream it, but we could watch it together on Discord. That's a good call. Yeah, maybe we'll watch it together on Discord. Yeah. Yeah. If we can find a way to, if we can find a source for it, we'll stream it on Discord and commentate on it. That could be fun. So let's plan tentatively on a Discord party. Brian Higgins is apparently selling his home. He's quitting his job and moving out of state. Aw, that's very sad. I thought doing a reactive video is fair use. It's not that simple. It's not that simple. And even if it was fair use, I'd have to fight it. So that's dealing with what a second habeas review is. Let's see. Jurisdiction of the tax court. Ugh. Oh, the FBI raided the wrong house. Okay, that's kind of interesting. Oh yeah, this is actually a pretty interesting thing. Let's deal with this one with the FBI raiding the wrong house. This is a good case. This is interesting. It does affect gun rights. It does affect gun rights. I'll prove it to you. Give me a second, please. I thought it was 928. It was 922. Okay, sorry. 922. I think I said 928 on stream earlier. 922. Sorry. 922G. I think I said 928G earlier. All right. So, yeah, does Karen Reed lose her rights? Does Karen Reed lose her firearms rights? Yes, she does. And to prove that, we turn our attention to 18 USC 922 G1. It shall be unlawful for any person who's been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year. That's Karen Reed. She was convicted of a crime punishable by a term exceeding 1 year. So she is banned from firearm ownership on the federal level. That's just what it says. So yeah, that's it. She's banned. Yeah, that's it. Yeah. Okay, great. Let's deal with the FBI one. All right. This is the case of Martin versus United States, dealing with the FBI raiding the wrong house. This might be potentially relevant to your work, Travis. This feels like a case that could potentially touch a case concerning you at some point, or your clients, more to the point, not you personally. But this feels like something that might be relevant to you, Travis. So assuming you hadn't already heard already, you might want to pay attention to this one. All right, on October the 18th of 2017, the FBI raided the wrong house in a suburban Atlanta. Officers meant to execute a search and arrest warrant at a suspect gang hideout at 3741 Landu Lane, but instead stormed 3756 Denville Trace, a quiet family home occupied by the petitioners. A 6-member SWAT team breached the front door, detonated a flashbang grenade, and assaulted the innocent occupant before realizing their mistake. Yeah, they broke down the wrong door, Travis. They broke down the wrong door for the search warrant, arrest warrant, whatever. They broke down the wrong door, Travis. They can't read. Not going great, Travis. The cause of the error was Special Agent Guerra's reliance on a personal GPS device, combined with the team's failure to notice the street sign for Denville Trace and the house number visible in the mailbox. Our observation skills leave something to be desired, Travis. They could have looked at the number on the mailbox or, the name of the street, but, we apparently failed in our mission. So that's not going great. Left with personal injuries and property damage, petitioners sued the United States under the Federal Tort Claim Act, seeking damages resulting from the alleged negligent and intentional acts during the raid. The district court granted summary judgment to the government. The 11th Circuit approached applying a unique approach to the Federal Tort Claim Act. So the Federal Tort Claim Act basically says you can't sue the federal government unless these things are true, right? So the Federal Tort Claim Act, as the name sort of implies, says here's the situations in which you can sue the federal government for torts. Hence why it's called the Federal Tort Claim Act, because here's why you can sue the federal government for torts. So, but they read the law in a particular way, and so they're like, oh, not so much, you can't sue. All right, pertinent to our discussion, the Federal Tort Claim Act waives the federal government's sovereign immunity from suit as to certain torts committed by federal employees acting within the scope of their employment. So the federal government could do the sovereign immunity thing, but not so much. We're not interested in that. We would like to be sued very much, says the U.S. government. Please sue us. But that waiver is subject to statutory exemptions, including 2 relevant to law enforcement misconduct like this one. The first is the intentional tort exemption, which bars claims against the government for 11 new enumerated intentional torts. So the federal government says you can sue us, but not for these 11 reasons. If your cause of action is one of these 11 things, you can't sue us. Sorry, not so much. So none of those things. The second is the discretionary function exemption, which bars claims against the government that are based on an official's exercise of discretionary functions. The relevant law also contains a law enforcement proviso, which countermands the intentional force tort exception, allowing suits for 6 specified torts, including assault, battery, false imprisonment, and false arrest, to proceed against the United States when the torts are committed by law enforcement. So we have an exception to the exception, right? Here's 11 reasons you can't sue the federal government. Unless it's a law enforcement reason, then 6 of those reasons are back on the menu, baby. What can you do, man? That's the way they wrote it. What do you want, right? What do you want? That's the way they wrote it. Okay. While most courts hold that the law enforcement proviso applies only to the intentional tort exception, the 11th Circuit's approach is different in 2 key respects. First, the 11th Circuit also holds the proviso overrides all the exceptions, including discretionary functions. So so you can't sue them. You can't sue them for these 11 torts, and you can't sue them for discretionary functions, but you can sue them for these 6 specific torts if it's law enforcement. So is that simply bringing back in the things from the intentional tort, or is it also relating to discretionary functions? So can I sue you for your discretionary functions if you also did one of these 6 torts at the same time? If in your discretion you did one of the torts, can I still sue you? That's basically the question at this point. That's what we're doing over here. Okay, great. So the 11th Circuit held the proviso overrides everything. So if the 11th Circuit said okay, if it's one of these 6 reasons, then please basically ignore anything else, right? Please ignore everything else, right? You can just sue for these 6 reasons, full stop. That's basically what they said. Okay, great. So thus, an intentional tort claim covered by the proviso would thus apply to the merits because we're just going to ignore everything else. Okay. Second, to compensate for this plaintiff-friendly approach, the 11th Circuit permits the government to assert a restrictive supremacy clause defense at the liability stage, which makes absolutely no fucking sense. How the 11th Circuit wrote this is beyond me completely. This makes absolutely no fucking sense. Okay. You can still assert a supremacy clause defense. Now, the supremacy clause says the federal statutes are the supreme law of the land. Wait a second. How are you bringing a supremacy clause defense to the Federal Tort Claim Act? The Federal Tort Claim Act, as the name says right in the title, is a federal act, right? It's the Federal Tort Claim Act. It is a federal act. Thus, it's an act of Congress. So riddle me this, Batman. Riddle me this. How are you using supremacy clause defense, which says that the federal law is the supreme law of the land, to defeat an act of Congress, which is a federal law, which is the supreme law of the land? How's that working? How's that? The Federal Tort Claim Act isn't legal because of the supremacy clause. The Federal Tort Claim Act isn't legal because the Constitution says the federal law is the supreme law of the land, and the Federal Tort Claim Act is defeated by the supremacy clause, which says the supreme law of the land, which includes the Federal Tort Claim Act. My brain hurts. My brain part hurts. I don't understand. It doesn't make any sense. The stupid is real. The stupid is real in levels, man. It doesn't make any fucking sense. The stupid is incredibly real. You can't say that a federal statute somehow is defeated by the supremacy clause. It is a federal statute. What the hell are you talking about? So in any event, the 11th Circuit somehow brought the supremacy clause into this bullshit, allowing the government to escape liability when an officer's actions have some nexus with furthering federal policy. You know what really has a really good nexus with furthering federal policy? You know what has a really good nexus with furthering federal policy? An act of Congress. An act of Congress has a really good nexus with furthering federal policy. So the federal statute is defeated by federal policy, even though the federal statute is federal policy. It's crazy pills. It's crazy pills. Jesus Christ. How they write this with a straight face? And reasonably complied with the full range of federal law, but the Federal Tort Claim Act is federal law. It says so right in the title. Applying this distinctive approach, which is Supreme Court language for bullshit, the 11th Circuit held that law enforcement proviso protected petitioners' intentional tort claims from both the intentional tort and discretionary function exemptions. The court dismissed petitioner's negligent claim under the discretionary function, reasoning that the special agents enjoyed discretion in preparing for the warrant, which, okay. On the merits of the remaining claims, the court found the government had a valid supremacy clause defense. If anyone can explain to me how they had a valid supremacy clause defense without me having a stroke, I'd like to hear it, but it doesn't make any sense. Held, the law enforcement proviso overrides only the intentional tort exception, not the discretionary function or other exceptions. Okay, fair enough. I mean, that is a valid legal question. That's a valid legal question. So what does the proviso exception give an exception to? And that's just straight statutory interpretation at that point, right? So we could go read the statute, but I'm not going to because my brain already hurts enough as it is. So we'll just take the Supreme Court's word for it, right? That the proviso, that the exception is only exception to the intentional court provision and not the discretionary function. Okie dokie, fine. Fair enough. That's just straight statutory interpretation. No muss, no fuss. Great. Pressing on. The text and structure of the relevant law demonstrates that law enforcement proviso applies only to the intentional tort exception. The proviso appears within the same subsection and sentence as the intentional tort exception, reflecting the established principle that statutory provisos generally only modify provisions in which they appear. Well, I mean, that's just straight uncomplicated statutory interpretation, right? This is normally how we interpret a statute. This is how it's written. This is normally what we do. So we're just going to kind of do that because there's no reason not to. Cool. Great. The relevant law contains 13 discrete exceptions. Coupled with the lead-in clause, each exception forms a separate sentence and operates as a separate distinct provision. Okay. The proviso addresses the same subject matter, intentional torts, while other exceptions cover entirely different topics like lost mail, combat injury, and quarantine impositions. Fair enough, like for like, right? I mean, they were talking about intentional torts. These are also intentional torts. So we're going to just treat them like in the intentional tort bucket. That makes sense. I can understand that. I'm okay with all that. Further, Travis, incidentally, why are you, okay, Travis or literally anyone else at this point, I could really use a drink. So is anyone in Houston and do they want to get together for a drink tonight? I could really use some margaritas and maybe a nachos. So is anyone in Houston, preferably on the western side of Houston, you know, near Katy? Is anyone in Houston on the western side? Does anyone want to have like nachos and margaritas? Because I could really use a drink at this point. I've earned it, goddammit. I've earned my margarita. Fuck everything else. I've earned my margarita. Fuck you if you don't think I have. I want my goddamn margarita. Travis, why are you not in Harris County? I want a margarita, Travis. I've earned it. I want to go drinking, Travis. I can do this. Further, the provision's definitional sense expressly limits the definition of investigative or law enforcement officer to this subsection, even though the phrase law enforcement officer applies elsewhere in the statute. Congress's choice to embed the provision within subsection H rather than place it at the end of the full list, as it sometimes does with broadly applicable provisions, further comprises the limited section. That's just straight statutory interpretation. I'm fine with all those things. Petitioner's argument for broader application of the proviso is unpersuasive. While the proviso mirrors the language of 2680's lead-in clause by stating that 1346 shall apply rather than shall not apply, the textual similarity does not demonstrate the proviso applies to all exceptions, which form discrete instructions that may be understood completely without reference to other provisions. The absence of limiting language in the proviso's first sentence does not expand the scope beyond subsection H, as Congress accomplished that limitation through the proviso's placement within the same sentence as the intentional tort. I mean, if it's literally in the same sentence, that kind of is pretty strongly suggestive. It's just one incredibly unbroken sentence. So, you know, just do that. That's pretty easy. Legislative history suggesting Congress intended to address wrong house raids broadly cannot displace what law terms clearly direct, as legislative history is not the law and members of Congress may have multiple purposes. The supremacy clause, which is like the stupidest argument I've heard in a while. I don't know when the last time I heard an argument this stupid has been. I'm not sure when the last time I heard a legal argument this stupid, but this is pretty dumb. The supremacy clause argument is not for the United States defense in federal claim suits. The FTCA is the supreme law of the land. Thank you just for saying the obvious. Governing the United States, I want to go to Torchy's Tacos. Torchy's has good margaritas, and they also have good tacos. Let's go to Torchy's. I will also accept Velvet Taco. Velvet Taco also has good tacos. I want Torchy's or Velvet Tacos. I've earned it. I want my tacos. I want my margarita. You can't deny me. Emergency margarita. Emergency margarita get together. What am I doing? The statute generally makes the government liable under state law on the same terms as a private individual would be liable under law of the place where the tortious conduct occurred. Yeah, Congress can do that. Normally state law wouldn't apply to the federal government. Duh, right? A state can't pass a law that makes the federal government liable under state law. That would be incredibly dumb, right? That would just defeat all the supremacy clause. If the state passed a law that says your federal agents are responsible, and that was a thing that was if that was a thing that was true, that would bring the federal government to a halt. And I think we solved that problem right around 1865, I think, was when we clarified that one. But in any event, Congress can choose to make itself subject to state law if it wants. If Congress wants to pass a law and say, sue us under state law too, then, cool. So you can sue under state law because Congress said it was cool. So what more do you want? What is this bullshit? Because the FTCA incorporates state law as the liability standard, there's no conflict. Right, because Congress is we're cool with the state law. Oh, okay. We like the state law. Oh, all right, fine. While federal law may sometimes displace state law in an FTCA suit where constitutional text or federal statute supplies controlling liability, there's no such statute here. The court's reliance on some case is misplaced, as the 19th century decision involved a federal officer's immunity from a state criminal proceeding for acts necessary and proper in discharging a federal duty, not their liability under a statute that expressly subjects it to liability. Yeah. Is Nate back? Nate is back. You think I could get Nate to come over and pick me up and take me out for emergency margarita? Oh, there's a panel. Oh, okay. Let me join a Karen Reed panel. Yeah, I've read enough of this case. We get the gist. It's fine. Let's join this panel and talk about Karen Reed stuff some more. First of all, I need a beer. So let me get a beer. Let me get several beers and possibly a whiskey and some other things. And give me 1 second, please. Emergency alcohol. I have discount bullshit margarita. Emergency discount bullshit margarita sounds pretty good right about now. Let's do emergency bullshit discount margarita. Yeah, that'll work. Do that. Okay. All right. Going for 1.5 ounces of liquor. That sounds good. God damn, thanks. Excellent. Oh God, yes. Ah. "21st Amendment is best amendment. Come for me, bro. Come for me."
I think strike while the iron's hot.
Hey, guess who's here? It's Kurt.
Hello, how are you?
Oh.
Kurt, how's
Can you hear
it
me?
going?
Good. I've got an emergency margarita and celebration. How are you guys doing?
A margarita. Good one. Okay, Kurt, this is above you is Miss Mandy. We've met.
We've met.
Oh, you know Miss Mandy. Oh,
We do.
I work for her. He's your mod. Over the left here is Tom CPU, boots on the ground, which you would have seen his stream since trial 1.0.
Nice to meet you.
Nice to be here. Thank you.
So what do you think,
Aussie
Kurt?
Insider.
Well, I'm quite happy with the resolution of the whole thing. And I'm quite happy that sentencing was done summarily and with the standard, and that we don't have to worry about that issue. And I'm happy that that appears to be over and done, and very happy for Miss Reed, and very happy the jury eventually came to the right decision, and want to know why it took them about 19 hours and 55 minutes longer than it should have. But other than that, I'm good.
Right, should have happened last trial in my book. Can you explain to us what you mean by sentencing being done summarily, please?
Well, I just meant it was, maybe summarily is technically the wrong word. It was just done instantly, I suppose is better. They just did it like, they didn't have a separate sentencing hearing. So they just did it immediately.
That wasn't obvious because we were all busy jumping out of our skins, running around naked. So can you just explain what did happen there?
Yeah, sure. So the judge said
there is no sentencing hearing.
no. It was done instantly. The judge said, "Do you guys want to have a sentencing hearing next week?" Brennan said, "Now's good," and the defense is like, "Okay." And then they had a sidebar, and the prosecutor and Brennan said, "A year's probation and the 24D, which is some sort of program that pre-exists. It's a thing that exists.
Driving program,
whatever." And so, Bev said, just the standard thing we normally give in the first DUI. And Brennan's like, yep. And the defense like, we just want you to treat her the same. And the judge is like, yeah, I'm cool with that. And so done. And that was the end of that. So the sentencing hearing took about 20 seconds.
Nice. Well, that's why it flew past all of us. Sorry, Tony.
I have a question for Kurt. I still don't understand. What's the deal with this? The jury came to a verdict and then gave it to her, and then they changed their mind, or someone changed their mind and knocked on the door and said, forget it, throw that one away. And then this came back. What was in the first one, and what happens to it now?
Who can say what happens to the first one? As to what happens, I don't think anyone cares, to be quite honest at this point. But it's sealed and put in the record. Like, it doesn't matter. I mean, as a matter of law, the jury has the right to change or any juror has the right to change their verdict up until it's accepted by the court. And, so if they do like individual polling, they poll the jury, the common question is like, is this, and does it remain your verdict? So like, until the juror says yes or no, they have the right to change their mind. So there's nothing special about that. I don't know how many last second changes there are, but it's legal. I mean, a verdict isn't final till it's final, as they say. So, until
what happens to it though?
It's sealed. It's sealed and it's just put in the record in case anyone cares, which no one will ever care. No one will care under any circumstance. The real reason to do it is just to show the tracing of it, because there's only one official verdict form, right? There's only one that's printed off for the jury, and so the reason to do it is to have the one that was given that was spoiled. It's like a spoiled ballot, the same kind of thing. And how states deal with a spoiled ballot. It's, a lot of jurisdictions, when there's a spoiled ballot, they put it in an envelope somewhere, and just so that they have a record of every ballot that was issued. So that's basically the same thing.
Right.
Okay, I get it.
Well, thanks for answering those questions.
Yeah.
Yeah, we were curious about all of that. Nobody was really filling us in, so it all makes sense now.
Yep.
So, was there anything else that happened? Well, actually, yesterday. So, just questions about yesterday. There was the jury had asked 3 questions, or technically 4, but she held one off.
Mm-hmm.
What was that about?
Well, based on context, it seems to me that the 4th question was presented to the counsel before the lunch break, because the 4th question appeared to contemplate new instructions or new jury instructions. And so what I think happened, and based on context, is that she presented the question to the jury, presented the question to the counsel, and they're like, we want more time to respond. And since the lunch break was already upon them anyway, she's like, okay, fine, no problem. I'll give you to, end of lunch, so you have more time. And the other 3, they were able to deal with right away. So what I'm inferring is that all 4 were presented at the same time to counsel. They're like, we want more time. Only one. It's like, fine, I'll hold it. The other 3 were presented and then read on the record, and then there was the lunch break, and then they went away and contemplated what exciting jury instructions they wanted. And then when they came back, she then read it on the record. And so, that's what I think happened based on context.
Right.
Best guess.
So we've got, I think that sounds right, to be honest. We were all confused and no one was giving us any feedback. We watch all of you guys to get that feedback and no one was giving it. So what it is, it's CWOF ruling means she gets a year probation with 24D disposition, means she has to attend OUI classes, usually 16 weeks long, once per week. She will still have fines to pay that are standard.
Yeah, that sounds right.
What happens to a car? What happens to a car? They completely destroyed a fucking car.
Her sister made a statement on X about that. They told her she could get it back today, but that they did not have to put it back together.
Yeah, that's right. Yeah, so you're entitled to your Lexus. You can have it back.
It's a lease. It's a freaking lease that she's been paying on from the time of the accident.
Okay, what?
And she's got some insurance.
What happens with that lease? She got any insurance that covers her? Like, they completely destroyed that car.
There's got to be a clause in there. There's got to be a clause where if it gets seized in the third party, that it's not your person.
I'm just gonna assume that she's hosed and that she's on the hook for whatever is what I'm gonna assume.
Body in the snow clause.
Yeah, something like that. Yeah, so she owes money. She owes money, but that is the least of her problems.
True.
All right, so you're saying the insurance won't cover it. Is that what you're saying?
That's my basic assumption. Obviously, there could be some special provision in a lease or whatever, but I'm going to assume that she's on the hook for it. That's my best guess.
How the hell did Amber Heard get her insurance to cover her? Wasn't that household insurance that covered her for getting sued or something?
Well,
it's a different thing.
Yeah, first of all, it's a different kind of insurance, and second of all, there's political aspect to that, which also is a thing. So that's partially it.
Yeah.
So.
Because the other thing is, someone bought another Lexus for them to crash it up with the with the crash.
What happens to that?
Aperture has a Lexus they'd like to sell you. Arca has a Lexus they'd like to sell you. Many Lexuses are available.
Who bought that Lexus?
Wait till the market softens a little bit.
The obviously, the state free blue paint.
Obviously, the state bought the Lexus for Aperture, but who bought the Lexus for Arca? Surely they didn't.
Well, Karen Reed, effectively, yeah. I mean,
effectively we did because we all paid for as much as we could.
Yes, we are all now shareholders in a Lexus. I get my 3 minutes next week. How about you guys?
Yeah, there we go. That worked.
I actually didn't do any specific fundraising, but I did share the link out to make sure that my viewers had the link to go donate whenever they wanted to. Unfortunately for Australia, though, we were locked out of the link. A lot of us had to use her Cash App.
Yeah, I remember that. Do you realize that she raised $1 million all with like 25, 15, $5 donations? There's
So only like $4 million to go.
Yeah, no doubt, huh?
Exactly.
$1 million out of the crowd.
I mean, these lawyers are at the top of their game. They're probably charging like the lawyer charges like $2,000 an estimate. It's like I'm conservatively estimating $5,000 an hour collectively just for the legal assistance. $5,000 an hour for every single hour these people are working on this case. Yeah, that adds up real fast. That means in 8-hour day that's $40,000 every single day.
Alessi is volunteering.
I think the point where Judge Bev started destroying reputations, it became personal, and all bets were off as far as billing. They were just doing it for the sake of saving the reputations after that. So I know Alessi was doing pro bono. I'm pretty sure the other, I can't think of his name off the top of my head, Martin Weinberg, I think he was doing pro bono. But I think that Alan Jackson, it turned personal for him when Bev started going after his reputation. I don't know that he was billing after that point.
I don't know. I can't speak to their financial arrangements, so that's between them.
It is. I got a question for you, Kurt. If Yannetti hadn't suggested putting the OUI in there, do you think we would have been looking at a hung jury again?
I don't know the answer to that.
The thing that saved her.
I don't know the answer to that question, and I'm not really willing to infer anything at this time based on the notes. I don't know what the problems were or where the issue was. Like, I don't know if, like, there were 11 people who, at the end, like, there were 11 people who were ready to vote guilty on DUI, but one person was like, no, I want to vote no across the board, and I won't do it. Or in the alternative, maybe 11 people were ready to vote guilty on the DUI, but there was one person who's like, no, I want to vote manslaughter. So like, I don't know where the holdouts were. I don't know how many of them were. Like, was it one person, two people, three people? I don't know the answers to these questions.
Right. Yeah, we don't know.
I wasn't necessarily concerned with this jury. I was concerned with the difference between the two juries, because the last jury didn't get a split the baby option, whereas this jury did get a split the baby option. Do you get what I'm saying?
Oh, I see. So
I feel like
them convicting her on that one little thing is better than the rest of the whole smash.
I think they had it. It just wasn't clear on the form.
Oh well, not for straight DUI. I mean, that was not on the form. No.
No, the defense wanted that on.
Yeah, that's what they wanted added. Yeah, and they got it, and they're there. And then they wanted it opened up too, because like they asked like what the time frame for the DWI is. And Brennan had the right answer. The time frame for the DWI would be the time of the manslaughter, because it's a lesser included. So assuming that the state's theory is that the manslaughter occurred at 12:40 in the morning, then the DUI has to be 12:40 in the morning because it's a lesser included. So Brennan was right.
They didn't put it in the They didn't put it in the indictment. Though.
It doesn't matter. It doesn't matter. It flows logically from the parent. The child inherits the parent.
Yeah.
Right.
Only Brian Higgins knows the time for sure. Allegedly.
Allegedly. We don't need to talk about any allegedly while Kurt's on the channel. We'll talk about that when he goes, because, he's got a bar license and we don't. So.
Speaking about how do you think that the law community as a whole sees what happened today? They see it as a change in anything, or it just is, it's just a trial that happened and it just happened to cost a lot of money to do a drunk driving case, but that's okay. Yeah. But does the law community see this as, hey, there's problems and they identified them and they're going to fix them? Like, do they see it that, or is it, I mean, we need the bar associations to help us to do this. You guys are smart ones that can make these laws to fix this stuff so it can't happen, right?
Well, it's actually the lawmakers, not so much the Bar Association.
But get me a lawyer, a good lawyer who can find a way around it. I want the
Tom
you know what I mean?
Tipke lives in the area. He was actually at the courthouse when everything was announced today, correct?
Cool.
Yeah,
How was that?
Unbelievably electric.
I would imagine. I heard the cries from inside the courtroom. It was great.
Yep. It was just I can't. There's no words to put it into words, I guess. But Vinnie Politan and all the other people that from outside couldn't believe the crowds that we had Monday, Tuesday, and then today. They just couldn't believe the crowds.
I have no problem with the guilty verdict on the DWI. I think there's more than sufficient information. Like from a purely legal posture, I probably would have voted guilty. There's more than enough information. The blood draw. I think one of the things that is interesting about the DWI that I've heard in commentary is people don't understand that DWI is like from first principles the same as any other crime. So like they will say things like, well, the cops didn't write a report, like they didn't pull her over, or they didn't do a breathalyzer, or they didn't do a legal blood draw, or they didn't charge her right away. Like DUI from first principles is the same as any other crime. So as long as you're within the statute of limitations of DWI, and for the purposes of this discussion, DWI is a lesser included. So it was always there. That's the conceit, right? As long as they charge within the statute of limitations, in order to convict beyond a reasonable doubt, the government only needs to present evidence, whatever that is, that will convince a jury beyond a reasonable doubt. So they don't. I mean, I don't know what I don't know what the percentages are, but like probably 95% of the time, if not greater, a DWI is they pulled you over, they did a breathalyzer, they did the roadside sobriety test, they did the blood draw, right? So. But that's the standard. But I think what people are confusing is they think that that's required, and it's not. It's sufficient, but it's not required. What is required is that they present evidence from whatever sources that can come that will convince a jury beyond a reasonable doubt that is true, and that can be anything. And so there could have never been a blood draw at all. There could have been whatever. And so it's like. And the state tried to prove evidence by, counting drinks. They had eyewitness testimony. They had a blood sample that was done by a hospital. And you're like, well, that's not an accredited lab. I'm like, well, be that as it may, it's still some evidence. It's not nothing. It definitely makes it more probable. Forensic. Yeah, but it's like,
it's not forensic evidence.
She admitted she wouldn't get on the interstate though.
And their statements from Karen Reed too on top. So I was like, I would have convicted her of DUI. It's fine.
So here's the problem I have with the DUI is they didn't mention her medical condition. They took out her small intestine because she has colitis. So if I'm led to believe that alcohol, where it absorbs in your small intestine, when she's drinking these drinks and they're not hitting her because they're light, it's a weak pour, she called it, and she was doubling up on them because when she was testing them, drinking them, it wasn't hitting her. Because it didn't ingest into her small intestine.
Well, as you point out, the jury had no ability they had no information relating to that. So I couldn't. I obviously couldn't factor it in. So it's not evidence. So what do you want me to do about it, right?
No, I'm just saying I didn't hear anything about that. So if that's the route that the defense was going, they didn't have anything to defend Karen.
I think the defense was very deliberately trying to make that DUI as open as possible. Because when they were asked, like, what time, the legally correct answer would be the time of the manslaughter. That is the right answer. But they're like, well, it's open. And I think they were trying to make it open. I think they wanted to increase as long as you check box 5, we're happy. So you think the DUI occurred at 12:40, you think it occurred at 5 o'clock, you think it happened yesterday. We don't care. As long as you check box 5, we're happy campers. That was their view. That was what they were going with. They got what they wanted. So I guess mission accomplished.
Right. Yeah. I think that they were very deliberately looking at the last trial where the jury had no split the baby. And then this trial, they needed to give them that split the baby. I don't believe that either trial there was enough evidence to support the Commonwealth's theory but they weren't given any other option, and that's what I think. And when you see the example or the sample that they sent through the sample jury form that they submitted, they filed a motion to have something like this and gave an example. I could see what they were saying. They wanted it to be a separate charge. Like they wanted counts 1, 2, 3, and then they wanted to add 4 as a separate charge. And then Bev kind of overrode them and stuck it down as a lesser. And
No, that's correct. That's correct. It is a lesser included. That was right. I mean, you couldn't bring it as a separate charge. It is lesser included. It was correct.
Right. But that's why I think it was a smart move, because they gave the jury something to split the baby. Well, it's called a compromise verdict, isn't it?
Sure.
Something in legal terms. So,
Yeah.
question from Morel.
What about the Karen Reed's, the O'Keefe's legal issue they have with Karen? Does this make that a whole much huger hill to climb now for them?
No, I mean the suit for wrongful death will continue unabated, I imagine. Okay. It's a different standard. It's obviously preponderance, and so that it has no impact on that one way or another. So the other question
I would have thought they had a stronger case of wrongful death if she was convicted.
It wouldn't have hurt. That's for sure.
Can new evidence come in?
Oh, sure, of course, because it's a completely separate trial. In fact, for that matter, there is no evidence in the civil case. All evidence will have to be presented again, because it's a new case, new jury.
Oh.
Yeah.
Wow. So question from the audience, do you think Karen can drive, or did she lose her license for a certain amount of time? I knew she couldn't drive all this time that she's been going to court. They had suspended her license, but do we know what's going to happen with that?
I don't know the answer. I don't know the answer to that question. It's a state-specific law question about what are the consequences of a first DUI. So I don't know the answer.
I would strongly say that she most likely, seeing where she lives now, she's already gotten used to not having a vehicle. She doesn't need one. She can get around to go do what she needs to do with where she is. Everything's accessible. I don't think she misses not having a car, to be honest with you.
Yeah, there is one big piece of evidence in the civil case that will be new, and that is the testimony of Karen Reed, because she no longer has jeopardy.
Ooh,
so either side can call her, and she will be forced to testify if either side calls her, because she no longer has jeopardy. Yeah.
Wow. Yeah.
So there's that.
They have to win it first, don't they? They have to actually get a judge to say, yeah, we're going to hear this first. It hasn't passed that stage, has it?
Oh, no, it'll make it past any issues relating to that. There's more than enough on a prima facie to make it past summary judgment or any other issues. Yeah, this is going to proceed to trial in the absence of some settlement. I have no doubt.
Just real quick off subject, Kurt, did you know that Proctor was going to be on 2029?
I did hear that. That's pretty exciting. I'm thinking about if I can find a feed of it somewhere. I'm thinking about streaming it on Discord and then getting really, really drunk as I make fun of Proctor. That sounds fun.
And he's got a tissue. Then the trailer's got like a little tissue in his hand and he's wiping away a tear.
Yeah, no, I definitely want a piece of that. Also, Mr. Proctor, and I say Mr. Proctor very deliberately. If you'd like to join me, I'm more than happy to interview you. I've got questions, several questions.
You'd be very fair, I think. I'd love to see that.
Yeah.
Yep, you'd be fair. Absolutely.
Sure.
Right. So Be in Trouble, I think, is local, and he says that she should get it back pretty much immediately, but they've both stipulated that she has to complete classes first.
And Be in Trouble is the one who did the
not for possession of the Lexus. Whether she can drive it or not is a whole other side of issues, but she could get possession back immediately.
No, her license. They were talking about her license.
Fair enough.
Is Be in Trouble the one that did the taillight breaking and showed the inside? Okay, yeah, all right.
Colleen, please tell your son I said hello and thank him for helping me pass out those ducks. I had a bunch of ducks yesterday and gave them to a young man, and he helped me pass them out to amongst all the Karen Reed people. He did a great job helping me yesterday, so thank him.
Whoops, Carol M has a question. Uncivil is a lesser included, also including the main charge?
It was in 2.
Well, I don't understand.
was
I don't understand the question. Like every charge could include a lesser included, if that's the question, because every murder includes assault. So, like assault is an implicit lesser included.
It was hotly debated whether the main charge of manslaughter, which was charge 002 on the form, was still applicable if they, regardless of what they did with the lessers. That was hotly debated. If they chose the option number 5, which they did, was she still going to be able to be retried for the main charge?
The answer to that question is no. The answer to that question is no.
Yeah.
Yeah, this is it. It's done. Because especially to the extent there wasn't any ambiguity, which there really wasn't, but to the extent there was, the new verdict made it clear because it said like, if you find not guilty, then proceed below. So the not guilty is implicit in the way it's written. I mean, it was already implicit, but yeah, there's no ability to bring manslaughter. This is it. We're done. And if she were to appeal the DWI, OWI, or whatever they call it, if she were to appeal it, there's no possibility of those other charges coming back. So this is the end of the case. I mean, hypothetically, if she appealed her conviction, hypothetically, she could be putting her sentence in jeopardy, but she wouldn't be facing manslaughter convictions.
I don't think she's going to appeal. That would be pretty stupid.
A message just from Microdots. Justice won't truly be served until Turtle Boy is free of all of his charges. The same discredited and disgraced machine that charged Karen Reed did it to him too, when it's clear now to everyone he was reporting the truth. Over and above 100%. Whether he was reporting the truth, they only went after him because they thought they could revoke Karen's bond by going after him and somehow tying him to witness intimidation through Karen. So
exactly,
I agree with Microdots on that note. Did that make more sense to you after you spoke with Turtle Boy, Kurt?
Well, I haven't really dug into the Turtle Boy question in enough depth to know. I've only been very superficially involved. I saw what I think was his initial probable cause hearing, where they talked about defamation for some reason, which made no sense. And I was like, that doesn't really understand. So I don't really want to take a position on his liability because I haven't dived into it enough to know. But
well, not so much about the liability, just the background story was Karen was on a $50,000 bond. And if they could, but part of her conditions were that she was not allowed to have anything to do with any of the witnesses or the victim's family. And the reason they went after Turtle Boy was because they found out that he was in touch with Karen. So they thought that if we have Turtle Boy intimidating witnesses, we can have Karen's bond revoked because she's trying to get him to intimidate witnesses. That was the when Brennan was going after they tried to hold that court hearing and then the whole tribe turned up.
Sure.
They're trying to have that court hearing without her.
Yeah, that was pretty hilarious.
Yeah,
does she have the right to appear in a hearing that's filed under her case? That was a fun discussion for some reason. Yeah. I like that one.
For some reason.
Yeah.
That was it. Yeah.
But that's exactly what that was about. They were trying to tie. So they had to first of all get Turtle Boy charged with witness intimidation so they could then tie it to Karen Reed, and then the final outcome would be...
Bye, guys. I'm going to leave it to you professionals.
All right. Thank you so much, Mandy.
Thank you, Mandy. It was a nice pleasure meeting you.
Thank you, Mandy. Thank you for everything.
We'll reach out to you about the group stream when we get to it.
Okay, sounds good.
All right. Bye-bye. So the end product of that would have been that they could revoke Karen's bail. That was the whole point of doing the Turtle Boy shit.
I think that's a very reasonable conclusion based on what happened, especially with respect to the hearings. Seems like that when they were talking about text messages between Karen Reed and Turtle Boy trying to pierce privilege and all kinds of things. I don't know whether or not the motivation was, but I mean, that's certainly a very reasonable conclusion that they were looking for any way they could get to whatever they wanted to be. The whole thing is very, very scummy.
I'm pretty sure Karen Reed and Aiden didn't set out to pierce the veil of, attorney-client privilege.
No, it was pretty dumb.
The whole thing was, but yet here we are. it happened. It's still going to happen again until we get the people in office out, and that's it. I mean, these people they paid, I don't know how much they paid, but it's going to be the world record amount just to prosecute someone on a DUI charge.
Yep.
It's just ridiculous. And here we are, right? Only in Massachusetts can that happen. And we have another case that, the 24-year-old girl was pregnant with the cop's baby. We assume it was a cop's baby. Now it's someone else's baby, for crying out loud. It's just so much up here. We need help. We need a lot of help. So...
yeah, I never want to hear. I grew up in the South. I never want to hear shit about the South ever again. I'll tell you what.
Fair deal, done deal. I'll shake on that one, my friend. I'm good with that deal. Yep. No, I mean it's really because the people that the lady sitting next to me, right? She's saying to the other lady who she's never met before, two strangers, just out as supporters. They're talking about how their daughters could be Karen, and they're not wrong. So these ladies that. They were just all in about it. How do you fix that? You can't until there's another Karen Reed.
No, I mean,
until there's another one.
The legal system as a whole has been trying for basically the last 800 years to try to figure out ways to deal with all these issues systemically, right? And so what we've come up with is the best solution that we've come up with, but it's like, human beings are human beings. And this is the problem at the end of the day. It's like human beings are flawed. And, how many people does it take? And the answer to that question, whether it's for good or bad, is sometimes surprisingly few. Like, how many people does it take to inspire really good things to happen, revolutions to happen? Sometimes the answer is surprisingly few. And how many people does it take to corrupt things? Sometimes surprisingly few. And we have not figured out a solution to that problem on a systemic level. And I don't think one is necessarily forthcoming, so I'm not sure what to do, but we've done our best. So how do you make human beings not suck?
On the positive side, Tommy, one of your lawmakers from the Massachusetts Senate, or I think whatever you call it, one of your lawmakers has actually taken notice of these witness intimidation charges and how they were abused this time. In both Aidan Carney's case and in Karen's case. So the lawmakers are watching. So, and that's how you bring about the change. When you get the attention of the lawmakers, they see they've taken notice of what's going on with the witness intimidation charges, but they're also noticing that you guys are out on the streets protesting. And I would suggest stick with it. Like I know we've got the final verdict for Karen, and that's not going to be the motivator anymore, but you guys have got the motivation to keep going with this, and you've already got the attention of the lawmakers, and I would say that's the way to go about changing things.
Well, and again, we have to work within the confines of the law, hence why we need attorneys and people like that to help us, these smarter people that make the laws, that know the ways around the laws, to help us maybe tighten them. Because, I believe that, there's good in everybody and there's bad in everybody, but we want more good for bad. And police officers should be all about that goodness and sharing that goodness. But
one of the problems is like, the other end of that equation, or the other end of whatever situation we're in now. And that causes people outrage too, because you have those situations like, you have the person who, is obviously 100% guilty, but gets off because of the technicality, right? We call the technicality. Right. And people get outraged by that too. It's like, how can this person who's clearly guilty, and like everyone agrees clearly guilty, like how can it be? And people cry for outrage about that situation. How can we let this person get away with it? It's like, we can't really satisfy both these demands at the same time. It's like, how do we simultaneously guarantee that, the innocent person won't get convicted and the guilty person will? And when the outrageous case happens that the innocent person gets convicted or the guilty person gets free, those both cause outrage, and people demand viscerally, they demand the problem be fixed. And it's like, well, it's going to screw over the other side. And there's no really way to deal with that. Unfortunately, you got to pick your poison.
Double-edged sword, right?
Yeah.
So like, what side do you want to be cut with? The answer is neither, right?
Yeah.
But you're gonna get caught one way or the other. So yeah, that's a good way to think about it. That's very interesting. Huh.
Yeah, I find law very interesting because, especially on the common law system, because common law is just the collection of cases. It's like, because we have a precedential system, the way the law has gone developed in our system is just from cases. Every case is a story. And what the law, and people ask, for example, like, why are jury instructions so complicated? Why is law so complicated? Why can't it be simpler? And it's like, well, just imagine that we start with just a really clean line, right? Whatever it is, we just start with a clean line, and this clean line is going to separate the good from the bad. It's like, well, there will be a case, and there has been a case over history where the line is in the wrong place. People are like, we have to adjust the line. And there's another case, the line's in the wrong place, so we have to adjust the line. You do that for 800 years, and you wind up with this noise.
Yeah.
And the reason this exists is not because law is trying to be complicated in the first instance. It's because we're trying to deal with everyone's use cases. And that's what happened. It's like, why can't the law be simpler? Well, because people are not simple. They keep coming with new ways to break everything, and we keep having to come with things so they won't break things. We've been doing it for 800 years. And they still coming with new ways to break things. So that's our Sisyphean task over here. It sucks.
It's pretty much the same here, actually.
I understand that a lot better now. And I guess I'm okay with the guilty person getting off if that means that the innocent person doesn't get convicted.
Yeah, well, the common saying is it's better for 10 guilty men to go free than one innocent person to go to prison. The problem is, in the real world, people don't really believe that.
Right. Well,
one of the things that I found when I was studying international law, it is actually quite different, where our system of law locally in our countries is based on case law, as Kurt explained. People come and break shit. You got new case law to unbreak it, or right. Try and fix that problem. But international law is not like that, and that's an example of the alternative, where it's just a freaking free for all, and nobody actually follows any law. Because it's not built on case law.
Yeah, I mean, the entire concept of rule of law is relatively new in grand human history. Like the ideas of like presumption of innocence, or that maybe the defendant gets to present a case sometimes. Maybe we should do that. I mean, these are relatively new phenomena in human history. So it's like we've come a long way in some ways, but that leads to problems on the other end too.
So now that Karen is found not guilty, can she sue the Commonwealth, or only for the civil rights violations that have to be proven separately?
Yeah,
yes,
I don't know.
Question.
I don't know. That's the question. Yeah, I don't know. And the reason I don't know is because the standard answer is that if you're convicted, you can't sue for the civil rights violation, because it's kind of a res judicata collateral estoppel thing. The issue having been decided against you because you were found guilty, you can't then come back around the other side and sue. An issue decided is an issue decided. So normally there's an estoppel problem. I don't know whether or not that's true here, because I don't know the extent to which the DUI conviction as a lesser included has a preclusive effect on the civil suit. So I think the answer is there's probably some around here, but to get an exact answer would require much case law research. I think it's very interesting.
Right. I think that also for her to be able to sue, the prosecution had to end in her favor.
That's what I'm saying. Exactly right. Yeah, that's what I'm saying.
And that it was bought with malice, but I don't think she can do any of that. Well, the malice part is about all she's got in that group of subset of things. So she's not fully exonerated. She was convicted of the OUI, which is a lesser included under count 002.
Yep.
Technically that's ended in a conviction, so it's not a full acquittal.
Right.
But there may be a path later, apparently, if they want to overturn the OUI conviction on appeal, but I don't think they're going to do that. I think they're just going to take that one.
I think so too.
Going to.
I think so too.
I mean, that would be this. I would be thanking my freaking lucky stars that it's just 12 months probation and a freaking drink driving course.
If that's all it is, sure. I mean, yeah.
But because it didn't end in her favor, if it was a full acquittal across the board. See, this is why I wonder what was in the first envelope. First envelope, because if that was a full acquittal across the board, that would mean that she could sue them. Who talked them out of that and went, no, she can't sue them. Don't let us sue them. We've got to.
I seriously doubt the jury was sophisticated enough to be making that discussion. I doubt that was the issue.
I didn't think it was going to be the jurors making that. I fully expected. We were expecting the fuckery this time, Kurt. I don't know that you bought into the fuckery last time, but there was definitely fuckery last time with the jury. The fact that people on X saying this is going to happen tomorrow and that's going to happen tomorrow in the last trial, and then those things actually happened.
Right.
That's what signaled to us there was fuckery in that jury. But thankfully that wasn't the case this time. So, but that was what I was thinking when that first verdict form came out. I wonder if someone had a word with them that, she could actually sue if they didn't find her guilty on something. So there was someone the other day, I forget which state, if I remember off the top of my head, it might have been New York State or maybe California. I can't remember which one now. But when someone just won against the state for malicious prosecution somewhere in one of those states, and I was reading it out to the audience the other day, and it's completely fallen out of my head what that case was. Do you remember what it was, Kevy? But yeah, there was a case where he actually spent 20 years in jail, and then he sued the state, essentially. No, he doesn't remember either. I can't remember what the case was, but that didn't end in his favor. Well, actually it did, because he was overturned. So having it overturned is what ended in his favor. It took 20 years for him to get there.
Wow. So is there a mechanism in place, do you think, that we can petition like the district attorney, if it was a new one, to maybe look into the death of Officer O'Keefe and maybe look at a different direction than where they looked prior?
I mean, you can always write letters and petition the government that way. So I mean, there's always that. So beyond that, I don't know. Going to city council meetings, petitioning your representatives, writing letters to them, keeping the pressure on. But I seriously doubt there would be a problem. Any future attempt to prosecute would be tainted by Karen Read, because Karen Read is automatically like a viable suspect. The state has made every possible effort to prove that she is reasonable. So any defense attorney for any future suspect would be out of their mind not to basically just parry the state's argument. Basically, they've laid out the reasonable doubt for that person. It's just I just copy their argument and make it my own argument because they've basically established reasonable doubt for me. It could have been Karen Read. I'm already there.
Right. Huh.
Thank you, Supermod. John Rivers case, convicted in Illinois for the 1992 murder of Holly Staker, largely based on coerced confessions, exonerated in 2012 after DNA evidence, and his conviction was officially vacated. So that's how it worked in his favor. The conviction was vacated. In 2015, Rivera sued, how do I say that, Waukegan? Waukegan and Lake County, Illinois, along with private interrogation firm Reed and Associates. Oh, the Reed technique, of course. He ultimately received a $20 million settlement, including $7.5 million from the city of Waukegan, $12 million from Reed Associates. There you go, big settlement. But again, I think that's because it ended up being resolved in his favor, right, Kurt?
Mm-hmm. Yeah.
Kurt, I have a question. You've obviously seen more judges than the average person, right?
Sure.
How do you see Beverly? You see her at the end of her career, and do you think she's all done with this? You think she's gonna pack her stuff up and go home now?
She's pretty close to mandatory retirement anyway. I think she's like only 2 years away as it is.
Yeah. You think this is the thing that would make her go quicker? This loss?
I don't know. I think she probably wants to end her career I would assume that she's just going to stay on the bench for the remaining 2 years that she has and call it a day. That's what I would assume.
Yep.
Well, okay.
Yep. She's just going to move along. She's already been rotated out. So we were talking about Bev, weren't we?
Yep.
Or did I just accidentally flip on you because I was reading something else?
We'll talk about everything. This is cool.
Right. If you were talking about Bev, yeah, she already rotated out. She's going to finish up what she was doing. The only thing I thought of was that, you know, someone like DA Morrissey gets replaced and then her position, someone else gets put in her position, but I don't think that's going to happen. So
does she have to disclose this when she fills out a job application? Is this one of the things that they ask for?
What do you mean?
Think, like in the financial district, like that you have to be like bonded, I think, and they have to do a background check on you. She worked in Karen worked in finance.
Oh, Karen. Oh,
Yeah,
I don't know
Karen,
I don't know the answer to that question. I don't know if I have the financial regulations well enough to answer that question.
Okay. Just a thought, because I know you're
So,
in order to be bonded, you got to be like crystal clean and stuff like that. And I didn't know if this was enough to make.
I find it difficult to believe there aren't people with bonds that have DUIs. That strikes me as unlikely. DUIs are known to the profession, and they're known to lawyers in particular. Lawyers have something like a 3-time incident rate for alcohol issues. So I think there's probably people with bonds that have DUIs, I would imagine.
So this is a question, I think it's a question. Can Karen sue for deprivation of rights under colour of law?
I don't know. Yeah, it's the same question. I don't know.
Yeah, my first initial sort of research of it falls under 42 USC section 1983.
That's the baby. That's the one.
I think it has caveats that would be she would have to prove that he fabricated evidence, withheld exculpatory data, targeted her on bias. I think that bit she can prove like straight up because he's already been fired for it, or a coordinated cover up. If they can do that,
those are all problems. But the bigger immediate problem is for me, like, what is the preclusive effect of the DUI conviction? That's the question I don't know the answer to. So, like, without the preclusive effect of the DUI, yeah, I can just do a standard 1983 analysis, and I can tell you all the reasons it's difficult anyway. The question I don't know the answer to is what is the preclusive effect of the DUI conviction? Does that serve as a barrier that just kills her completely out of the gate? And I'm not sure. Because
I don't think it does. Looking at this, if she got it overturned, then it would be especially if she got it overturned, she would have a stronger grounds. But I don't think it's an exclusionary where it would be under suing the state. But I don't think it is for him personally. It's just a stronger case if she could get it overturned.
I don't know. I don't want to opine on a turn. I'm not sure.
Yeah.
I mean, they get deep pockets. That's what you're supposed to go after, right? Whoever's got the deepest pockets, sue them.
Yeah, to some degree.
I personally would give it a shot, just because it's not exclusionary, that it's not found in her favor, where it is in the other case, suing the state. So he blew his qualified immunity. He blew his qualified immunity when he wrote those texts, basically. Well, when he got fired, I guess the final thing, he blew his qualified immunity when he got fired for all of that bias. So, but anyway, do we have any more questions for Kurt? Do you have anything to wrap up with, Kurt?
Not in particular. I think all things being considered, it's a good day, kind of no matter what happens. I think that, justice was done. I think from first principles, it's a lot easier to get to a DUI conviction. You just have to prove beyond a reasonable doubt that she was drunk, whenever. And I think there's enough evidence to draw that conclusion. So I don't really have a problem with it from first principles. I'm happy that this is over.
Sorry.
I
think she has a plate full with the civil suit afterwards, so I don't think any of this really makes any difference, to be honest. But
yeah.
Thank you for answering.
And then I'm going to just try to see if I can find a feed somewhere online where I can watch this 2020 interview and perhaps stream it on my Discord, because that sounds like fun.
All right. So who is streaming it is the Glarer, and he's going to be streaming it on Kick.
Excellent.
So it's kick.com/the Glarer. I'm pretty sure I have that pinned. Yes, I do. I have it pinned in the chat there. If you want to restream his, and if you do all of that, how about you invite me? I am on Discord, or get Mandy to invite me, and I'll come watch with you and stream it to my channel.
Sounds fun. All right, looking forward to
I'll
that.
stream everybody.
Could you make sure to send me the link for the Kick on the Discord as well, please?
Sure, I'll do
Thanks.
that on
For sure.
Discord.
All right, let me let you go for
No
now.
worries.
Listen, it's an honor to meet you. I've been watching you for a long time, so I'm like fan guy in here or something. But
I appreciate that.
I love how you see the law, and it's you always just make me see it just a little different. That's always just seems to be right.
Then I must be doing something right.
Enjoy
Thank
the
you.
night. Thank you for your time.
Bye-bye.
Thank you for joining us and answering all our questions, Kurt. Much appreciated.
No problem. Thanks. Bye-bye.
Hi, this is Mark from LongIslandWatch.com. Today, I'm here to tell you about a watch. It's pretty much backpack, which is always a good thing. But typically, when you see a watch,
Okay, sorry. I didn't realize I was still streaming. Ha ha ha. My fault. I was going to watch something else completely. I'm just going to sign off. Sorry about that. My fault. I'm just going to sign off. I'll try to catch you up on Discord. I was watching a watch review, in case you're wondering what's in the background. Of course I was. I was watching a watch review. I was like, I want to move on to something else. So if you're curious, what was that noise in the background? What content was Kurt watching? What was he watching when we weren't aware he was streaming? It was a watch review. Because, All right, so I'll catch you up on Discord. I've been Uncivil Law. Until later, my friends, I hope